Act No. 361/2000 of September 14, 2000 on Traffic on Roads and on Amendments to Certain Laws, Road Traffic Act. The Parliament has adopted this Act of the Czech Republic. Part 1 LAW on Traffic on Roads Chapter I Introductory Provisions Section 1 Subject of Regulation. This law incorporates relevant regulations of the European Union and regulates a. Rights and obligations of traffic participants on roads. B. Rules of traffic on roads. C. Regulation and control of traffic on roads. D. Driving licenses and driving permits. E. Competence and authority of state administration bodies and the police of the Czech Republic, hereinafter police, in matters of traffic on roads. Section 2. Definition of basic terms for the purposes of this law. A. A traffic participant on roads is anyone who directly participates in traffic on roads. B. A vehicle operator is an owner or other person who is registered as an operator in the vehicle register according to a special legal regulation or similar registry of another state. C. A guide of led or driven animals is a traffic participant who accompanies animals walking individually or in herds on a road. A guide of led or driven animals is not a pedestrian walking a dog. D. A driver is a traffic participant who drives a motor or non-motor vehicle or tram. A rider on an animal is also a driver. E. A wagon driver is a driver who drives a draft vehicle. F. A vehicle is a motor vehicle, non-motor vehicle or tram. G. A motor vehicle is a non-rail vehicle powered by its own propulsion unit and trolleybus. H. A non-motor vehicle is a trailer vehicle and a vehicle moving by human or animal power, for example a bicycle, hand cart, or draft vehicle. I. A vehicle combination is a combination consisting of one or more motor vehicles and one or more trailer vehicles. J. A pedestrian is also a person who pushes or pulls a sled, baby carriage, wheelchair, or hand cart with a total width not exceeding 600 mm. Moves on skis, roller skates, or similar sports equipment, or using a manual or motor wheelchair for disabled persons. Leads a bicycle. Motorcycle with engine displacement up to 50 cm. 3. Dog and similar. K. A public transport vehicle is 1. A bus, trolleybus, or tram. Or 2. Another vehicle when operating public scheduled transport. L. Must not endanger. Means the obligation to act so that no danger arises to another traffic participant on roads. M. Must not restrict means the obligation to act so that another traffic participant on roads is not obstructed in any way. N. To stand. Means to bring a vehicle to rest beyond the time permitted for stopping. O. To stop means to bring a vehicle to rest for the time necessarily needed for immediate boarding or alighting of transported persons, or for immediate loading or unloading of cargo. P. To stop a vehicle. Means to interrupt the journey for reasons independent of the driver's will. Q. To give way. Means the driver's obligation not to start driving or a driving maneuver, or not to continue them if the driver who has the right of way would have to suddenly change direction or speed. R. A motorway is a road marked with the traffic sign, motorway. S. A road for motor vehicles is a road marked with the traffic sign, road for motor vehicles. T. A traffic lane is a part of the roadway allowing the movement of vehicles in one traffic stream one after another. U. A merging lane is an additional traffic lane intended for vehicles to merge into the traffic stream of the through lane. V. A hard shoulder is a part of the road surface lying between the edge of the adjacent traffic lane and the edge of the road crown, usually consisting of a reinforced and unreinforced part. W. An intersection is a place where roads cross or connect. The junction of a field or forest road or other purpose road to another road is not considered an intersection. X. The boundary of an intersection is a place marked by the horizontal traffic sign, solid transverse line. Solid transverse line with give way symbol, or solid transverse line with stop inscription. Where such a traffic sign is not present, The boundary of the intersection is formed by perpendiculars to the roadway axis at the place where the curvature of the roadway edge begins for the intersection. Y. A controlled intersection is an intersection where traffic is controlled by light signals, possibly also accompanying acoustic signals, or by a police officer in uniform, hereinafter policeman, a member of the military police in uniform, hereinafter military policeman, or directed by a municipal police officer in uniform, hereinafter municipal police officer. Z. A through lane is a traffic lane running in the original direction without turning through an intersection or at a place where the number of traffic lanes changes. A tram lane is a part of a road intended primarily for tram traffic. BB. A railway crossing is a place where a road crosses a railway at grade level, possibly with another railway lying on a separate body, and marked with the appropriate traffic sign CC. A built-up area is a built-up area whose beginning and end is marked on the road with appropriate traffic signs. Signs are not installed on purpose roads. DD. A pedestrian crossing is a place on a road intended for pedestrians to cross, marked with the appropriate traffic sign. E. A traffic obstruction on roads is everything that could endanger the safety or smoothness of traffic on roads, for example cargo, material or other objects, a vehicle left on a road, or defects in the passability of a road. FF. Reduced visibility is a situation when traffic participants on roads cannot clearly distinguish other vehicles, persons, animals, or objects on the road, for example from dusk to dawn in fog, snow, heavy rain, or in a tunnel. GG. An identity document is a document by which a citizen of the Czech Republic or a foreigner proves their identity according to a special legal regulation. HH. Habitual residence on the territory of the Czech Republic is the place of permanent residence of a natural person on the territory of the Czech Republic, or if a natural person does not have permanent residence on the territory of the Czech Republic. A place on the territory of the Czech Republic where the natural person 1. Stays at least 185 days in a calendar year for personal reasons, which means especially cohabitation in a common household, family ties, ownership or rental of real estate, and possibly also for business reasons. Performance of other self-employed activity or dependent work on the territory of the Czech Republic, or 2. Stays for personal reasons and regularly returns to this place, although they do business. Perform other self-employed activity or dependent work in another state, unless the performance of such activity in another state is limited to a definite period. Roman II. A restraint safety system is a device approved according to a special legal regulation and intended to ensure the safety of transported persons. A restraint safety system is a safety belt or child restraint system, hereinafter child car seat. JJ. A child car seat is a device approved according to a special legal regulation intended to ensure the safety of transported children whose body weight does not exceed 36 kg. And body height does not exceed 150 cm. KK. The National Traffic Information System is a system containing current information about the situation in traffic on roads that affects the safety and smoothness of traffic on roads. LL. A bicycle crossing is a place on a road intended for cyclists to cross the road marked with the appropriate traffic sign. A column of vehicles means a continuous stream of multiple vehicles where individual vehicles cannot be overtaken. The spacing between individual vehicles when overtaking or bypassing does not allow safe merging. NN. A personal technical device is a personal transporter with self-balancing device or similar device. Chapter Roman II Traffic on Roads Division 1 Traffic Participants on Roads Section 3 Basic Conditions for Participation in Traffic on Roads. 1. A person who, due to age or reduced physical or mental abilities, could endanger the safety of this traffic, must not participate in traffic on roads. This does not apply if the person themselves, or another person has taken such measures that endangering the safety of traffic on roads does not occur. 2. Only a person who is sufficiently physically and mentally capable of driving a vehicle or riding an animal, and who adequately controls the driving of the vehicle or riding on an animal and traffic regulations on roads, may drive a vehicle or ride an animal. 3. Only the following may drive a motor vehicle. A person who holds a driving license for the appropriate group of motor vehicles, hereinafter vehicle group, and holds a driving permit that certifies the driving license on the territory of the Czech Republic according to Section 104, Paragraph 2. B. An applicant for a driving license who, under the supervision of a driving school instructor, undergoes training in driving a motor vehicle or takes a driving test. Or C. A person who, under the supervision of a driving school instructor, prepares for re-examination of professional competence to drive motor vehicles, takes an examination as part of this re-examination, or participates in training for beginning drivers according to a special legal regulation. In the case of a driver who lost their driving license according to Section 123C, Paragraph 3, this applies at the earliest 30 days before the expiration of the deadline, according to Section 123D, Paragraph 1. 4. A motor vehicle classified in vehicle groups C1, C1 plus E, C, C plus E, D1, D1 plus E. D or D plus E may only be driven by a person who is professionally competent to drive these vehicles according to a special legal regulation, or based on a decision of the competent authority of another state, that is a member state of the European Union, or a contracting party to the agreement on the European Economic Area, hereinafter another member state, or the Swiss Confederation. Professional competence to drive a vehicle classified in one of the groups C1, C1 plus E, C and C plus E applies to driving a vehicle classified in any of these groups. Professional competence to drive a vehicle classified in one of the groups D1, D1 plus E, D and D plus E applies to driving a vehicle classified in any of these groups. 5. The condition of professional competence according to Paragraph 4 does not apply to a driver who is not a citizen of the Czech Republic, Swiss Confederation or another member state, and who does not perform dependent work for an employer established on the territory of one of these states, nor does business on this territory, and further to drivers of A. Vehicles whose design speed does not exceed 45 km/h. B. Vehicles used by the armed forces of the Czech Republic, police of the Czech Republic, municipal police, road transport inspection, prison service of the Czech Republic, Customs Administration of the Czech Republic, hereinafter Customs Administration, General Inspection of Security Corps and Intelligence Services of the Czech Republic. C. Vehicles of the Fire Rescue Service of the Czech Republic and fire protection units that are not part of the Fire Rescue Service of the Czech Republic. Emergency Medical Service Providers and the State Material Reserves Administration. D. Vehicles used in ensuring civil protection and mine rescue service. E. Vehicles in trial operation and during test drives in connection with their repair and maintenance. F. Vehicles used in training and examinations when obtaining and improving professional competence of motor vehicle drivers according to a special legal regulation. G. Vehicles used in transporting goods that the driver uses in performing their dependent work or business, provided that driving is not the main subject of the driver's dependent work or business performance. H. Vehicles used in transporting goods within agriculture, forestry, or fishery business within a radius of 50 km from the business premises of the entrepreneur transporting goods, provided that driving is not the main subject of the driver's dependent work or business performance. I. Vehicles used for purposes other than business, or J. Agricultural and forestry tractors, except tractors with maximum permissible mass exceeding 3,500 kg and design speed of 80 km/h or higher. 6. No one may use technical devices and equipment that prevent or affect the function of technical devices used in supervising the safety of traffic on roads, hereinafter anti-radar. Section 4. Obligations of traffic participants on roads. When participating in traffic on roads, everyone is obliged to a. Behave considerately and disciplined so that their actions do not endanger the life, health, or property of other persons or their own. Do not damage the environment or endanger the life of animals. Their behavior must be adapted especially to the structural and traffic technical condition of the road. Weather conditions, traffic situation on roads, their abilities and health condition. B. Comply with traffic rules on roads regulated by this law. Instructions of policemen. Instructions of persons authorized to control or direct traffic on roads according to Section 75, paragraphs 5. 8 to 10. And vehicles stopping according to Section 79, paragraph 1, and instructions of persons specified by special legal regulation, issued to ensure safety and smoothness of traffic on roads. C. Comply with light signals, possibly also accompanying acoustic signals, traffic signs. Traffic devices and devices for operational information. Section 5. Driver obligations. 1. In addition to the obligations listed in Section 4, the driver is further obliged to a. Use a vehicle that meets the technical conditions established by a special legal regulation. B. Devote themselves fully to driving the vehicle or riding an animal and monitor the traffic situation on roads. C. Adapt driving to the technical characteristics of the vehicle or physical characteristics of the animal. D. Exercise increased caution, especially towards children, persons with limited mobility and orientation ability, persons with severe disabilities, and animals. Take into account vehicles transporting children. Novice drivers or persons with severe disabilities, marked according to implementing legal regulation, and training vehicles, marked according to special legal regulation. E. Remove on the spot any defect discovered during driving that the vehicle or cargo does not meet the established conditions listed in Section 52. If they cannot do so, they may continue driving at reasonable speed only to the nearest place where the defect can be removed. They must take such measures that safety of traffic on roads is not endangered during driving, and the road or environment is not damaged. F. Submit to examination according to a special legal regulation upon request of a policeman, military policeman, employer, attending physician or municipal police officer to determine whether they are not influenced by alcohol. G. Submit to examination according to a special legal regulation upon request of a policeman, military policeman, employer, attending physician or municipal police officer to determine whether they are not influenced by an addictive substance other than alcohol, hereinafter other addictive substance. H. Reduce driving speed or stop the vehicle before a pedestrian crossing if other drivers of vehicles traveling in the same direction also reduce driving speed or stop their vehicles before the pedestrian crossing. I. Ensure the safety of transported persons or animals and safe transport of cargo. J. Secure transported animals so that they do not endanger the driver and transported persons. K. Ensure that a sufficient number of capable and properly instructed persons are brought along for the journey if traffic safety on roads requires it. L. Wear clothing accessories with retroreflective material, marking established by implementing legal regulation according to Section 56, paragraph 8, when outside the vehicle on a road in connection with emergency stopping. This does not apply to drivers of motorcycles, mopeds, and non-motor vehicles. 2. The driver must not a. Consume an alcoholic beverage or other substance containing alcohol, hereinafter alcoholic beverage, or use another addictive substance during driving. B. Drive a vehicle or ride an animal immediately after consuming an alcoholic beverage or using another addictive substance. or at such time after consuming an alcoholic beverage, or using another addictive substance, when they could still be under the influence of alcohol or another addictive substance. In the case of other addictive substances listed in the implementing legal regulation, the driver is considered to be influenced by such addictive substance if its amount in the driver's blood sample reaches at least the limit value established by the implementing legal regulation. C. Drive a vehicle or ride an animal if their ability to drive a vehicle or ride an animal is reduced as a result of their health condition. D. Hand over control of a vehicle or entrust an animal to a person who does not meet the conditions according to Section 3 paragraphs 2 and 3, or who is under the influence of alcohol or another addictive substance, or whose ability to drive a vehicle or ride an animal is reduced as a result of their health condition. E. Throw objects from the vehicle. F. Endanger or restrict a pedestrian who is crossing a road at a pedestrian crossing, or who obviously intends to cross a road at a pedestrian crossing. If necessary, the driver is obliged to stop the vehicle before the pedestrian crossing. These obligations do not apply to tram drivers. G. Endanger a pedestrian crossing a road onto which the driver is turning, and further must not endanger a pedestrian when turning to a place located outside the road, when entering a road, and when turning around or reversing. H. Endanger a cyclist crossing a road and bicycle crossing. I. Drive a vehicle on which there is dirt, frost, or snow that prevents visibility from the driver's position forward, backward, and to the sides. J. Drive a vehicle on which or on whose cargo there is ice that could endanger traffic safety on roads if released. K. Drive a vehicle on which a registration plate is not installed, if it is a vehicle to which a registration plate was or should have been assigned, or a registration plate is installed that was not assigned to the vehicle. L. Drive a vehicle whose registration plate is covered, illegible, or modified or placed so that its readability is prevented or substantially hindered. 3. The obligation according to paragraph 1 letter A does not apply to the driver of a combination consisting of a mountain rescue service rescue vehicle that meets the conditions established by special legal regulation and is intended primarily for movement in otherwise inaccessible terrain. Snow. Scooter, ATV, with a trailer chassis, vehicle, intended for evacuating an injured person or transporting rescue equipment, if the use of such combination for solving extraordinary events or their prevention on the road is necessary. Section 6. 1. In addition to the obligations listed in Section 4 and 5, the driver of a motor vehicle is further obliged to a. Be fastened to the seat with a safety belt while driving, if the seat is mandatorily equipped with it according to a special legal regulation. B. Not transport in a vehicle of category M1, N1, N2, or N3 that is not equipped with a restraint safety system. 1. A child under 3 years of age. 2. A child shorter than 150 cm in the seat next to the driver. C. Transport in a vehicle of category M1, N1, N2, or N3 that is equipped with a restraint safety system. A child whose body weight does not exceed 36 kg and body height does not exceed 150 cm, only using a child car seat. During this transport, 1. The child must be placed in a child car seat that corresponds to their weight and body dimensions. 2. In a seat equipped with an airbag that has not been deactivated, or if it has been deactivated automatically. A child in a child car seat must not be transported facing against the direction of travel. D. Place and secure the child car seat in the seat, and the child in the child car seat according to conditions established by the child car seat manufacturer in the usage instructions for this child car seat. E. Transport in a vehicle of category M1, N1, N2, or N3 that is equipped with a restraint safety system. A child whose body weight exceeds 36 kg or body height exceeds 150 cm, only if the child is fastened with a safety belt while driving. F. Transport in a vehicle of category M1 and N1 that is equipped with a restraint safety system, and in which 2 child car seats are already installed in the rear seat, and lack of space does not allow installing a 3rd child car seat. A 3rd child over 3 years of age and shorter than 150 cm in the rear seat, only if this child is fastened with a safety belt while driving. G. Instruct persons over 3 years of age or persons accompanying them transported in a vehicle of category M2 and M3 that is equipped with a restraint safety system about the obligation to use the restraint safety system, if this information is not ensured in another way. H. Wear a protective helmet of approved type according to a special legal regulation, properly fitted and secured on the head, while riding a motorcycle or moped, and protect their eyesight in an appropriate way, for example with glasses or a visor, if this does not reduce driving safety, for example in rain or snow. 2. The provision of paragraph 1 letter A does not apply to a driver when reversing a vehicle, b. a driver who cannot use a safety belt for health reasons, c. a driver of a vehicle of security corps, armed forces and military intelligence when performing official duties, a driver of a municipal police vehicle when performing municipal police tasks, a driver of a fire protection unit vehicle, and a mountain rescue service rescue vehicle when solving extraordinary events, and a driver of an emergency medical service provider vehicle in cases where using a safety belt prevents quick exit from the vehicle for performing other duties. 3. The provisions of paragraph 1 letters C, E, and F do not apply a. to a driver who transports a person whose health condition does not allow the use of a restraint safety system, b. for transporting a child in a vehicle of security corps when performing official duties, in a municipal police vehicle when performing its duties, in a fire protection unit vehicle when solving extraordinary events, and in an emergency medical service provider vehicle and mountain rescue service when solving extraordinary events, or when providing medical services to the transported child, c. until May 1, 2008. For transporting children in vehicles ensuring collection and distribution of children to kindergartens and elementary schools, or transporting children to sports, cultural or social events under the condition of limiting the speed of the given vehicle to a maximum of 70 km/h. 4. The provision of paragraph 1 letter C does not apply to transporting children in a city in a taxi vehicle when operating taxi service. A child referred to in paragraph 1 letter C must not be transported in the seat next to the driver and must be fastened with a safety belt. However, if a child car seat is used when transporting a child, the conditions stated in paragraph 1 letter C, point 2 must be met. 5. The provision of paragraph 1 letter H does not apply to a mountain rescue service vehicle driver in cases where using a protective helmet could make communication with the rescued person more difficult or impossible. 6. Health reasons must be documented by a medical certificate, except in cases where the current health condition clearly indicates sudden health problems manifesting in fulfilling health reasons according to paragraph 2 letter B and paragraph 3 letter A. This certificate must be carried by the driver or transported child or person accompanying the transported child while driving and must be presented for inspection upon request of a policeman or municipal police officer, in cases where it is not a permanent condition. The validity of the medical certificate must be time-limited to a maximum period of 1 year. The implementing legal regulation establishes requirements and a template for the medical certificate. 7. A motor vehicle driver must have with them while driving a valid driving permit. This does not apply if they are a holder of a Czech Republic driving permit, b. a vehicle registration certificate, according to a special legal regulation. This does not apply if the vehicle is registered in the vehicle register, according to a special legal regulation. c. A driver's professional competence certificate, or similar document issued by another member state or Swiss Confederation, or a driver's certificate, according to a directly applicable European Union regulation regulating access to the international road freight transport market with professional competence data marked with a harmonized code, if Section 3, Paragraph 4 applies to them. This does not apply if they have a record of professional competence in their driving permit, or this fact is recorded in the Central Driver Register. D. A health fitness document. If it concerns a driving license holder who is over 65 years old and is obliged to undergo regular medical examinations according to Section 87, Paragraph 1 or 3. And E. In the case of a vehicle of category M2, M3, N2, N3, O3 or O4, or a vehicle of category T with design speed exceeding 40 km/h. 1. A document about the last technical road inspection, if it was performed on the territory of another member state, and 2. A document about the last regular technical inspection, if it concerns a vehicle registered in another member state. 8. Upon request of a policeman, military policeman, municipal police officer, road transport inspector in uniform, hereinafter road transport inspector, or customs officer in uniform, hereinafter customs officer. A motor vehicle driver is obliged to present the documents according to Paragraph 7 for inspection. If they are not obliged to have some of these documents with them while driving, they may prove their identity instead of presenting it. 9. If during vehicle inspection, a driver presents a vehicle registration certificate that was declared retained according to Section 6b, Paragraph 4, or a driving permit that was declared retained according to Section 118b, Paragraph 6, or whose holder lost their driving license, or it was revoked or suspended, the policeman, military policeman, municipal police officer, road transport inspector, or customs officer shall confiscate this document and immediately deliver it to the competent municipal authority with extended competence. They shall issue a receipt to the driver. 10. A motor vehicle driver is obliged to subject the vehicle upon request of a policeman or road transport inspector to technical road inspection. Inspection of cargo placement, securing or fastening, vehicle or vehicle combination weight inspection. Weight ratio inspection of vehicles in a vehicle combination. Weight distribution inspection on axles, axle groups, wheels or wheel groups, vehicle or vehicle combination dimension inspection, including cargo or inspection of compliance with vehicle combination connectivity conditions. Section 6. A technical road inspection. 1. Technical road inspection means inspection of the technical condition and function of a vehicle, its systems, structural parts and independent technical units, and their impact on the environment for the purpose of detecting or excluding defects, according to a special legal regulation. If the purpose of technical road inspection cannot be achieved using means or equipment that a policeman or road transport inspector has available at the inspection site, and there are reasonable doubts about the technical capability of the vehicle. Technical road inspection can also be performed using a mobile inspection unit, at a technical inspection station, or at an emissions measurement station. 2. During technical road inspection, the driver is obliged to a. Drive to a mobile inspection unit, technical inspection station, or emissions measurement station, if the detour including the return journey is not longer than 50 kilometers. B. Present documents according to Section 6, Paragraph 7, letter E. If it concerns a vehicle of category M2, M3, N2, N3, O3, O4, or a vehicle of category T with design speed exceeding 40 km/h, and C. Follow the instructions of the person performing the inspection. 3. The police or road transport inspection issues a document about the performed technical road inspection to the driver. The police or road transport inspection transmits data contained in this document to the Ministry of Transport, hereinafter Ministry. The Ministry makes this data available through the Technical Inspection Information System. 4. The costs of performing technical road inspection are paid to the person who performed it by the police or road transport inspection. If a serious or dangerous defect is detected during technical road inspection, the vehicle driver is obliged to reimburse the police or road transport inspection for the costs of performing this inspection. Tax procedures are followed in administering payment of these costs. 5. Technical road inspections are performed regardless of the driver's nationality and the state in which the vehicle is registered. Technical road inspection must not be performed by a person who is biased due to their relationship to the driver or vehicle operator. A person performing technical road inspection must not obtain material or other benefit depending on the inspection result. A person operating a mobile inspection unit must be a holder of a control technician professional certificate. 6. Technical road inspections of vehicles of categories M2, M3, N2, N3, O3 and O4 are performed so that the total number of these inspections performed in a calendar year corresponds to at least 5% of the total number of vehicles of these categories registered in the vehicle register. 7. The method and scope of performing technical road inspection. Technical conditions for evaluating its result. Technical requirements for mobile inspection units. Requirements for the document about performed technical road inspection. Method and form of transmitting data contained in this document and method of determining costs for performing technical road inspection are established by implementing legal regulation. Section 6b. 1. If a dangerous defect is detected during technical road inspection, or when investigating a traffic accident that significantly increases the endangering of traffic safety on roads or adverse effects of vehicle operation on the environment due to its nature or extent, the policeman or road transport inspector retains the vehicle registration certificate showing such defect and issues a document about this to the vehicle driver or its operator, if present. Until the issuance of a technical inspection protocol according to Section 6c paragraph 1, the vehicle cannot be used in traffic on roads. 2. In the document about retention of vehicle registration certificate, according to paragraph 1, the policeman or road transport inspector states: A. Identification data of the retained vehicle registration certificate. B. Detected defects according to paragraph 1. C. Information about whether the vehicle registration certificate was retained during technical road inspection, or when investigating a traffic accident. D. The authority competent to return the retained vehicle registration certificate. E. Instruction about the consequences of retention of the vehicle registration certificate and conditions for its return. And F. In case the driver did not present the vehicle registration certificate, information about this fact. 3. The retained vehicle registration certificate is sent by the police or road transport inspection together with a copy of the document about its retention and a copy of the document about performed technical road inspection, if issued without undue delay, at the latest the next working day after the day of its retention, to the municipal authority with extended competence competent for recording vehicle data in the vehicle register according to a special legal regulation, or to the ministry, if there is no such authority. If the document about retention of vehicle registration certificate is not issued according to paragraph 1 to the vehicle operator, the police or road transport inspection sends a copy of the document to the vehicle operator within the same deadline. 4. If there is a reason for retention of vehicle registration certificate according to paragraph 1 and the driver did not present it to the policeman or road transport inspector, the policeman or road transport inspector declares this vehicle registration certificate as retained. Paragraphs 1 to 3 apply accordingly with the provision that the vehicle registration certificate is not attached to the copy of the document about retention of vehicle registration certificate, and the vehicle operator has the obligation to surrender the vehicle registration certificate within 5 working days from the day they were issued the document about retention of vehicle registration certificate, or a copy was delivered to them, to the authority according to paragraph 3. 5. Paragraph 1 does not apply to vehicles of basic components of the integrated rescue system, vehicles of armed forces, vehicles of intelligence services, and mountain rescue service vehicles. 6. Dangerous defects that significantly increase the endangering of traffic safety on roads or adverse effects of vehicle or vehicle combination operation on the environment due to their nature or extent. And templates of documents about retention of vehicle registration certificate, according to paragraphs 1 and 4, are defined by implementing legal regulation. Section 6C. 1. The authority to which the retained vehicle registration certificate was sent or surrendered according to Section 6B paragraphs 3 or 4 returns the retained vehicle registration certificate to the vehicle operator upon their request. If the applicant proves with a technical inspection protocol that a. Dangerous defects detected during technical road inspection were removed, or b. The vehicle is technically capable for traffic on roads if it concerns dangerous defects detected when investigating a traffic accident. 2. If the ministry does not receive a request according to paragraph 1 within 30 days from the day of delivery of the retained vehicle registration certificate, it sends this certificate to the competent central authority of the state that issued the vehicle registration certificate. 3. The technical inspection protocol according to paragraph 1 replaces the retained vehicle registration certificate for a period of 5 working days. Section 7. 1. The driver must not a. Hand over control of a motor vehicle to a person who does not meet the conditions of Section 3 paragraph 3. b. Bother other traffic participants on roads or other persons especially by excessive noise, air pollution, splashing puddles, mud or unnecessary leaving the engine of a stationary vehicle running. c. Hold in hand or otherwise a telephone device or other voice or recording device while driving a vehicle. d. Smoke while riding a motorcycle, moped or bicycle. e. Transport a person under 12 years of age on the second seat of a motorcycle. 2. A public transport vehicle driver must not smoke in the vehicle and must not eat and drink while driving. Talk with transported persons and let them into the space reserved for the driver. Start before closing doors and open doors before stopping. 3. A taxi service and occasional personal road transport vehicle driver must not smoke in the vehicle while transporting persons. 4. A motor vehicle driver with maximum permissible mass exceeding 3,500 kg, special vehicle or vehicle combination driver, must drive downhill with a gear engaged. A motor vehicle driver with maximum permissible mass not exceeding 3,500 kg must do so if driving safety requires it. 5. The provision of paragraph 1 letter C does not apply to drivers of vehicles of security corps, armed forces and military intelligence when performing official duties. Drivers of municipal police vehicles when performing their duties and drivers of vehicles of fire protection units and emergency medical service providers when solving extraordinary events and mountain rescue service when solving extraordinary events. Section 8 Tram Driver Obligations. 1. For tram drivers, Section 4, 5 and Section 7 paragraph 1 letters A and C apply. 2. A tram driver is obliged to have with them, while driving a tram, an identity card and a competence certificate for driving rail vehicles according to a special legal regulation. Upon request of a policeman, the tram driver is obliged to present these documents to the policeman for inspection. Section 8 A Driving School Instructor Obligations. 1. A driving school instructor, when supervising a motor vehicle driver according to Section 3 paragraph 3 letters B or C, must not a. Consume an alcoholic beverage or use another addictive substance during driving in a training vehicle. b. Perform driving school instructor activity immediately after consuming an alcoholic beverage or using another addictive substance, or at such time after consuming an alcoholic beverage, or using another addictive substance when they could still be under the influence of alcohol or another addictive substance, for assessing the influence of a driving school instructor by another addictive substance. Section 5, paragraph 2, letter B, applies accordingly. C. Perform driving school instructor activity if their ability to perform this activity is reduced as a result of their health condition. 2. A driving school instructor, when supervising a motor vehicle driver according to Section 3, paragraph 3, letters B or C, is obliged to a. Submit to examination according to a special legal regulation upon request of a policeman, military policeman, employer, attending physician or municipal police officer to determine whether they are not influenced by alcohol. B. Submit to examination according to a special legal regulation upon request of a policeman, military policeman, employer, attending physician or municipal police officer to determine whether they are not influenced by another addictive substance. Section 9, transported person obligations. 1. A transported person is obliged to a. Be fastened to the seat with a safety belt while driving, if the seat is mandatorily equipped with it according to a special legal regulation. B. Use a protective helmet of approved type according to a special legal regulation while riding a motorcycle or moped, which they have properly fitted and secured on their head. C. Not endanger traffic safety on roads by their behavior, especially not restrict the driver in safe vehicle control. D. Follow driver instructions, especially when boarding and alighting from the vehicle. 2. The obligations according to paragraph 1, letter A, do not apply to a person over 18 years of age and shorter than 150 cm, and a person who cannot do so for health reasons based on a medical certificate. The medical certificate must be carried while driving. In cases where it is not a permanent condition, the validity of the medical certificate must be time-limited to a maximum period of 1 year. The requirements of the medical certificate are established by implementing legal regulation. If a mobility-impaired person is transported in a vehicle on a wheelchair, both the wheelchair and the mobility-impaired person must be fastened with a special restraint system of approved design. 3. The obligations according to paragraph 1, letter A, further do not apply to security corps, armed forces and military intelligence when performing their official duties, municipal police when performing tasks according to law, firefighters in fire protection vehicles and rescuers in Mountain Rescue Service rescue vehicles when solving extraordinary events, when using a safety belt prevents quick exit from the vehicle, driving instructors during training, as well as to medical personnel of emergency medical service providers, rescuers or medical personnel of Mountain Rescue Service who provide medical services to a patient during transport. 4. The obligation according to paragraph 1, letter B, does not apply to a Mountain Rescue Service member in cases where using a protective helmet could make communication with the rescued person more difficult or impossible, or when using a protective helmet is excluded by the rescued persons. Health condition. 5. A transported person must not throw objects from the vehicle. 6. A transported person when riding a motorcycle must touch the foot pegs with their feet and must not smoke. 7. Side seating on a motorcycle is prohibited. 8. A transported person who can actively participate in vehicle driving, especially by pedaling, braking, negatively affecting vehicle balance in similar ways, must not consume an alcoholic beverage or use another addictive substance during driving and immediately before starting it, or start driving at such time after consuming an alcoholic beverage or using another addictive substance when they could still be under the influence of alcohol or another addictive substance. For assessing the influence of a transported person according to this sentence by another addictive substance, Section 5, paragraph 2, letter B, applies accordingly. A transported person according to the previous sentence is obliged to submit to examination according to a special legal regulation upon request of a policeman, military policeman, employer, attending physician or municipal police officer to determine whether they are not influenced by alcohol or another addictive substance. Division 2 Vehicle Operator Section 10 Vehicle Operator Obligations 1. A vehicle operator must not a. Order or allow a vehicle that does not meet the conditions established by a special legal regulation to be used in traffic on roads, unless it concerns a trailer chassis vehicle, for a mountain rescue service rescue vehicle according to Section 5, Paragraph 3, b. Entrust vehicle control to a person who does not meet the conditions of Section 3, Paragraph 2. c. Entrust motor vehicle control to a person who does not meet the conditions according to Section 3, Paragraph 3. d. Order or entrust independent vehicle control to a person about whom they do not know the data necessary to determine their identity. 2. A vehicle operator is obliged to ensure that the color design and marking of the vehicle is not confusable with the special color design of vehicles of the military police, according to a special legal regulation. Police according to a special legal regulation. Customs Administration according to a special legal regulation. Municipal Police according to a special legal regulation. Road Transport Inspection according to a special legal regulation. Prison Service of the Czech Republic. Hereinafter, Prison Service. According to a special legal regulation. Emergency Medical Service Vehicles according to a special legal regulation, and Fire Protection Unit vehicles according to a special legal regulation. 3. A vehicle operator ensures that when using a vehicle on a road, driver obligations and traffic rules on roads established by this law are observed. 4. A vehicle operator and a person to whom the operator entrusted the vehicle, except when the vehicle operator is an intelligence service, are obliged upon police, regional authority or municipal authority with extended competence request to state facts necessary to determine the identity of the vehicle driver suspected of violating provisions of this law. This provision does not affect the provision of a special legal regulation regulating the right to refuse testimony or providing explanation. 5. A vehicle operator of a vehicle of category M2 and M3 that is equipped with a restraint safety system is obliged to ensure that transported persons over 3 years of age or persons accompanying them are instructed about the obligation to use this restraint safety system. Methods of informing are established by implementing legal regulation. Division 3 Traffic Rules on Roads Subdivision 1 Vehicle Driving Section 11 Direction and Method of Driving 1. On a road, driving is on the right, and unless special circumstances prevent it, at the right edge of the roadway, unless otherwise established. 2. A motor vehicle driver may enter the hard shoulder only when stopping and standing or, if necessary, when bypassing, avoiding, turning or turning around. They must exercise increased caution. Section 12 Driving in Traffic Lanes 1. Outside built-up areas on a road with 2 or more traffic lanes marked on the roadway in one direction of travel, driving is in the right traffic lane. Other traffic lanes may be used if it is necessary for bypassing, overtaking, turning around or turning. 2. In built-up areas on a road with 2 or more traffic lanes marked on the roadway in one direction of travel, a motor vehicle driver may use any traffic lane for driving. It is not considered overtaking if vehicles in one traffic lane travel faster than vehicles in another traffic lane. If vehicles traveling simultaneously in all traffic lanes would prevent a faster traveling vehicle from driving, the driver in the leftmost traffic lane must clear this lane as soon as possible. This does not apply if the driver uses the leftmost traffic lane for turning around or during parallel driving according to paragraph 3. A driver of a truck with total mass exceeding 3,500 kg, vehicle combination whose total length exceeds 7 m, special motor vehicle, motorcycle with design speed up to 45 km/h, and a cyclist may use the leftmost traffic lane for driving only if it is necessary for bypassing, overtaking, turning around, or turning. 3. If there is such traffic density on a road with 2 or more traffic lanes in one direction of travel that continuous vehicle streams are formed in which a motor vehicle driver can only drive at a speed depending on the speed of vehicles traveling ahead. Motor vehicles may drive in parallel, hereinafter parallel driving. It is not considered overtaking if vehicles in one traffic lane travel faster than vehicles in another traffic lane. 4. On a road with 3 or more traffic lanes marked on the roadway in one direction of travel, a driver of a truck with total mass exceeding 3,500 kg, vehicle combination whose total length exceeds 7 m. Special motor vehicle and motorcycle with design speed up to 45 km/h may use exclusively the 2 traffic lanes closest to the right edge of the roadway for driving. They may drive in other traffic lanes only if it is necessary for bypassing, turning around, or turning. 5. A driver may change from one traffic lane to another only if they do not endanger or restrict a driver traveling in the traffic lane into which they are changing. They must give signals about changing driving direction. During parallel driving, drivers of vehicles traveling in the through lane enable drivers of vehicles changing into this lane from a lane that ceased to be through to enter, so that vehicles traveling in the through lane and vehicles changing into it can merge alternately one by one into the traffic stream of the through lane. Where 2 traffic lanes converge into one without it being clear which is through, a driver in the left traffic lane must not endanger a driver in the right traffic lane. 6. On a road with 3 traffic lanes marked on the roadway in one direction of travel, a driver may change from the left traffic lane to the middle traffic lane only if they do not endanger a driver changing to the middle traffic lane from the right traffic lane. Similar procedure applies when changing from left traffic lanes to middle traffic lanes on a road with 4 or more traffic lanes marked on the roadway. 7. If a merging lane is established for merging into the through traffic lane, the driver is obliged to use the merging lane before merging into the through lane. When merging from the merging lane into the through lane, the driver must not endanger drivers traveling in the through lane. If no merging lane is established, the driver is obliged to give way to vehicles traveling in the through lane. 8. If traffic lanes are not marked on the roadway, for the purposes of paragraphs 3 and 5, a traffic lane means a part of the roadway allowing the movement of vehicles other than 2-wheeled motorcycles in a traffic stream one after another. Section 13. Driving in special cases. 1. Along a boarding or protective island, driving is on the right. Driving on the left is allowed only if an obstacle prevents driving on the right or if it is safer, considering the dimensions of the vehicle or cargo. When driving along a boarding or protective island, increased caution is necessary. Along a tram, driving is on the right, unless the traffic sign "tram bypassing" allows driving on the left. 2. A tram lane at roadway level may be entered longitudinally only when bypassing, overtaking, turning around, entering a road, or if special circumstances require it, for example if there is insufficient space between the tram lane and the roadway edge. A tram lane elevated above or lowered below the roadway level or otherwise separated from the roadway, for example by a curb, may be crossed only transversely and at place adapted for this purpose. When entering a tram lane, the driver must not endanger or restrict a tram in its movement. Section 14. 1. If a traffic lane is marked with the traffic sign "Reserved Traffic Lane," hereinafter "Reserved Traffic Lane." For a certain type of vehicle, Section 13, paragraph 2 applies accordingly for drivers of other vehicles, and if the reserved traffic lane is marked on a tram lane, also Section 21, paragraph 7. A traffic lane cannot be reserved for motorcycles. 2. If a driver of a vehicle for which a traffic lane is reserved changes from the reserved traffic lane to an adjacent traffic lane, a driver of a vehicle traveling in this lane must enable this by reducing driving speed, possibly even by stopping the vehicle. A driver of a vehicle in the reserved traffic lane is obliged to give signals about changing driving direction and must not endanger drivers of other vehicles. 3. If a vehicle for which a traffic lane is reserved travels in the reserved traffic lane, or a tram travels at a different speed than other vehicles traveling in the same direction, it is not considered mutual overtaking. 4. If traffic in a reserved traffic lane marked on a tram lane is controlled by light signals for trams, a driver of a vehicle traveling in this traffic lane follows these light signals. 5. If a traffic lane is marked with horizontal traffic signs as a traffic lane for cyclists, paragraphs 1 to 3 apply accordingly for cyclists and drivers of other vehicles. A driver of another vehicle may enter a traffic lane for cyclists longitudinally also when the adjacent traffic lane is not sufficiently wide for this vehicle. When entering a traffic lane for cyclists, the driver must not endanger a cyclist traveling in this lane. Section 15. 1. Behind a public transport vehicle that is stopped in a built-up area at a stop without a boarding island or without a platform on an elevated tram lane, the driver of another vehicle must stop their vehicle. If there are multiple public transport vehicles at the stop, they must stop behind the second one. They may continue driving only when they will not endanger passengers who are boarding or alighting. This does not apply if a bus or trolleybus stops at the roadway edge. 2. Behind a bus marked designation of bus transporting children that is stopped at a designated stop, the driver of another vehicle must stop their vehicle. They may continue driving only after the bus departs from the stop. Drivers of oncoming vehicles must consider the possibility of children running into the roadway and adapt their driving so that children are not endangered. Section 16. Bypassing a driver who, when bypassing a vehicle that is stopped or is standing, or when bypassing a traffic obstruction on roads or pedestrians, deviates from the direction of their travel, must not endanger or restrict an oncoming driver and endanger other traffic participants on roads. They must give signals about changing driving direction. Section 17. Overtaking. 1. Overtaking is done on the left. Overtaking on the right is done of a vehicle that is changing direction to the left and there is no longer any doubt about the further direction of its travel. When driving in a merging or turning lane, a vehicle traveling in the through lane may also be overtaken on the right. A turning lane is an additional traffic lane intended for turning, exiting vehicles from the through traffic lane. 2. A driver who deviates from the direction of their travel when overtaking must give signals about changing driving direction and must not endanger drivers traveling behind them. A driver must give signals about changing driving direction when overtaking a cyclist. 3. A driver who merges in front of a vehicle they have overtaken after overtaking must give signals about changing driving direction and must not endanger or restrict the driver of the vehicle they overtook. 4. The driver of an overtaken vehicle must not increase driving speed or otherwise prevent overtaking. 5. A driver must not overtake a. If they do not have visibility ahead for such distance that is necessary for safe overtaking, b. If they could not safely merge in front of the vehicle or vehicles they intend to overtake, c. If they would endanger or restrict an oncoming driver or endanger other traffic participants on roads, d. At a pedestrian crossing or bicycle crossing and immediately before them, e. If the driver of a vehicle traveling ahead gives signals about changing direction to the left and overtaking on the right according to paragraph 1 or overtaking in another free traffic lane marked on the roadway in the same direction of travel, is not possible. F. At an intersection and in close proximity before it, this prohibition does not apply. 1. if it concerns overtaking on the right according to paragraph 1, 2, if it concerns overtaking bicycles, mopeds, and motorcycles without sidecar, 3, on a main road, 4, at an intersection with controlled traffic, G, at a railway crossing and in close proximity before it. 6. When overtaking a cyclist, a motor vehicle driver is obliged to maintain a safe lateral distance. A safe lateral distance when overtaking a cyclist means a distance between the nearest edges of the motor vehicle, trailer vehicle or cargo, and the bicycle, trailer or cyclist of at least 1.5 m. In a place with maximum permitted speed not exceeding 30 km/h. The safe lateral distance when overtaking a cyclist, according to the second sentence, is at least 1 m. Section 18. Driving speed. 1. A driver must adapt driving speed especially to their abilities, vehicle and cargo characteristics, expected structural and traffic technical condition of the road, its category and class, weather conditions and other circumstances that can be anticipated. They may drive only at such speed that they are able to stop the vehicle at a distance at which they have visibility. 2. A driver must not a. Suddenly reduce driving speed or suddenly stop unless traffic safety on roads requires it. B. Restrict the smoothness of traffic on roads, especially by unreasonably slow driving and slow overtaking. 3. A motor vehicle driver with maximum permissible mass not exceeding 3,500 kg, basic component vehicle of the integrated rescue system and bus, may drive outside built-up areas at a speed of maximum 90 km/h. On a road for motor vehicles at a speed of maximum 110 km/h, and on a motorway at a speed of maximum 130 km/h. A driver of another motor vehicle may drive at a speed of maximum 80 km/h. 4. In built-up areas, a driver may drive at a speed of maximum 50 km/h, and if it concerns a motorway or road for motor vehicles, maximum 80 km/h. 5. A driver must not exceed the design speed of the vehicle, and if it concerns a vehicle combination, the design speed of any vehicle in the combination. 6. By local traffic regulation on roads according to Section 61, Paragraph 2, the maximum permitted speed according to paragraphs 3 and 4 can be reduced. If it concerns a motorway or road for motor vehicles without directionally separated carriageways, the maximum permitted speed is reduced to maximum 90 km/h. 7. By local traffic regulation on roads according to Section 61, Paragraph 2, the maximum permitted speed according to paragraph 4 can be increased, but by maximum 30 km/h. On a road for motor vehicles with directionally separated carriageways or on a motorway, the maximum permitted speed according to paragraph 3 can also be increased, but by maximum 20 km/h. 8. When using snow chains on a vehicle, a driver may drive at a speed of maximum 50 km/h. 9. The maximum permitted speed according to paragraphs 3, 4, and 8, and maximum permitted speed established by local or temporary traffic regulation on roads does not apply to drivers of vehicles of intelligence services. General inspection of security corps and designated organizational parts of the fire rescue service of the Czech Republic and police and military police units, and organizational units of customs administration bodies, if it is necessarily needed to fulfill tasks established by special legal regulation, but they are obliged to exercise necessary caution so as not to endanger road traffic safety on roads. Organizational parts of the fire rescue service of the Czech Republic and police units are established by the Minister of the Interior. Military police units are established by the Minister of Defense. Organizational units of customs administration bodies are established by the Minister of Finance. Section 19. Distance between vehicles. 1. A driver of a vehicle traveling behind another vehicle must maintain a safe distance behind it so that they can stop the vehicle in case of sudden speed reduction or sudden stopping of the vehicle traveling ahead. 2. A motor vehicle driver with maximum permissible mass exceeding 3,500 kg. Vehicle combination whose total length exceeds 10 m. And special vehicle driver must maintain such distance behind a vehicle traveling ahead outside built-up areas that an overtaking vehicle can safely merge in front of them. This does not apply when preparing for overtaking, during overtaking, and during parallel driving. 3. A driver who does not intend or cannot drive along a tram on the right must travel behind it at such distance that allows other drivers to drive along the tram. Section 20. Avoiding drivers of oncoming vehicles avoid each other on the right, in time and sufficiently. If they cannot safely avoid each other, the one on whose side of travel there is an obstacle or narrowed roadway must give way. If one of them must reverse, the one for whom it is easier or less dangerous does so. If it is not possible to avoid an oncoming tram on the right, it is avoided on the left. Section 21. Turning. 1. When turning at an intersection or to a place located outside the road, the driver must give signals about changing driving direction. When turning, they must not endanger drivers traveling behind them and must exercise increased caution. 2. If circumstances require it, for example when transporting long cargo, the driver must ensure safe turning with the help of a capable and properly instructed person. 3. Before turning right, the driver must position themselves as close as possible to the right edge of the roadway. If they must deviate to the left from the direction of their travel considering vehicle or cargo dimensions, they always give signals about changing direction only to the right. Before turning left, they must position themselves as far left as possible in the part of the roadway intended for their direction of travel considering vehicle or cargo dimensions and roadway width. When drivers of oncoming vehicles turn left, they avoid each other on the left. 4. A driver who leaves the through lane when turning must enter the turning lane as soon as possible, if marked. 5. A driver turning left must give way to oncoming motor and non-motor vehicles, riders on animals, oncoming organized pedestrian groups and guides of driven animals with animals, trams traveling in both directions and vehicles traveling in a reserved traffic lane for which this traffic lane is reserved, and cyclists traveling in a traffic lane for cyclists. 6. A driver turning right must give way to vehicles traveling in a reserved traffic lane for which this traffic lane is reserved, and cyclists traveling in a traffic lane for cyclists. Where driving along a tram on the left is permitted, they must also give way to the tram. 7. A tram that crosses the direction of travel of a vehicle traveling on its right or left side when turning or otherwise changing driving direction, and gives signals about changing driving direction, has the right of way. Section 22. Driving through intersections. 1. A driver approaching an intersection on a secondary road marked with the traffic sign "Give way" or "Stop, give way" must give way to vehicles or riders on animals approaching on the main road, or an organized group of pedestrians or guides of driven animals, with animals coming on the main road. 2. If the right-of-way does not follow from the provision of paragraph 1, the driver must give way to vehicles or riders on animals approaching from the right, or an organized group of pedestrians or guides of driven animals, with animals coming from the right. 3. A driver must not enter an intersection if the situation does not allow them to continue driving in the intersection and beyond the intersection, so that they would be forced to stop the vehicle in the intersection. This does not apply if the driver stops the vehicle in the intersection for the purpose of fulfilling obligations according to Section 5, Paragraph 1, letter H, or when turning left according to Section 21, Paragraph 5. 4. Upon the command of the traffic sign, "Stop, give way," the driver must stop the vehicle at such place from where they have proper visibility into the intersection. 5. A driver entering a roundabout marked with traffic signs, "Roundabout" together with the sign "Give way," or "Roundabout" together with the sign "Stop, give way," must give way to vehicles and riders on animals traveling on the roundabout and organized groups of pedestrians and guides of led and driven animals, with animals walking on the roundabout. Section 23. Entering a road. 1. When entering a road from a place located outside the road, the driver must give way to vehicles or riders on animals traveling on the road, or an organized group of pedestrians or guides of driven animals with animals walking on the road. This also applies when entering from a purpose road, or from a bicycle path, or from a residential, pedestrian, or bicycle zone to another road. 2. If circumstances require it, especially insufficient visibility, the driver must ensure safe entry onto the road with the help of a capable and properly instructed person. 3. Vehicles entering a road must be previously cleaned so that they do not pollute the road. Section 24. Turning around and reversing. 1. When turning around, the provisions about turning, Section 21, apply accordingly. And when turning around at an intersection, also the provisions about driving through intersections, Section 22. 2. When reversing, the driver must not endanger other traffic participants on roads. 3. If circumstances require it, especially insufficient visibility, the driver must ensure safe turning around or reversing with the help of a capable and properly instructed person. 4. The driver must not turn around and reverse. A. In non-visible or otherwise dangerous places, for example in a non-visible curve and in its close proximity, before a non-visible hilltop of a road climb, on it and behind it. B. At an intersection with controlled traffic and in its close proximity. C. At a pedestrian crossing. D. At a bicycle crossing. E. At a railway crossing and in its close proximity. F. In a tunnel and in its close proximity. G. On a road with one-way traffic. They may reverse if it is necessarily needed, for example, to drive into a line of standing vehicles or drive out of it. Section 25. Stopping and standing. 1. A driver may stop and stand only, A. On the right in the direction of travel as close as possible to the road edge and on a one-way road both on the right and left, B. In one row and parallel to the road edge. If it does not endanger safety and smoothness of road traffic, a driver of a vehicle with total mass not exceeding 3,500 kg may stop and stand perpendicular or diagonally to the road edge in built-up areas, or stop in the second row. 2. In the second row, a taxi service vehicle driver marked with a roof light according to a special legal regulation may stop when performing taxi service, but they are obliged to exercise necessary caution so as not to endanger safety and smoothness of traffic on roads. 3. When standing, at least one traffic lane 3m wide must remain free for each direction of travel. When stopping, at least one traffic lane 3m wide must remain free for both directions of travel. 4. When stopping and standing, the driver must not prevent other drivers from exiting a line of standing vehicles. When stopping and standing next to a vehicle marked designation of vehicle transporting a severely mobility-impaired person, they must leave a lateral clearance of at least 1.2 m. 5. When a driver drives to the road edge or sidewalk for the purpose of stopping or standing, they must give signals about changing driving direction. 6. A driver of a vehicle that has stopped or stood and is driving away from the road edge or sidewalk, again, must give signals about changing driving direction and must not endanger other traffic participants on roads. Drivers of other vehicles must enable a public transport vehicle driver to exit a stop or stopping lane in built-up areas by reducing driving speed, possibly even by stopping the vehicle. The public transport vehicle driver must not endanger especially drivers of vehicles traveling in the same direction. Section 26. 1. Opening doors or side walls of a vehicle, as well as boarding or alighting from a vehicle, is allowed only when it does not endanger the safety of boarding or alighting persons or other traffic participants on roads. 2. A driver who intends to move away from the vehicle, so that they cannot immediately intervene if necessary, must take such measures that the vehicle cannot endanger traffic safety on roads and cannot be used by another unauthorized person. If the vehicle is mandatorily equipped with a device against unauthorized use, the driver must use it. A motor vehicle or vehicle combination driver mandatorily equipped with wheel chocks must use them if it is necessary to secure the vehicle or combination against movement. 3. A motor vehicle driver that is mandatorily equipped with a portable warning triangle must use this triangle during emergency standing, for example when interrupting travel due to a vehicle or cargo defect, as a result of a traffic accident or due to sudden illness. If such vehicle creates a traffic obstruction on roads, the triangle must be placed at the roadway edge so that it is visible to approaching drivers in time and clearly, at a distance of at least 50 m, on a motorway at least 100 m behind the vehicle. In built-up areas, this distance may be shorter if circumstances require it. If the motor vehicle is equipped with warning light equipment, the driver must use it at least for the time until they place the warning triangle on the roadway. Section 27. 1. A driver must not stop and stand, a. in a non-visible curve and in its close proximity, b. before a non-visible hilltop of a road climb, on it and behind it, c. at a pedestrian crossing or bicycle crossing and at a distance shorter than 5 m before them, d. at an intersection and at a distance shorter than 5 m before the intersection boundary and 5 m behind it. This prohibition does not apply in built-up areas at a T-shaped intersection on the opposite side of the emerging road, e. in a merging or turning lane, f. at a tram, bus or trolleybus stop without a boarding island in the section that begins with the traffic sign bus stop, tram stop or trolleybus stop, and ends at a distance of 5 m behind the stop sign, and where such traffic sign is not present, at a distance shorter than 30 m before and 5 m behind the stop sign, whereby if the stop space is marked with the horizontal traffic sign bus or trolleybus stop or tram stop. This prohibition applies only to the marked space. This does not apply to drivers of vehicles for whose stopping or standing the stop is intended, g. at a railway crossing, in an underpass and in a tunnel and at a distance shorter than 15 m before and behind them. H. in a place where the vehicle would cover a vertical traffic sign or horizontal traffic sign, directional arrows, or road inscription. I. in a reserved traffic lane and traffic lane for cyclists, J. in traffic lanes marked on the roadway outside the right traffic lane, K. at a distance shorter than 5 m from the beginning and end of the horizontal traffic sign, solid longitudinal line, or boarding island, where at least one traffic lane 3 m wide would not remain free between this traffic sign or boarding island and the vehicle, L. on a bridge, M. in a tunnel. This does not apply in case of emergency standing at a place marked with the traffic sign emergency standing. In case of emergency standing, the driver must turn off the engine, N, before the entrance to a road from a field or forest road or from a place located outside the road, O, in a reserved parking lot unless it concerns a vehicle for which the parking lot is reserved. This does not apply if it concerns stopping and standing that does not exceed 3 minutes and does not endanger or restrict other traffic participants on roads. Possibly does not restrict drivers of vehicles for which the parking lot is reserved, P, on a tram lane, R, on road vegetation. Unless permitted by local traffic regulation on the road, S, in other places where it would endanger traffic safety on roads, especially the movement of other vehicles. 2. From 5 o'clock to 19:00 hours, standing is prohibited where a free traffic lane 3. 5 m wide would not remain between the vehicle and the nearest tram rail. 3. On Class I roads, and during reduced visibility also on Class Roman II and Roman III roads outside built-up areas, stopping and standing is prohibited elsewhere than at places marked with a traffic sign as parking lots. 4. On a traffic ring marked with the traffic sign ring or ring direction change, standing is prohibited. 5. About removal of a vehicle that is unlawfully standing in a reserved parking lot, a policeman or municipal police officer decides. The vehicle is removed at the expense of its operator. 6. The prohibition of stopping and standing according to paragraphs 1 to 4 does not apply to drivers of vehicles of security corps, armed forces, and military intelligence when performing official duties. Drivers of municipal police or road transport inspection vehicles when exercising their competence, and drivers of vehicles of fire protection units, emergency medical service, and mountain rescue service when solving extraordinary events. The driver of this vehicle is obliged when stopping and standing to take measures necessary so as not to endanger safety and smoothness of traffic on roads, or to mitigate such endangering as much as possible. Section 28 Railway Crossing 1. Before a railway crossing, the driver must be especially cautious, especially make sure that they can safely cross the railway crossing. 2. Vehicles line up behind each other before a railway crossing in the order they arrived. Unless it concerns parallel driving or driving according to Section 12 Paragraph 2, vehicles may cross the railway crossing only in one traffic stream. 3. At a distance of 50 m before a railway crossing, and when crossing it, the driver may drive at a speed of maximum 30 km/h. If the intermittent white light of the crossing safety device signal is on, they may drive 50 m before the railway crossing, and when crossing it at a speed of maximum 50 km/h. When crossing a railway crossing, the driver must not unnecessarily prolong the time of crossing it. 4. If a vehicle stops at a railway crossing, its driver must remove the vehicle outside the railway track, and if they cannot do so, they must immediately do everything so that railway vehicle drivers are warned of the danger in time. 5. Before a railway crossing where the traffic sign "Stop, give way" is placed, the driver must stop the vehicle at such place from where they have proper visibility of the track. Section 29. 1. A driver must not enter a railway crossing, a. If a warning is being given by two red alternately flashing lights of the crossing safety device signal, b. If a warning is being given by the flashing sound of a horn or bell of the crossing safety device, c. If barriers are lowered or are lifting, d. If an approaching train or other railway vehicle is already visible or audible, or its honking or whistling is audible. This does not apply if the intermittent white light of the crossing safety device signal is on. E. If a railway employee gives a stop signal by circling a red or yellow flag, and during reduced visibility by circling a red light. F. If the situation beyond the railway crossing does not allow its safe crossing and continuing in the journey. 2. In cases listed in paragraph 1 letters A, B, and C, the driver may enter the railway crossing only if they received oral consent from an authorized employee of the railway operator before the railway crossing to travel across the railway crossing. In this case, the driver is obliged to follow the instructions of the authorized employee of the railway operator when traveling across the railway crossing. The authorized employee of the railway operator is obliged to identify themselves with a valid authorization from the railway operator upon the driver's request. Section 30 Signals about changing driving direction. 1. In addition to cases listed in individual provisions, the driver must also give signals about changing driving direction always when changing driving direction, deviating from it, or if traffic safety on roads requires it. 2. The driver must give signals about changing driving direction in time before starting a driving maneuver considering traffic circumstances on roads, especially drivers traveling behind them and the nature of the driving maneuver. 3. Signals for changing direction of travel are given by directional lights. If the vehicle is not equipped with them, or in case of malfunction, signals are given by arm extension. With the arm bent upward at the elbow, a signal is given for changing direction of travel to the opposite side. When circumstances require it, particularly when signals given by directional lights or arm are not sufficiently visible, for example due to load width or reduced visibility. Signals must be given by other clearly visible means, for example by a competent and properly instructed person. Otherwise, a driver may perform the intended driving maneuver only in such a way that other road traffic participants are not endangered or restricted. 4. A driver shall maintain signals for changing direction of travel given by directional lights only until completion of the change of direction of travel, deviation from it, or until the vehicle takes position in the lane it is entering. Signals for changing direction of travel given by arm are given only before beginning the driving maneuver. 5. When entering a roundabout and driving on a roundabout, unless changing from one lane to another according to Section 12(5). A driver does not give signals for changing direction of travel. When exiting a roundabout, a driver is required to give signals for changing direction of travel. Section 31 Warning Signals. 1. When necessary to avert imminent danger, a driver gives audible warning signals. Outside built-up areas, a driver may give audible warning signals also when necessary to alert the driver of an overtaken vehicle. 2. Instead of audible warning signals, a driver may give light warning signals by brief intermittent switching on of high beam or alternating between low and high beam. To alert the driver of an overtaken vehicle, these may be given also in built-up areas. 3. When necessary to alert other road traffic participants to imminent danger, particularly in cases when it is necessary to suddenly reduce speed or stop the vehicle. A driver gives light warning signals by switching on hazard warning lights. 4. Warning signals are used only for the time strictly necessary. Section 32 Vehicle Lighting. 1. A motor vehicle must have clearance lights and low beam lights or daytime running lights switched on while driving, if equipped with them according to a special legal regulation. A tram must have low beam lights or daytime running lights switched on. 2. During reduced visibility, a vehicle must have clearance and low beam or high beam lights switched on while driving, if equipped with them according to a special legal regulation. 3. A driver must not use high beam lights if the roadway is sufficiently and continuously lit, or if it could blind the driver of an oncoming vehicle, the driver of a vehicle ahead, or another road traffic participant, train operator, driver of another rail vehicle, or watercraft operator. When stopping a vehicle before a railway crossing, a driver must not use even low beam lights if they could blind a driver of a vehicle in the opposite direction. 4. Front fog lights may be used by a driver only during fog, snowfall, or heavy rain. Rear fog lights must be used by a driver during fog, snowfall, or heavy rain. 5. The active surface of lights must not be covered or excessively dirty. Section 33 Lighting for oversized vehicles. 1. Motor vehicles or vehicle combinations whose dimensions or load dimensions exceed the limits set by a special legal regulation must have clearance and low beam lights switched on while driving. 2. A vehicle standing during reduced visibility in a built-up area at a place where it creates an obstacle to road traffic, or on a road outside a built-up area, must have clearance or parking lights switched on at least on the side facing the center of the road, or must be illuminated on the side facing the center of the road by at least one white non-dazzling light visible from front and rear. This does not apply in parking areas. Section 34 Towing motor vehicles. 1. When towing a motor vehicle, the maximum speed is 60 km/h. 2. A motor vehicle may be towed on a rope only if it has functioning steering and effective brakes. 3. A motor vehicle may be towed on a rigid bar only if it has functioning steering. If the towed vehicle does not have effective brakes, its actual weight must not exceed the actual weight of the towing vehicle. 4. When towing a motor vehicle, the length of the coupling must be such that the distance between vehicles is not greater than 6 m. When using a rope, the distance between vehicles must not be less than 2.5 m, and when using a rigid bar, not less than 1 m. The coupling must be clearly marked rigid bar with transverse red and white stripes 75 mm wide. Rope with a red flag or plate measuring at least 300 x 300 mm. 5. Drivers of the towing and towed vehicles are required to agree in advance on the method of communication during travel. 6. Towing more than one motor vehicle or a motor vehicle with a trailer is prohibited. However, a motor vehicle with a semi-trailer may be towed. No other motor vehicle may be towed behind a motor vehicle with a trailer. A motorcycle without a sidecar and a moped may not be towed or used as a towing vehicle. 7. A bus or motor vehicle towed using special equipment may be towed only without passengers. 8. The towing vehicle must have clearance and low beam lights switched on. The towed vehicle must be visibly marked at the rear with a warning triangle, for example behind glass, on the rear face of the body. 9. During reduced visibility, the towed vehicle must have clearance or low beam lights switched on. In case of malfunction, the vehicle must be illuminated on the side facing the center of the roadway in front with a non-dazzling white light, and at the rear with at least one red light. These lights must be clearly visible and must not be placed more than 400 mm from the side outline of the vehicle. Division 2 Vehicle Operation in Special Cases, Section 35 Highway Operation. 1. On highways, only motor vehicles and vehicle combinations with a design speed not less than 80 km/h are permitted. In highway sections passing through built-up areas, motor vehicles and vehicle combinations for public mass transport with a design speed not less than 65 km/h are also permitted. Other road traffic participants are prohibited from entering, walking, and driving on highways, except in highway service areas. 2. A driver may enter and exit a highway only at designated places. 3. The prohibition of operation according to paragraphs 1 and 2 does not apply to vehicles of the road administrator lawfully used for road management and maintenance. Section 36 Highway Restrictions. 1. On highways, drivers are prohibited from a. Stopping and standing anywhere except at places designated as parking areas. During emergency stopping according to Section 26(3), the vehicle must stand on the shoulder and only if this is not possible on the roadway. Such a vehicle must always be marked by the driver as a traffic obstacle. In case of a motor vehicle required to carry a portable warning triangle, the driver must place the triangle according to Section 26(3). B. Turning around, backing up, and entering the central dividing strip, including places where the strip is interrupted. 2. If a defect occurs during travel on a vehicle or load that prevents reaching a speed of at least 80 km/h on level ground, the driver must leave the highway at the nearest exit. 3. Towing a motor vehicle is permitted only when necessary for its removal from the highway. The vehicle may be towed only to the nearest exit, where it must leave the highway. 4. The driver of a truck or special vehicle with a total weight exceeding 500 kg, and the driver of a vehicle combination with a total length exceeding 7 m, must not overtake another vehicle unless they have sufficient speed to overtake it without restricting other vehicles with their significantly lower travel speed. Section 37 General Highway Provisions, unless otherwise specified in this division. Other provisions of this law apply to highway operation. Section 38 Roads for Motor Vehicles Provisions on Highway Operation also apply to roads for motor vehicles. Section 39 Operation in Residential, Pedestrian, Cycling, and Shared Zones. 1. A residential zone is a built-up area whose beginning is marked by the traffic sign residential zone and whose end is marked by the traffic sign end of residential zone. 2. A pedestrian zone is an area whose beginning is marked by the traffic sign pedestrian zone and whose end is marked by the traffic sign end of pedestrian zone. 3. In residential and pedestrian zones, pedestrians may use the road in its entire width, and Section 53 does not apply to them. Children's games on the road are permitted only in residential zones. 4. Entry to a pedestrian zone is permitted only for vehicles marked in the lower part of the traffic sign, according to paragraph 2. 5. In residential and pedestrian zones, a driver may travel at a maximum speed of 20 km/h. They must exercise increased consideration toward pedestrians, whom they must not endanger. If necessary, they must stop the vehicle. Parking is permitted only at places designated as parking areas. 6. For traffic organization purposes, a municipality may, in a generally binding municipal regulation issued in delegated competence, designate local roads or their sections in residential zones that may not be used for parking by trucks, tractors with maximum permissible weight exceeding 500 kg and design speed of 80 km/h or higher, or vehicle combinations. 7. In residential and pedestrian zones, pedestrians must allow vehicles to pass. This also applies to children playing in residential zones. Section 39A. Cycling zones. 1. A cycling zone is an area whose beginning is marked by the traffic sign cycling zone and whose end is marked by the traffic sign end of cycling zone. 2. In cycling zones, cyclists may use the roadway in its entire width, and Section 57(2) and 3 do not apply to them. 3. Vehicles other than bicycles are permitted to enter a cycling zone only if they are marked in the lower part of the traffic sign, according to paragraph 1. 4. In cycling zones, a driver may travel at a maximum speed of 30 km/h. They must exercise increased consideration toward cyclists, whom they must not endanger. If necessary, they must stop the vehicle. Parking is permitted only at places designated as parking areas. 5. In cycling zones, cyclists must allow motor vehicles to pass. Section 39B. Shared zones. 1. A shared zone is a built-up area whose beginning is marked by the traffic sign shared zone and whose end is marked by the traffic sign end of shared zone, and is intended for use by all road traffic participants. 2. In shared zones, road traffic participants must exercise increased consideration toward other traffic participants, whom they must not endanger. Other road traffic participants must not restrict tram drivers, and trams always have right-of-way. 3. In shared zones, pedestrians and cyclists may use the road in its entire width, with Section 53 and 54 not applying to pedestrians and Section 57(2) and 3 not applying to cyclists. When a vehicle with right-of-way approaches, pedestrians must immediately clear space for this vehicle to pass. 4. In shared zones, a driver may travel at a maximum speed of 20 km/h. Parking of motor vehicles is permitted only at places designated as parking areas. Parking of bicycles and other non-motor vehicles is permitted only at designated places. Section 40. General provisions for special zones. 1. Unless otherwise specified in this division, other provisions of this law apply to operation in residential, pedestrian, cycling, and shared zones. 2. If cyclists are permitted to enter a sidewalk or pedestrian path, Section 39(5) and 7 apply analogously to their movement. Section 40. A vehicle operation in winter period. 1. During the period from November 1 to March 31, when a. There is a continuous layer of snow, ice, or frost on the road, or b. Weather conditions suggest that a continuous layer of snow, ice, or frost may occur on the road during travel. Motor vehicles of category M or N may be used for road traffic only under the condition of using winter tires on all wheels for motor vehicles, with maximum permissible weight not exceeding 3,500 kg. And on all wheels of driving axles with permanent power transmission for motor vehicles, with maximum permissible weight exceeding 3,500 kg. Winter tires, according to the first sentence, must have a tread depth of main tread grooves or cuts of at least 4 mm, and for motor vehicles with maximum permissible weight exceeding 3,500 kg, at least 6 mm. 2. Paragraph 1 does not apply to spare tires used for emergency driving. Section 41 Driving Vehicles with Right-of-Way. 1. A driver who uses special warning lights of blue or blue and red color, possibly supplemented by special audible warning signals, hereinafter, vehicle with right-of-way. While performing tasks related to special duties is not required to comply with Section 4C, Section 5(1)(h) and 2(f), Section 7(1)(b), Section 11, Section 12(1), 2, 4, 5, and 7, Section 13 to 17, Section 18, 2, 3, 4, and 8, Section 19, Section 20, Section 21, 2, 3, 4, 5, and 6, Section 22, 23, Section 24 and 5, Section 26, Section 27, 1, 2, 3, and 4, Section 28, 2, 3, and 5, Section 31, Section 35, 1 and 2, Section 36, 1, 2, and 4, Section 39, 4 and 5, Section 39A, 3 and 4, Section 39B, 2 and 4, Section 47, 2A and C, 3A, C, D, F, and G, and they must exercise necessary caution not to endanger road traffic safety. 2. Vehicles that may be equipped with special audible warning equipment supplemented by special warning lights of blue color include vehicles: A. Used by police and marked according to special legal regulation. B. Of the prison service. C. Of military police marked according to special legal regulation. D. Of municipal police designated by the municipality. E. Used by the Fire Rescue Service of the Czech Republic or fire protection units that are not part of the Fire Rescue Service. F. Of Mine Rescue Service. G. Of Gas Facility Emergency Services. H. Used by emergency medical services and vehicles of medical transport service providers and providers of non-urgent patient transport. I. Of armed forces used by military rescue units for humanitarian civil protection tasks. J. Of Customs Administration marked according to special legal regulation. K. Of the General Inspection of Security Corps marked according to special legal regulation. L. Of intelligence services when transporting classified information carriers or persons they provide protection to. M. Used by road traffic inspection and marked according to special legal regulation. 3. The government may establish by regulation additional vehicles that may be equipped with special audible warning equipment supplemented by special warning lights of blue color for performing tasks related to special duties. 4. A driver of a vehicle with right-of-way must be a person older than 21 years who must meet the conditions set by this law. 5. A driver of a vehicle with right-of-way must not eat, drink, or smoke while driving. 6. Paragraphs 1 and 4 also apply analogously to drivers of vehicles escorted in front, and for more than 3 vehicles, also behind by vehicles of armed forces or armed corps with right-of-way. Escorted vehicles must have clearance and low beam lights switched on. 7. Drivers of other vehicles must allow vehicles with right-of-way and vehicles escorted by them to pass safely and smoothly, and if necessary, stop their vehicles at such a place that they do not obstruct them. Drivers of other vehicles must not merge into a group formed by vehicles with right-of-way and vehicles escorted by them. 8. If a highway or road for motor vehicles with at least 2 lanes is not freely passable due to a queue of stopped or slowly moving vehicles, vehicle drivers are required to create space between lanes for vehicles with right-of-way to pass. They may enter the shoulder or central dividing strip. If there are more than 2 lanes in one direction, this space is created between the leftmost lane and the adjacent lane. Only vehicles with right-of-way, road administrator vehicles, and vehicles used to remove consequences of traffic accidents or traffic obstacles may enter this space. 9. When special warning lights of blue or blue and red color are flashing on a stopped vehicle, drivers of other vehicles must reduce their speed and possibly stop their vehicles according to circumstances. 10. It is prohibited to unlawfully use special warning lights and special audible warning signals used by vehicles with right-of-way, or to imitate them in road traffic. 11. Vehicles used by police, and marked according to special legal regulation. Vehicles used by the Fire Rescue Service of the Czech Republic, or fire protection units that are not part of the Fire Rescue Service. And vehicles of emergency medical service providers may be equipped with special warning lights of blue and red color. Section 42. Orange warning lights. 1. A driver of a vehicle equipped with special warning lights of orange color may use these lights only when their driving or work activity could endanger road traffic safety. If required by the work activity of such vehicle, its driver is not required to comply with traffic rules provisions listed in Section 4C. Section 7.1b, Section 11.2, Section 12.1, 2 and 4, Section 13, Section 14.1 and 2, Section 18.2b, Section 22.3, Section 24.4a, c, d, e, f, and g, Section 25.1, 2 and 3. Section 26.3, Section 27, Section 28.2, Section 30, 36, 37, and Section 39.4 and 5. However, they must exercise increased caution not to endanger road traffic safety. 2. Drivers of other vehicles must allow the vehicle according to paragraph 1 to drive or perform work activity and reduce their speed according to circumstances, possibly stop their vehicles. 3. Groups, columns, of vehicles of armed forces or armed corps may be escorted in front and behind by vehicles using special warning lights of orange color. Escorted vehicles must have clearance and low beam lights switched on. Division 3 Special Provisions for Vehicle Operation Section 43 Restrictions on driving certain vehicles. 1. On highways and Class I roads, the following vehicles are prohibited from driving: trucks, special purpose vehicles, and special vehicles with maximum permissible weight exceeding 500 kg trucks, special purpose vehicles, and special vehicles with maximum permissible weight exceeding 3,500 kg with attached trailer vehicles during a. Sundays and other non-working days in the period from 1:00 p.m. to 10:00 p.m. b. Saturdays from July 1 to August 31 in the period from 7:00 a.m. to 1:00 p.m. c. Fridays from July 1 to August 31 in the period from 5:00 p.m. to 9:00 p.m. 2. On Class I roads outside built-up areas from April 15 to September 30, special vehicles, towed vehicles, and hand carts wider than 600 mm are prohibited from driving during a. The last working day before Saturday or a non-working day from 3:00 p.m. to 9:00 p.m. b. The first non-working day and Saturday, if it follows a working day, from 7:00 a.m. to 11:00 a.m. c. The last non-working day from 3:00 p.m. to 9:00 p.m. 3. The driving prohibition according to paragraphs 1 and 2 does not apply to vehicles used for a. Combined transport of goods by rail or inland waterway and road from consignor to nearest combined transport terminal, or from nearest combined transport terminal to consignee. B. Necessary seasonal agricultural transport. C. Activities directly connected with ongoing maintenance, repairs, and construction of roads. D. Transport of goods subject to rapid deterioration. Provided such goods occupy or during transport occupied at least half the volume of the vehicles or combinations cargo space. E. Transport of live animals. F. Transport of fuel intended for continuous supply of fuel stations. G. Loading and unloading of aircraft, ships, or railway wagons within a distance not exceeding 100 km. H. Transport of postal items. I. Empty driving related to driving according to letters A to H, or driving following transport according to letter D, when transporting returnable deposit containers or waste from them. During such driving, transport aids may be in the vehicle. J. Natural disasters. K. Driving of vehicles of armed forces, armed corps, road traffic inspection, fire rescue service, or fire protection units. L. Transport of chemical substances subject to temperature changes or crystallization. M. Driver training. N. Removal of water, sewer, or energy facility emergencies for public use. 4. Paragraphs 1 and 2 do not apply to vehicles equipped with special lighting equipment of blue or blue and red color and special audible warning signals. 5. The locally competent regional authority may grant an exception from the driving prohibition according to paragraphs 1 and 2 for reasons deserving special consideration. The Ministry grants exceptions exceeding regional competence. Permits must be time-limited for a maximum period of 1 year. 6. The Ministry may establish an exception from the prohibition according to paragraph 1 by a measure of general nature for reasons of state security, protection of life, health, or property, or extraordinary events, or removal of their consequences, for a maximum period of 3 months. The draft measure of general nature is not published, and no comments or objections are submitted. The measure of general nature becomes effective on the day of posting the public notice. The Ministry immediately informs the police about issuing the measure of general nature. 7. A legal regulation specifies the requirements for applications for exception permits according to paragraph 5. Section 43. A vehicle weights and dimensions. 1. A motor vehicle driver must not use a vehicle whose weight, dimensions including load or weight distribution on axles, axle groups, wheels, or wheel groups endangers road traffic safety or the condition of the road, unless its use is enabled by procedures according to a special legal regulation. 2. A driver must not use a vehicle combination if a. Its weight or dimensions including load endanger road traffic safety or road condition, unless its use is enabled by procedures according to a special legal regulation. B. The weight or dimensions of individual vehicles including load, weight ratio of individual vehicles, or weight distribution on axles, axle groups, wheels, or wheel groups endanger road traffic safety or road condition, unless its use is enabled by procedures according to a special legal regulation. Or C. The coupling of vehicles endangers road traffic safety. 3. A driver of a motor vehicle of category M2, M3, N2, N3 or vehicle combination consisting of such vehicle and trailer vehicle of category O must have with them, while driving, a vehicle registration certificate or other official document stating vehicle dimensions, unless these data are indicated on a plate attached to the vehicle. 4. If a vehicle is equipped with foldable or removable equipment for reducing aerodynamic resistance, its use must not endanger road traffic safety. 5. A vehicle operator must not order or allow use of a vehicle in cases according to paragraph 1 or 2, unless its use is enabled by procedures according to a special legal regulation. 6. Values of weights and dimensions of vehicles and vehicle combinations, weight ratios of vehicles in combinations, weight distribution on axles, axle groups, wheels and wheel groups, whose non-compliance endangers road traffic safety or road condition, conditions for vehicle coupling in combinations, and use of foldable or removable equipment for reducing aerodynamic resistance, whose non-compliance endangers road traffic safety. And the scope of data stated in vehicle dimension documents are specified by implementing legal regulation. Section 44. Fuel dispensing. 1. In fuel station areas, both drivers and passengers are prohibited from smoking, handling open flames, and adjusting or repairing vehicle engines. Before fuel dispensing, drivers must stop the engine and turn off ignition. If independent heating is used for vehicle heating, drivers must turn it off before arriving at the fuel station. 2. Drivers of vehicles with right-of-way have priority in fuel dispensing. They do not use special warning signals in this case. Section 45. Traffic obstacles. 1. Anyone who causes a traffic obstacle must remove it immediately. If they fail to do so, the road owner removes it at their expense. 2. If a traffic obstacle cannot be removed immediately, its originator must mark it and report it to police. 3. A traffic obstacle must be marked so that other road traffic participants can notice it in time and from sufficient distance. For example, with a red flag, traffic device, barrier for marking closures, direction board, mobile closure board, or vehicle equipped with special warning lights of orange, blue, or blue and red color. During reduced visibility, traffic devices must be supplemented with yellow warning lights. For marking motor vehicles required to carry portable warning triangles, Section 26(3) applies, and for marking vehicles during reduced visibility, Section 33(2) also applies. 4. If the traffic obstacle is a vehicle, a police officer or municipal police officer decides on its removal according to Section 45(4), and on highways, one of the persons mentioned in paragraph 1 ensures vehicle removal upon police request. The vehicle is removed at the operator's expense. 5. If the traffic obstacle is a road condition defect where the technical condition does not allow further safe driving, a police officer is authorized to prohibit further vehicle driving until the defect is removed, and prohibit other vehicles from entering such road or section. 6. Details about marking traffic obstacles are specified by implementing legal regulation. Section 46 Vehicle stopping in tunnels. 1. If a vehicle breakdown occurs while driving in a tunnel making the vehicle immobile, or if a traffic accident occurs, the driver must immediately A. Turn off the engine, and if independent heating is used for vehicle heating, also turn off this heating. B. Take appropriate measures so that road traffic safety in the tunnel is not endangered. If circumstances require, they are authorized to stop other vehicles. C. Report the vehicle stopping or standing to police or persons supervising tunnel operation. 2. In cases mentioned in paragraph 1, neither drivers nor passengers may smoke or handle open flames. 3. Passengers in vehicles are required in cases mentioned in paragraph 1 to leave the vehicle and gather in designated places, or leave the tunnel. Section 47 Traffic Accidents. 1. A traffic accident is an event in road traffic, such as a crash or collision, that occurred or began on a road and resulted in death or injury to a person or property damage directly related to vehicle operation in motion. 2. A driver involved in a traffic accident is required to A. Stop the vehicle immediately. B. Refrain from consuming alcoholic beverages and using other addictive substances after the accident. For the time, it would be detrimental to determining whether they consumed alcoholic beverages or used other addictive substances before or during driving, but always until police arrival if accident participants are required to report the accident to police according to paragraphs 4 and 5. C. Take measures to prevent damage to persons or property if such danger exists as a result of the traffic accident. And D. Cooperate in establishing the factual situation. 3. Traffic accident participants are required to A. Take appropriate measures so that road traffic safety at the accident site is not endangered. If circumstances require, they are authorized to stop other vehicles. B. Report the accident to police in cases established by this law. If injury occurred, provide first aid according to their abilities and call emergency medical services for the injured person. C. Mark the accident site. D. Enable restoration of road traffic, especially public transport services. E. Immediately report to police any damage to roads, public facilities, or environment that occurred during the traffic accident. F. Mutually prove their identity upon request and provide information about vehicles involved in the traffic accident. G. In cases where there is no obligation to report the accident to police, prepare and sign a joint accident record that must contain determination of place, date and time of the traffic accident, its cause, course and consequences, identification data of participants and vehicles, and a sketch or photo documentation of the accident site. The joint accident record may also be prepared by remote access through user interface established by the Czech Insurance Bureau. 4. If a traffic accident results in death or injury to a person or property damage apparently exceeding 200,000 CZK on any of the involved vehicles including transported items, accident participants are required to A. Immediately report the traffic accident to police. B. Refrain from actions that would be detrimental to proper accident investigation, particularly moving vehicles. However, if the accident situation must be changed, especially if necessary to rescue or treat an injured person or restore road traffic, particularly public transport services. Mark the situation and traces. C. Remain at the accident site until police arrival or immediately return to this site after providing or calling for help or reporting the accident. 5. The obligation according to paragraph 4 also applies when a traffic accident A. Causes property damage to a third party, except damage to a vehicle whose driver was involved in the accident or damage to items transported in such vehicle. B. Results in damage or destruction of road components or accessories according to the Roads Act. Or C. Accident participants cannot themselves restore traffic flow without disproportionate effort. Section 47. A prohibition of participation in certain events in road traffic. A driver may not use a vehicle on highways, roads, and local roads to participate in sporting and similar events that could endanger road traffic safety, unless they are events organized in accordance with a decision of the competent administrative authority on special road use, according to other legal regulations. Division 4, Transport of Persons and Cargo, Section 48, Transport of Persons. 1. A driver must not allow the number of transported persons over 12 years old to exceed the number of authorized seats for transporting persons. 2. In a motor vehicle or its trailer designed for transporting persons, people may be transported only in authorized seats and only up to the permissible payload. But the number of persons over 12 years old must not exceed the number of authorized seats. 3. Paragraph 2 also applies to transporting persons in the driver's cab of a truck or special vehicle. 4. Persons under 15 years old must not be transported in special motor vehicles. 5. Transporting persons in other trailers than those designed for person transport is prohibited, except in cases according to Section 51. 6. Paragraphs 1 and 2 do not apply to transporting injured and otherwise health-endangered persons in approved mobile rescue equipment designed for evacuating injured and health-endangered persons from exposed terrain, transported in Mountain Rescue Service rescue vehicles and necessary rescue personnel transport. Paragraph 5 does not apply to Mountain Rescue Service trailers when transporting rescued persons. Section 49, Transport of Persons by Public Transport Vehicles. 1. A person waiting at a public transport stop, boarding such vehicle, being transported in it, or alighting from it must behave so as not to endanger road traffic safety. 2. A person waiting at a public transport stop may enter the roadway at a stop without a boarding island or platform on an elevated tram track, only after the public transport vehicle has stopped at the stop. 3. In cases mentioned in paragraphs 1 and 2, the person is required to follow instructions of the transport operator. 4. When operational or other serious reasons require persons alighting from or boarding public transport vehicles outside stops to enter the roadway, the transport operator is authorized to stop other vehicles. Section 50, Transport of Persons by Taxi Vehicles. 1. The authorization according to Section 49(4) applies analogously to taxi drivers with vehicles marked by roof lights according to special legal regulation. 2. Persons boarding and alighting from taxi vehicles are required to follow instructions of the taxi driver. Section 51, Transport of Persons in Truck Cargo Areas and Tractor-Trailer Cargo Areas. 1. transporting persons in truck cargo areas and tractor-trailer cargo areas is prohibited. 2. Paragraph 1 does not apply to transporting fire rescue service members, fire protection unit members not part of the fire rescue service, armed forces and security corps personnel, military police officers and municipal police officers in performance of their duties, other persons performing civil protection tasks and during natural disasters, and students of military schools during practical instruction. 3. Persons transported according to paragraph 2 must sit in the truck cargo area or tractor-trailer cargo area on the floor, or on seats firmly attached to the floor. Transported persons must not lean out during travel, let objects protrude from the vehicle, or otherwise endanger road traffic safety. 4. Side panels of truck cargo areas and tractor-trailer cargo areas must be sufficiently high so transported persons do not fall out during travel. 5. Only drivers over 21 years old with at least 2 years' experience driving such vehicle type may drive trucks or tractors in whose cargo areas persons are transported according to paragraph 2. These conditions do not apply to armed forces vehicle drivers. 6. The prohibition of transporting persons in truck cargo areas does not apply to transporting injured and otherwise health-endangered persons in approved mobile transport equipment of Mountain Rescue Service, designed for evacuating injured and health-endangered persons from exposed terrain. Transported in cargo spaces of Mountain Rescue Service rescue vehicles and necessary rescue personnel transport. 5. A driving license issued for group also authorizes driving four-wheeled vehicles with engine power up to 15 kW and weight in unloaded state up to 400 kg. A driving license issued for Group A1 also authorizes driving four-wheeled vehicles with engine power up to 15 kW, weight in unloaded state up to 400 kg, and engine displacement up to 125 cm3. Section 52, Transport of Cargo. 1. Objects placed in a vehicle must be positioned so as not to restrict or endanger the driver or persons transported in the vehicle and not to obstruct the view from the driver's position. 2. When transporting cargo, the maximum permissible weight of the vehicle and the maximum permissible axle weight of the vehicle must not be exceeded. The cargo must be positioned and secured on the vehicle in such a way as to ensure the stability and controllability of the vehicle, and so as not to endanger traffic safety on roads, not to contaminate or damage the road, not to cause excessive noise, not to pollute the air, and not to cover prescribed lighting, reflectors and registration plates, state identification marks, and maximum permitted speed markings. This also applies to equipment used for securing and protecting cargo, such as tarpaulins, chains, or ropes. Objects that can be easily overlooked, such as individual rods or pipes, must not protrude sideways. 3. If cargo protrudes beyond the vehicle by more than 1 m at the front or rear, or if cargo protrudes from the side of a motor vehicle or vehicle combination beyond the outer edge of the outline lights by more than 400 mm, or from a non-motor vehicle beyond its edge by more than 400 mm. The protruding end of the cargo must be marked with a red flag of dimensions at least 300 x 300 mm, in reduced visibility at the front with a non-dazzling white light and white reflector, and at the rear with a red light and red reflector. Reflectors must not be triangular in shape and may be positioned no more than 1.5 m above the road surface. 4. When transporting agricultural products in non-reduced visibility, paragraph 2 regarding marking of cargo protruding sideways from the vehicle does not apply. In reduced visibility, lights, reflectors, or reflective plates shall be used. 5. When transporting live animals, the safety of the driver, transported persons and animals as well as road traffic safety must not be endangered. 6. When transporting bulk substrates, the cargo must be secured so as to prevent its spontaneous dispersal. 7. Loading and unloading of cargo on a road is permitted only when it cannot be done off the road. Cargo must be loaded and unloaded as quickly as possible, and in such a way that road traffic safety is not endangered. 8. The consignor is obliged to hand over cargo for transport in such a condition, and in such a manner that enables compliance with the requirements for loading, positioning, and securing cargo according to paragraphs 1, 2, and 7. 9. In the case of vehicles of category M2, M3, N2, N3, O3, O4, or vehicles of category T with a design speed exceeding 40 km/h, the inspection of cargo positioning, securing, or fastening according to paragraphs 1, 2, 5, or 6 may be combined with roadside technical inspection. In such cases, the result of the cargo positioning, securing, or fastening inspection shall be recorded in the document on the roadside technical inspection performed. 10. Additional conditions for cargo transport, including conditions for transporting dangerous goods, are set by special legal regulations. The method and scope of conducting inspections of cargo positioning, securing or fastening, and technical conditions for evaluating the results are set by implementing legal regulations. Section 5. Special provisions for walking, riding non-motor vehicles, riding animals and leading and driving animals walking. Section 53. 1. Pedestrians must primarily use sidewalks or pedestrian paths. A pedestrian carrying an object that could endanger traffic on the sidewalk shall use the right road shoulder or the right edge of the carriageway. 2. Other road traffic participants than pedestrians may not use sidewalks or pedestrian paths, unless otherwise provided in this law, or unless it concerns the use of sidewalks by vehicles of basic components of the integrated rescue system necessary for fulfilling tasks related to special duties, or by vehicles of the Road Traffic Inspectorate or municipal police in the performance of their duties. 3. Where there is no sidewalk or it is impassable, walking shall be on the left road shoulder, and where there is no shoulder or it is impassable, walking shall be as close as possible to the left edge of the carriageway. Pedestrians may walk on the shoulder or at the edge of the carriageway at most 2 abreast. In reduced visibility, increased traffic on roads, or in dangerous and blind sections, pedestrians may walk only in single file. 4. If a path for pedestrians and cyclists marked with the traffic sign "Path for pedestrians and cyclists" is established, the pedestrian must not endanger a cyclist riding on the path. 5. If a path for pedestrians and cyclists marked with the traffic sign "Path for pedestrians and cyclists" is established, on which a lane for pedestrians and a lane for cyclists are separated, the pedestrian is obliged to use only the lane designated for pedestrians. The pedestrian may use the lane designated for cyclists only when bypassing, entering and leaving the path for pedestrians and cyclists. While doing so, they must not endanger cyclists riding in the lane designated for cyclists. 6. A person moving with the help of a manual or motorized wheelchair for disabled persons must not endanger other pedestrians on the sidewalk or pedestrian path. If they cannot use the sidewalk, they may use the right shoulder or the right edge of the carriageway. 7. A person leading a bicycle or moped may use the sidewalk only if they do not endanger other pedestrians. Otherwise, they must use the right shoulder or the right edge of the carriageway. 8. A person moving on skis, roller skates, or similar sports equipment must not endanger other pedestrians on the sidewalk or pedestrian path. 9. When a pedestrian moves outside a built-up area in reduced visibility on a shoulder, or at the edge of the carriageway in a place that is not illuminated by public lighting, they are obliged to wear elements made of retroreflective material positioned so as to be visible to other road traffic participants. Section 54, 1. If there is a controlled intersection, pedestrian crossing, place for crossing the carriageway, overpass or underpass marked with traffic signs. Pedestrian crossing, underpass or overpass closer than 50 m the pedestrian must cross only at these places. On pedestrian crossings, one walks on the right. 2. Outside pedestrian crossings, it is permitted to cross the carriageway only perpendicular to its axis. Before entering the carriageway, the pedestrian must make sure they can cross the carriageway without endangering themselves or other road traffic participants. A pedestrian may cross the carriageway only if, considering the distance and speed of approaching vehicles, they do not force their drivers to suddenly change direction or speed. 3. Once a pedestrian steps onto a pedestrian crossing or carriageway, they must not stop or linger there without reason. A blind pedestrian signals their intention to cross the carriageway by waving a white walking stick in the direction of crossing. A pedestrian must not step onto a pedestrian crossing or carriageway if priority vehicles are approaching. If they are on a pedestrian crossing or carriageway, they must immediately clear the way for these vehicles to pass. A pedestrian must not step onto a pedestrian crossing or carriageway immediately in front of an approaching vehicle. A pedestrian must give way to trams. 4. A pedestrian must not overcome railings or other barriers on the carriageway. Section 55(1). Before a railway crossing, a pedestrian must be especially careful, particularly they must make sure they can safely cross the railway crossing. 2. A pedestrian must not enter a railway crossing in cases specified in Section 29 para. 1 letters A to E. 3. In cases specified in Section 29 para. 1 letters A, B, and C. A pedestrian may cross the railway crossing only if they received verbal consent from an authorized employee of the railway operator before the railway crossing. In this case, the pedestrian is obliged to follow the instructions of the authorized employee of the railway operator when crossing the railway crossing. The authorized employee of the railway operator is obliged to prove their identity with valid authorization from the railway operator upon request from the pedestrian. Section 56. Formation of pedestrians. 1. For an organized formation of pedestrians, for example members of armed forces, school youth or processions, the obligations of drivers according to Section 5 para. 1 letter B, Section 11 para. 1, Section 12 to 16, Section 20 to 24, Section 25 para. 1 and 2, Section 27, Section 28 para. 1, 2 and 5, Section 29 and 30 apply accordingly. 2. In reduced visibility, an organized formation of pedestrians must be marked at the front on both sides with non-dazzling white light, and at the rear on both sides with non-dazzling red light. Marking with lights may be replaced by clothing accessories with retroreflective material marking. 3. An organized formation of pedestrians must not march in unison on a bridge. 4. The leader of the formation, who can only be a person older than 15 years who is sufficiently capable, is responsible for complying with obligations according to paragraphs 1 to 3. 5. An organized formation of pedestrians walking at most in double file may walk on the sidewalk on the right side. While doing so, they do not need to be marked according to paragraph 2. 6. For an organized group of children who are not yet subject to compulsory school attendance, pedestrian provisions apply. 7. The leader of an organized formation of school youth, or an organized group of children who are not yet subject to compulsory school attendance, is authorized to stop vehicles when crossing the carriageway. 8. The design and method of using clothing accessories with retroreflective material marking are set by implementing legal regulations. Riding bicycles. Section 57. 1. If a bicycle lane for cyclists, reserved lane for cyclists, cycling path, or at a controlled intersection, a lane for cyclists and designated space for cyclists is established, the cyclist is obliged to use them in the given place and direction, unless this could endanger the safety or flow of road traffic. 2. On roads, bicycles are ridden at the right edge of the carriageway. If pedestrians are not endangered or restricted by this, they may ride on the right shoulder. For road traffic purposes, a bicycle also includes a scooter. 3. Cyclists may ride only individually in single file. 4. When vehicles are moving slowly or standing in line at the right edge of the carriageway. A cyclist riding in the same direction may overtake or bypass these vehicles from the right side along the right edge of the carriageway or shoulder, provided there is sufficient space to the right of the vehicles. While doing so, they must exercise increased caution. This does not apply if the vehicle is turning right and signaling a change of direction. 5. If a path for pedestrians and cyclists marked with the traffic sign "Path for pedestrians and cyclists" is established, the cyclist must not endanger pedestrians walking on the path. If at the place where the path for pedestrians and cyclists crosses another road, there is a combined pedestrian crossing and bicycle crossing, the provisions regulating the behavior of these road traffic participants at pedestrian crossings and bicycle crossings apply accordingly to the individual road traffic participants in relation to this combined pedestrian crossing and bicycle crossing. 6. If a path for pedestrians and cyclists marked with the traffic sign "Path for pedestrians and cyclists" is established, on which a lane for pedestrians and a lane for cyclists are separated, the cyclist is obliged to use only the lane designated for cyclists. The cyclist may use the lane designated for pedestrians only when bypassing, overtaking, turning, changing direction, and entering the path for pedestrians and cyclists. While doing so, they must not endanger pedestrians walking in the lane designated for pedestrians. 7. A reserved bicycle lane for cyclists or cycling path may also be used by a person moving on skis or roller skates or similar sports equipment. While doing so, this person is obliged to follow the rules according to paragraphs 2, 3, 5, and 6, and traffic light signals according to section 73. 8. Before entering a bicycle crossing, the cyclist must make sure they can cross the carriageway without endangering themselves or other road traffic participants. The cyclist may cross the carriageway only if, considering the distance and speed of approaching vehicles, they do not force their drivers to suddenly change direction or speed. On bicycle crossings, one rides on the right. Section 58. 1. A person under 18 years riding or being transported on a bicycle is obliged to use a protective helmet of approved type according to special legal regulations, and have it properly fitted and fastened on their head. 2. A child under 10 years may ride a bicycle on roads, local roads, and publicly accessible purpose-built roads only under supervision of a person older than 15 years. This does not apply to riding on sidewalks, cycling paths, and in residential, pedestrian, and shared zones. 3. It is not permitted to ride 2 people on a single-seat bicycle. However, if the bicycle is equipped with an auxiliary seat for transporting children and fixed footrests, a person older than 15 years may carry a person younger than 7 years. A person older than 18 years may carry at most 2 children younger than 10 years in a trailer designed for transporting children that meets technical conditions set by special regulations, or a child on a children's bicycle attached to the bicycle by a connecting rod. 4. A cyclist must not ride without holding the handlebars, hold onto another vehicle, lead another bicycle, hand cart, dog, or other animal while riding, or carry objects that would make steering the bicycle difficult or endanger other road traffic participants. While riding, the cyclist must have their feet on the pedals. 5. A cyclist is obliged to have a headlight with white light shining forward and a rear light with red light or flashing red light on while riding in reduced visibility. If the carriageway is sufficiently and continuously illuminated, the cyclist may use a white light with flashing light instead of a headlight. 6. A bicycle trailer may be attached to a bicycle if it is not wider than 900 mm, has 2 red non-triangular reflectors at the rear, positioned as close as possible to the side outlines of the trailer, and is connected to the bicycle by a fixed coupling device. If the trailer or its load covers the rear red outline light of the bicycle in reduced visibility, the trailer must be equipped with a red non-dazzling light on the left side of the rear. If children are being transported in the trailer must be marked with a yellow or orange flag or plate measuring 300 x 300 mm, erected at a height of 1200–1600 mm above road level. Section 59. Riding animal-drawn vehicles and hand carts. 1. A driver may only be a person older than 15 years. 2. If the driver is not riding on the animal-drawn vehicle, they must walk on its right side while the animal-drawn vehicle is moving. Before leaving the animal-drawn vehicle, the driver must brake the vehicle, release the inner reins, and chock the wheels on slopes. 3. From November 1 to March 31, and in reduced visibility from April 1 to October 31, the animal-drawn vehicle must be marked at the front with at least one non-dazzling white light on the left side, and at the rear with at least one non-dazzling red light on the left side. 4. A person pulling or pushing a hand cart with a total width greater than 600 mm must walk at the right edge of the carriageway. If pedestrians are not endangered or restricted by this, they may walk on the right shoulder. In reduced visibility, this person or the cart must be marked on the left side with a non-dazzling white light. 5. On Class I and Roman II roads, riding with animal-drawn vehicles and with hand carts mentioned in paragraph 4 is prohibited from 23:00 to 4 o'clock. Section 60. Riding animals and leading and driving animals. 1. For riders on animals and for guides of led or driven animals, the obligations of drivers according to Section 5 para. 1. Letters B, D, F, and G, Section 11 para. 1. Section 12 to 17, Section 20 to 24, Section 25 para. 1 and 2, Section 27, Section 28 para. 1, 2, 4, and 5, Section 29, 30, Section 41 para. 7 and Section 42 para. 2 apply accordingly. 2. If a lane for riders on animals or path for riders on animals marked with the traffic sign "Path for Riders on Animals" is established, the rider on an animal must use this lane or path. 3. Other road traffic participants may not use the lane for riders on animals or path for riders on animals. 4. On the carriageway, the rider on an animal must ride at the right edge of the carriageway. If pedestrians are not endangered or restricted by this, they may ride on the right shoulder. 5. On roads, local roads, and publicly accessible purpose-built roads, only a rider older than 15 years may ride an animal. A person older than 12 years may ride an animal on roads, local roads, and publicly accessible purpose-built roads only under supervision of a person older than 15 years. Riders on animals may ride only individually in single file. A rider may lead only one animal. 6. A guide of led or driven animals must be a person older than 15 years. If road traffic safety requires it, the guide of led or driven animals is authorized to stop vehicles when accompanying animals. 7. Animals may be led or driven only at walking speed, and only in such a way that road traffic is not endangered, and is restricted as little as possible. 8. Driven animals in herds must be accompanied by the necessary number of guides of driven animals, and must be divided into appropriately long groups separated from each other by sufficiently large gaps. 9. A guide of led animals may lead at most 2 animals, which must be harnessed together. 10. In reduced visibility, the rider on an animal must be marked on the left side with a non-dazzling white light visible from the front, and a red non-dazzling light visible from the rear. Guides of led and driven animals must be marked with a non-dazzling white light in reduced visibility. From dusk to dawn, it is prohibited to use Class I or Roman II roads for riding animals and leading animals. 11. The owner or keeper of domestic animals is obliged to prevent these animals from running around on roads. Section 60. A use of personal transportation devices. 1. on personal transportation devices with self-balancing equipment or similar technical equipment. Hereinafter, personal transportation device. One may move on sidewalks, pedestrian paths, paths for pedestrians and cyclists, or on the separated pedestrian lane on paths for pedestrians and cyclists, or in pedestrian, residential, and shared zones at a speed at most comparable to walking speed. For crossing carriageways on a personal transportation device, Section 54 para. 2 to 4 apply accordingly. This does not apply in shared zones. If there is a controlled intersection or pedestrian crossing closer than 50 m, a person on a personal transportation device may cross the carriageway only at these places. For crossing railway crossings on a personal transportation device, Section 55 applies accordingly. 2. For the use of bicycle lanes reserved for cyclists, cycling paths or separated bicycle lanes on paths for pedestrians and cyclists by a person on a personal transportation device, Section 57 para. 2, 3 and 8 and Section 73 apply accordingly. 3. Where there is no sidewalk, pedestrian path, path for pedestrians and cyclists, bicycle lane reserved for cyclists or cycling path, or where the sidewalk is impassable. A person on a personal transportation device may move on the left shoulder or as close as possible to the left edge of the carriageway. Persons on personal transportation devices may move in such cases only individually in single file, Section 53 para. 9 applies accordingly. In shared zones, a person on a personal transportation device may move across the full width of the road. If a priority vehicle is approaching, they must immediately clear the way for this vehicle to pass. 4. A person on a personal transportation device must not endanger pedestrians or cyclists on sidewalks, pedestrian paths, paths for pedestrians and cyclists, bicycle lanes reserved for cyclists or cycling paths, or in pedestrian, residential, and shared zones. When crossing carriageways on a personal transportation device, Section 5 para. 2 letters F to H apply accordingly. 5. A municipality may, by regulation, designate places in its territory where operating personal transportation devices on sidewalks, pedestrian paths, paths for pedestrians and cyclists, on separated pedestrian lanes on paths for pedestrians and cyclists, in pedestrian, residential and shared zones or on carriageways, is prohibited. 6. In case of designating territory where operating personal transportation devices on sidewalks, pedestrian paths, paths for pedestrians and cyclists, on separated pedestrian lanes on paths for pedestrians and cyclists, in pedestrian, residential, and shared zones, or on carriageways is prohibited. The municipality is obliged to mark the territory with a traffic sign. 7. The prohibition on operating personal transportation devices imposed by municipal regulation does not apply to the police of the Czech Republic and municipal police in the performance of their duties. However, the person using the personal transportation device is obliged not to endanger safety and flow on roads. Section 4 Traffic Regulation and Control on Roads, Section 1 Traffic Regulation on Roads, Section 61 General, Local and Temporary Traffic Regulation on Roads. 1. General traffic regulation on roads is established by this law. 2. Local traffic regulation on roads is traffic regulation on roads implemented by traffic signs, light signals, possibly also accompanying acoustic signals, or traffic devices. 3. Temporary traffic regulation on roads is traffic regulation on roads implemented by portable vertical traffic signs, temporary horizontal traffic signs, light signals, and traffic devices. 4. Temporary traffic regulation on roads and the use of operational information devices for selected or repeated activities connected with road management, maintenance, measurement, repairs, or construction, or to ensure road traffic safety may be established by general schemes. The validity of a general scheme must be time-limited for no more than 1 year, Section 62 Traffic Signs. 1. Traffic signs are distinguished as vertical and horizontal. 2. Vertical traffic signs are permanent, variable, and portable. A variable vertical traffic sign is a traffic sign whose active surface can change. A portable vertical traffic sign means a traffic sign placed on a red and white striped post, stand, or on a vehicle. 3. Horizontal traffic signs are permanent and temporary. Horizontal traffic signs may be supplemented with road studs. 4. The shapes of traffic sign symbols must not be changed. This does not apply to traffic signs with symbols that can be reversed, and symbols that are listed only as examples, and to variable vertical traffic signs. 5. Implementing legal regulations establish the meaning, use, design, and shapes of traffic signs and their symbols. 6. Traffic signs, light and acoustic signals, traffic devices, and operational information devices must correspond to special technical regulations in their dimensions, colors, and technical requirements. Section 63 Vertical traffic signs. 1. Vertical traffic signs are a. Warning signs which alert to places where road traffic participants face danger and where they must exercise increased caution. B. Priority signs which establish priority in traffic on roads. C. Prohibition signs which impose prohibitions or restrictions on road traffic participants. D. Mandatory signs which impose commands on road traffic participants. E. Information signs which provide road traffic participants with necessary information, serve for their orientation, or impose obligations established by this law or special legal regulations. F. Additional plates which specify, supplement, or limit the meaning of the traffic sign under which they are placed. 2. Implementing legal regulations establish details of information sign classification. Section 64 Horizontal traffic signs. Horizontal traffic signs are used independently or in connection with vertical traffic signs, possibly with traffic devices, whose meaning they emphasize or specify. Horizontal traffic signs are marked with paint or other understandable methods. Temporary changes in local traffic regulation on roads are marked in yellow or orange. Section 65 Light signals, accompanying acoustic signals and warning lights. 1. Light signals, possibly also accompanying acoustic signals, are used to control road traffic or to alert to the need for increased caution. 2. The design and shapes of light signal symbols and the character of acoustic signals executed according to implementing legal regulations must not be changed. This does not apply to light signals with symbols that can be reversed and symbols that are listed only as examples. Accompanying acoustic signals used for road traffic control must not be used for other purposes. 3. Implementing legal regulations establish the types, meaning, use, design, and shapes of light and acoustic signal symbols. 4. Light signals must correspond to special technical regulations in their dimensions, colors, and technical requirements. Section 66 Traffic devices. 1. Traffic devices supplement traffic signs and light and acoustic signals, direct road traffic, and protect road traffic participants. 2. The design and shapes of traffic device symbols executed according to implementing legal regulations must not be changed. This does not apply to traffic devices with symbols that can be reversed and symbols that are listed only as examples. 3. Implementing legal regulations establish the types, meaning, use, design, and shapes of traffic devices. 4. Traffic devices must correspond to special technical regulations in their dimensions, colors, and technical requirements. Section 67 Special vehicle and person markings. 1. Parking permits marking vehicles transporting severely disabled persons, hereinafter parking permits for persons with disabilities. Markings for vehicles driven by hearing-impaired persons, hereinafter O2 marking. Markings for vehicles of doctors making house calls. Markings for vehicles of home health care providers, or markings for vehicles of outreach social service providers, may only be used by persons who receive such markings from the competent municipal office with extended competence, or from an authorized foreign authority. 2. Parking permits for persons with disabilities are issued by the competent municipal office with extended competence to persons who hold a ZTP card, except for those disabled by complete or practical deafness, or hold a ZTP/P card according to other legal regulations. 3. O2 marking is issued by the competent municipal office with extended competence to holders of driving licenses who hold a ZTP card due to complete or practical deafness disability. 4. A vehicle may be marked with a parking permit for persons with disabilities only if the vehicle is driven by or transports a person who holds a parking permit for persons with disabilities, according to paragraph 1. The transported person is obliged to prove upon request by a police officer or municipal police officer that they hold a ZTP or ZTP/P card according to other legal regulations that entitles them to use a vehicle marked with a parking permit for persons with disabilities. 5. In individual cases, and when urgently necessary, drivers of motor vehicles marked with parking permits for persons with disabilities, doctors making house calls, and drivers of vehicles of home health care providers or outreach social service providers according to paragraph 1 need not comply with parking prohibitions and parking prohibitions resulting from the traffic sign, "No stopping," for the time strictly necessary. While doing so, road traffic safety and flow must not be endangered. 6. In individual cases and when urgently necessary, vehicles marked with parking permits for persons with disabilities may enter even where there is a no entry sign limited by additional plates. Deliveries only, except deliveries. Service vehicles only and except service vehicles. 7. In individual cases and when urgently necessary, vehicles marked with parking permits for persons with disabilities may enter areas marked with the traffic sign pedestrian zone. 8. On parking spaces reserved for vehicles marked with parking permits for persons with disabilities, stopping and parking is prohibited for vehicles without such marking. 9. The road authority may, upon application by a person who has been issued a parking permit for persons with disabilities, issue a decision on establishing a reserved parking space at the place of residence according to other legal regulations. The road administrative authority exercises supervision over the proper use of reserved parking spaces according to other legal regulations. 10. For their marking as road traffic participants, blind persons use white canes and deaf-blind persons use red and white canes. 11. Implementing legal regulations establish the types, designs, and execution of special vehicle and person markings. Section 68. Operational Information Devices. 1. Operational information devices provide current data that is significant for road traffic safety and flow, for example accidents, smog, travel time to a designated destination, directions to park and ride facilities, road or air temperature. 2. The design and shapes of operational information device symbols may be changed. This does not apply if traffic sign, light signal, or traffic device symbols are used on operational information boards. Section 62, para. 4 is not affected by this. 3. Implementing legal regulations establish the meaning, use, design, and shapes of symbols intended for use on operational information devices. 4. Operational information devices must correspond to special technical regulations in their dimensions, colors, and technical requirements. Section 2, Section 69 Road Traffic Control. Road traffic is controlled by light signals, possibly also accompanying acoustic signals, or by instructions from police officers or persons authorized to control or direct road traffic according to Section 75 para. 5, 8, 9, or 10 or special legal regulations. Traffic control by light signals. Section 70, 1. When controlling traffic at intersections, 3 color systems with solid signals or directional signals are used. 2. When controlling traffic at intersections for drivers. A signal with red light, stop, means the obligation to stop the vehicle before the traffic sign, continuous transverse line with give way symbol, and continuous transverse line with stop inscription. And where there is no such traffic sign before the light signaling device. B. A signal with simultaneous red and yellow light, attention, means the obligation to prepare to drive. C. A signal with green solid circular light, clear, means the possibility to continue driving, and if observing turning provisions, may turn right or left, while giving way to pedestrians crossing in the clear direction at pedestrian crossings and cyclists crossing in the clear direction at bicycle crossings. If the signal for leaving intersection located in the opposite corner of the intersection is lit, section 21 para. 5 does not apply to turning left. D. A signal with yellow light, attention, means the obligation to stop the vehicle before the traffic sign, continuous transverse line with give way symbol, and continuous transverse line with stop inscription, and where there is no such traffic sign before the light signaling device. However, if this vehicle is already so close when this signal lights up that the driver could not safely stop the vehicle, they may continue driving. If the light of this signal flashes, it is not an intersection with traffic controlled by light signals. E. A signal with green directional arrow or arrows, for example, signal for straight direction, combined signal for straight direction and right turn, means the possibility to continue driving only in the direction shown by the arrow or arrows. If the green arrow points left, section 21 para. 5 does not apply to turning left. F. Signals, yellow pedestrian-shaped light signal, yellow cyclist-shaped light signal, or yellow pedestrian and cyclist-shaped light signal, which supplement a signal with a green arrow pointing right or left, alert the driver that when driving in the direction shown by this arrow, they cross the walking direction of crossing pedestrians, the riding direction of crossing cyclists, or the walking direction of crossing pedestrians and riding direction of crossing cyclists. G. The signal, additional green arrow, lit simultaneously with the signal with red light, stop, or yellow light, attention, means the possibility to continue driving only in the direction shown by the arrow or arrows. While doing so, the driver must give way to vehicles and riders on animals driving in the clear direction and pedestrian formations walking in the clear direction. While doing so, they must not endanger or restrict crossing pedestrians. 3. When controlling traffic outside intersections, for example before pedestrian crossings or before blind spots, paragraph 2 applies accordingly, section 71. 1. When using the signal, speed signal with variable signal mark or speed signal with multiple signal marks, the lit number indicates the recommended speed in km/h. 2. If the signal, prohibited vehicle entry into lane, lights up above a lane, the driver must not use this lane. If the signal, free vehicle entry into lane, lights up above a lane, the driver may use this lane. 3. If the signal, light arrow left or light arrow right, lights up, the driver must leave the lane or bypass the obstacle in the indicated direction. 4. When controlling traffic at road closures, during work on roads or for other reasons, portable 3-color or 2-color signaling devices with solid circular lights are used. Section 70 para. 2 applies accordingly. 5. In special cases, for example to secure tram entry onto roads, the signal stop is used, preceded by the signal attention. The driver must stop before the traffic sign, continuous transverse line with give way symbol, and continuous transverse line with stop inscription, and where there is no such traffic sign, before the light signaling device. 6. A signal of 2 side-by-side alternately flashing red lights means for the driver the obligation to stop the vehicle before the light signaling device. 7. If the light signaling device is not equipped with an attention signal, section 70 para. 2 letter D, first sentence applies accordingly when the signal to stop the vehicle lights up. 8. The signal, flashing yellow light, used alone alerts the driver to the need for increased caution. 9. The signal, flashing yellow light, used together with a traffic sign or traffic device, emphasizes the meaning of the traffic sign or traffic device. Section 72. Tram traffic is controlled by light signaling devices with signals for trams. These signals may also be used on lanes reserved for city public transport buses or trolleybuses. Section 73. 1. If a light signaling device with light signals, cyclist signal with stop sign, cyclist signal with attention sign, cyclist signal with clear sign, cyclist signal with green directional arrow or arrows, or cyclist signal additional green arrow is installed on a cycling path or bicycle lane, section 70 para. 2 letters A to E and G apply accordingly. This also applies when a signal with solid circular lights is supplemented with a white plate depicting a bicycle. 2. If cyclist signals are placed beyond the road, the signal means A. Cyclist signal with stop sign, that the cyclist must not enter the carriageway. B. Cyclist signal with stop sign, together with the signal cyclist signal with attention sign, that the cyclist is obliged to prepare to ride. C. Cyclist signal with clear sign, that the cyclist may cross the carriageway if the signal cyclist signal with attention sign then lights up, they may complete the crossing to the light signaling device with this signal. 3. Where light signaling devices for cyclists are equipped with a button for cyclists, the cyclist may enter the carriageway after pressing the button only upon the signal cyclist signal with clear sign. Section 74. 1. For pedestrians, these 2 color system signals are used, possibly also with accompanying acoustic signals, which mean A. Pedestrian signal with clear sign, that the pedestrian may cross the carriageway if the signal pedestrian signal with stop sign then lights up, the pedestrian may complete crossing to the light signaling device with this signal. B. Pedestrian signal with stop sign, that the pedestrian must not enter the carriageway. 2. Where light signaling devices for pedestrians are equipped with a button for pedestrians, the pedestrian may enter the carriageway after pressing the button only upon the signal pedestrian signal with clear sign. Section 75. Traffic control by police instructions. 1. A police officer controls road traffic by changing posture and arm signals. While doing so, they usually use a baton held in the right hand. Their instructions mean for drivers and pedestrians: A. Stop, for the direction the police officer faces or has their back to. The driver is obliged to stop the vehicle. B. Attention, if the police officer raises their arm or forearm of the right arm with the baton. A driver coming from the direction for which traffic was previously stopped is obliged to prepare to drive. A driver going in the previously clear direction is obliged to stop the vehicle. However, if they are already so close that they could not safely stop the vehicle, they may continue driving. C. Clear, for the direction the police officer stands sideways to. The driver may continue driving, and if observing turning provisions, may turn right or left. D. If the police officer has the right arm extended forward and left arm raised, this means stop. For the driver approaching toward the police officer's back and right side, and clear. For the driver approaching toward the police officer's left side, the driver approaching toward the back and right side of the police officer is obliged to stop the vehicle. The driver approaching the left side of the police officer may continue driving, and if observing turning provisions, may turn right or left. The driver approaching toward the front of the police officer may only turn right. Pedestrians may cross the carriageway only behind the police officer. 2. When the driver stops during traffic control according to paragraph 1 letters A, B, and D, at an intersection, they are obliged to stop before the intersection boundary. 3. During stop and clear instructions, the police officer may raise both arms or one arm. They may lower both arms if posture is sufficient for traffic control. This does not apply to the instruction in paragraph 1 letter D. 4. During traffic control, the police officer may give other instructions besides those in paragraph 1, for example, speed up, by horizontal arm waving across the body, or slow down, by waving the arm up and down. To emphasize their instruction, the police officer may use whistle signals. 5. Paragraphs 1 to 4 also apply to road traffic control by military police officers and members of military order service, who use batons or stop signs when controlling road traffic. 6. Upon request, a member of military order service controlling road traffic is obliged to prove their identity to a police officer or military police officer with valid authorization for road traffic control. 7. The equipment and marking of military order service members controlling road traffic, the design of batons and stop signs, the form and content of authorization for road traffic control according to paragraph 6, and the design of traffic control instructions according to paragraphs 1 and 4 are established by implementing legal regulations. 8. Municipal police officers are authorized to direct road traffic with instructions when this is necessary to restore road traffic safety and flow, and traffic control is not provided by police or in cooperation with police. When directing traffic, municipal police officers use the instructions established for police traffic control. 9. Customs officers are authorized to direct road traffic with instructions when this is necessary to restore road traffic safety and flow, and traffic control is not provided by police. When directing traffic, customs officers use the instructions established for police traffic control. 10. Members of the Fire Rescue Service of the Czech Republic, in service uniform with markings of affiliation to the Fire Rescue Service of the Czech Republic, are authorized to direct road traffic with instructions when this is necessary in connection with emergency response. And traffic control or direction is not provided by police or municipal police. When directing traffic, they use the instructions established for police traffic control. Fire Protection Unit members who are not part of the Fire Rescue Service of the Czech Republic have similar authorization when responding to emergencies. Section 3. Relationships between traffic regulations on roads, their establishment and use of traffic signs, light signals, traffic devices, and operational information. Section 76. Relationships between general, local, and temporary traffic regulation on roads. 1. Local traffic regulation on roads takes precedence over general traffic regulation on roads. Temporary traffic regulation on roads takes precedence over both local and general traffic regulation on roads. 2. Permanent vertical traffic signs take precedence over horizontal traffic signs. 3. Temporary horizontal traffic signs take precedence over permanent horizontal traffic signs. 4. Portable vertical traffic signs take precedence over all traffic signs. 5. Instructions given during traffic control or direction according to Section 75 take precedence over temporary, local, and general traffic regulation on roads. 6. Light signals take precedence over vertical traffic signs regulating priority. 7. If horizontal traffic signs, pedestrian crossing, bicycle crossing, bus or trolleybus stop, no stopping, no parking, or diagonal parallel lines are used, these horizontal traffic signs take precedence over vertical traffic signs parking or vertical traffic signs zone with traffic restriction, with symbols regulating stopping, parking, or parking areas at the place of use. Section 77. Local and temporary traffic regulation on highways, roads, local roads, and publicly accessible purpose-built roads. 1. Local and temporary traffic regulation on roads and use of operational information devices are established by A. On highways, the Ministry. B. On Class I roads, regional authorities. C. On Class Roman II and Roman III roads, local roads, and publicly accessible purpose-built roads, municipal offices with extended competence. D. Railway administrative authorities, regarding the use of traffic signs, single-track railway crossing warning cross, and multi-track railway crossing warning cross, light signal railway crossing protection signal, and tram signals on roads except purpose-built roads that are not publicly accessible. 2. Involved authorities when establishing local and temporary traffic regulation on roads and use of operational information devices are A. Ministry of the Interior, regarding highways. B. Police, regarding roads, local roads, and publicly accessible purpose-built roads. C. Railway administrative authorities, regarding the use of traffic signs stop, give way, before railway crossings and traffic signs, railway crossing with barriers, railway crossing without barriers, signal board, tram and give way to tram. D. Regional authorities, regarding establishment according to paragraph 1 letter D, on Class I roads, and E. Municipal offices with extended competence, regarding establishment according to paragraph 1 letter D, on Class Roman II and Roman III roads, local roads, and publicly accessible purpose-built roads. 3. The competent administrative authority shall discuss proposals for establishing local or temporary traffic regulation on roads, or use of operational information devices according to paragraph 1 with involved authorities. If an involved authority does not express its opinion within 30 days from the day the establishment proposal was delivered, it is considered to agree with the establishment proposal. 4. If there is imminent danger, the competent administrative authority may establish temporary traffic regulation on highways, roads, local roads, or publicly accessible purpose-built roads without discussion with involved authorities, and without prior proceedings on the general measure proposal, but for no more than 60 days. 5. The competent administrative authority establishes local and temporary traffic regulation on roads by general measure if it concerns light signals, mandatory and prohibition traffic signs, priority traffic signs and their additional plates, or other traffic signs imposing obligations on road traffic participants different from general traffic regulation on roads. The competent administrative authority publishes the general measure or its proposal on the official boards of municipal offices in municipalities, whose administrative districts are affected by the general measure only if the establishment of local or temporary traffic regulation on roads relates to traffic in the built-up area of the affected municipality, or if establishing local or temporary traffic regulation on roads may lead to increased traffic density in the built-up area of the affected municipality. Regarding temporary traffic regulation on roads, the competent administrative authority does not deliver the general measure proposal and does not call on affected persons to submit comments or objections. The general measure becomes effective on the 5th day after posting. 6. On publicly accessible purpose-built roads, local or temporary traffic regulation is established only upon proposal or with consent of the owner. This does not apply to establishing local or temporary regulation by general measure. 7. Exceptions to local and temporary traffic regulation on roads are granted upon application by the administrative authority that established the regulation. Police is an involved authority in the proceedings. An exception may be granted if the applicant demonstrates serious interest in granting it and it does not endanger road traffic safety or flow. There is no legal right to granting an exception. No exception can be granted from local and temporary regulation establishing maximum permitted speed. Section 77. A local and temporary traffic regulation on purpose-built roads that are not publicly accessible. 1. The owner of a purpose-built road that is not publicly accessible places local and temporary traffic regulation and operational information devices on it. The road owner reports the placement of local or temporary traffic regulation or operational information devices within 5 working days to the municipal office with extended competence. 2. The municipal office with extended competence orders removal of local or temporary traffic regulation or operational information devices if the safety condition according to Section 78 para. 2 is not met. For the purpose of assessing road traffic safety assurance, the municipal office with extended competence requests a police opinion. 3. A road traffic participant may deviate from local and temporary traffic regulation on a purpose-built road that is not publicly accessible based on prior consent from the purpose-built road owner, provided road traffic safety is not endangered. Section 78, Use of traffic signs, light signals, traffic devices, and operational information. 1. Traffic signs, light and acoustic signals, traffic devices, and operational information devices must form a unified system. 2. Traffic signs, light and acoustic signals, traffic devices, and operational information devices may be used only to the extent and in such a manner as necessarily required by road traffic safety and flow or other important public interest. 3. Portable vertical traffic signs, temporary horizontal traffic signs, light signals, traffic devices, and operational information devices may be used only for the necessary duration, and only for reasons stated in paragraph 2. 4. Variable vertical traffic signs are used especially in road traffic control systems that react to specific road traffic situations or weather conditions. 5. Implementing legal regulations establish the method and scope of using portable vertical traffic signs, temporary horizontal traffic signs, light signals, traffic devices, and operational information devices. 6. In the immediate vicinity of roads in built-up areas, it is prohibited to place anything that could be mistaken for a traffic sign, light and acoustic signal, traffic device, or traffic information device, or that could reduce their visibility, recognizability, or effectiveness. Dazzle road traffic participants or distract their attention in a way affecting road traffic safety. Section 4 Vehicle Stopping. Section 79 1. Authorized to stop vehicles are A. Police officers, B. Military police officers, C. Municipal police officers. 1. Before pedestrian crossings to ensure safe crossing by persons when the situation at the crossing or the condition of crossing persons requires it. 2. If the vehicle driver or transported person is suspected of committing an offense related to road traffic safety and flow. 3. When detecting offenses in taxi services according to the road transport law. D. Road traffic inspectors. E. Railway operator employees near railway crossings. F. Traffic accident participants when circumstances according to Section 47 require it. G. Carriers according to Section 49 para. 4. H. Leaders of organized school youth formations. Leaders of organized groups of children not yet subject to compulsory school attendance, and guides of disabled persons when crossing carriageways. I. Guides of led or driven animals according to Section 60 para. 6. J. Employees performing work connected with road management, maintenance, measurement, repairs, and construction, and for ensuring road traffic safety, marked according to implementing legal regulations. K. Persons authorized by municipal offices with extended competence to ensure safe crossing of children and school youth across roads near school facilities, hereinafter authorized persons. Authorized persons are obliged to be marked according to implementing legal regulations when performing activities. L. Customs officers when performing activities within the scope of authority established by special legal regulations. M. Members of the General Inspection of Security Corps with external marking according to special legal regulations. N. Those listed in permits for special road use consisting of organizing sports, cultural, religious, entertainment, or similar events according to the roads law. Who have reached 18 years of age. O. Those who, in accordance with special use permits or general measures, provide escort for oversized vehicles according to the roads law. 2. A vehicle is stopped by giving a signal to stop the vehicle. Persons listed in paragraph 1 give signals to stop vehicles with a raised arm or stop sign, and in reduced visibility with red light moved in the upper semicircle. From a moving vehicle, they give this signal by waving the arm up and down or with an extended stop sign. Police officers, military police officers, road traffic inspectors, customs officers, members of the General Inspection of Security Corps or municipal police officers, may stop vehicles from a moving vehicle by lighting the inscription "Stop," according to special legal regulations from the direction of travel of the stopped vehicle, both from front and rear. 3. Signals to stop vehicles must be given in time and clearly considering road traffic circumstances, so that the driver can safely stop the vehicle without endangering road traffic safety. 4. An authorized person can only be a person older than 18 years, who is sufficiently capable for the activity according to paragraph 1 letter K. 5. An authorized person must carry authorization issued by a municipal office with extended competence when performing activities according to paragraph 1 letter K. The authorization must be time-limited for no more than 1 year. Upon request, the authorized person is obliged to prove their identity to a police officer with valid authorization. 6. An authorized person may stop vehicles only at pedestrian crossings. Where there is no pedestrian crossing or it is impassable, they may stop vehicles at other places on the carriageway. 7. An authorized person may not stop vehicles near controlled intersections, including at pedestrian crossings. 8. Persons according to paragraph 1 letters N and O must carry a copy of the special use permit when exercising authorization and must be visibly marked. Upon request, this person is obliged to prove their identity to a police officer with a copy of the special use permit. 9. Implementing legal regulations establish the method of marking persons according to paragraph 1 letters J, K, N, and O, and the design of authorization according to paragraph 1 letter K. Section 79. A vehicle speed measurement to increase road traffic safety. Police and municipal police are authorized to measure vehicle speeds. Municipal police performs this activity exclusively at places designated by police, proceeding in cooperation with police. Title Roman III Driving Licenses and Driving Permits. Section 1 Driving Licenses. Section 80 Basic Provisions. A driving license authorizes its holder to drive motor vehicles classified in the vehicle group for which the driving license was issued. Section 80A Vehicle Groups. 1. Vehicle groups include A. AM includes 1. Two-wheeled motor vehicles with design speed exceeding 25 km/h and not exceeding 45 km/h, whose technical parameters correspond to Category L1E vehicle parameters according to directly applicable European Union regulations governing Category L vehicle approval. 2. Three-wheeled motor vehicles with design speed exceeding 25 km/h and not exceeding 45 km/h, whose technical parameters correspond to Category L2E vehicle parameters according to directly applicable European Union regulations governing Category L vehicle approval. And 3. Four-wheeled motor vehicles with design speed not exceeding 45 km/h, whose technical parameters correspond to Category L6E vehicle parameters according to directly applicable European Union regulations governing Category L vehicle approval. B. A1 includes 1. Light motorcycles with or without sidecars with power not exceeding 11 kW and power/weight ratio not exceeding 0.1 kW/kg and engine displacement not exceeding 125 cm. 2. Three-wheeled motor vehicles with power not exceeding 15 kW/c. A2 includes motorcycles with or without sidecars with engine power not exceeding 35 kW and power/weight ratio not exceeding 0.2 kW/kg which have not been modified for motorcycles with more than double the power D, includes 1. Motorcycles with or without sidecars. 2. Three-wheeled motor vehicles with power exceeding 15 kW. B1 includes four-wheeled motor vehicles whose technical parameters correspond to Category L7 vehicle parameters, according to directly applicable European Union regulations governing Category L vehicle approval. Except vehicles mentioned in letter A. F. B includes motor vehicles except those mentioned in letters A to E, whose maximum permissible weight does not exceed 3,500 kg, designed for transporting at most 8 persons besides the driver, to which may be attached a trailer with maximum permissible weight. 1. Not exceeding 750 kg. 2. Exceeding 750 kg, provided the maximum permissible weight of this combination does not exceed 3,500 kg, or 3. Exceeding 750 kg, provided the maximum permissible weight of this combination exceeds 3,500 kg, but does not exceed 4,250 kg, in case of extended scope driving license. G. C1 includes motor vehicles except tractors whose design speed is less than 80 km/h and vehicles mentioned in letter I, whose maximum permissible weight exceeds 3,500 kg, but does not exceed 7,500 kg, designed for transporting at most 8 persons besides the driver, to which may be attached a trailer with maximum permissible weight not exceeding 750 kg. C includes motor vehicles except tractors whose design speed is less than 80 km/h and vehicles mentioned in letters G and I, whose maximum permissible weight exceeds 3,500 kg, designed for transporting at most 8 persons besides the driver, to which may be attached a trailer with maximum permissible weight not exceeding 750 kg. D1 includes motor vehicles except those mentioned in letters A to F, designed for passenger transport with number not exceeding 16 besides the driver and length not exceeding 8 meters, to which may be attached a trailer with maximum permissible weight not exceeding 750 kg. J. D includes motor vehicles except those mentioned in letter I, designed for transporting more than 8 persons besides the driver, to which may be attached a trailer with maximum permissible weight not exceeding 750 kg. K. B plus E includes combinations of vehicles mentioned in letter F, and trailers with maximum permissible weight not exceeding 3,500 kg. L. C1 plus E includes combinations whose maximum permissible weight does not exceed 12,000 kg, composed of 1. Vehicles mentioned in letter G and trailers with maximum permissible weight exceeding 750 kg, or 2. Vehicles mentioned in letter F and trailers with maximum permissible weight exceeding 3,500 kg. M. C plus E includes combinations of vehicles mentioned in letter H and trailers with maximum permissible weight exceeding 750 kg. N. D1 plus E includes combinations of vehicles mentioned in letter I and trailers with maximum permissible weight exceeding 750 kg. O. D plus E includes combinations of vehicles mentioned in letter J and trailers with maximum permissible weight exceeding 750 kg. 2. Group T includes tractors, except tractors with maximum permissible weight exceeding 3,500 kg and design speed of 80 km/h or higher, and self-propelled work machines. Trailers may be attached to these vehicles. Section 81 Equivalence of driving licenses. 1. A driving license issued for Group A. A2 also authorizes driving vehicles classified in Group A1. B. Also authorizes driving vehicles classified in Groups A1 and A2. C. B also authorizes driving vehicles classified in Group A1 with automatic transmission and vehicles classified in Group B1. D. C also authorizes driving vehicles classified in Groups C1 and T. E. D also authorizes driving vehicles classified in Group D1. F. C plus E also authorizes driving vehicles classified in Groups B plus E and C1 plus E. G. D plus E also authorizes driving vehicles classified in Groups B plus E and D1 plus E. H. C1 plus E or D1 plus E also authorizes driving vehicles classified in Group B plus E. I. C plus E also authorizes driving vehicles classified in Group D plus E. If the holder has a driving license for Group D. 2. A driving license issued for any group except Group T also authorizes driving vehicles classified in Group AM. 3. A driving license issued for Group B authorizes the holder who has reached 21 years of age to also drive three-wheeled vehicles classified in Group A and snowmobiles. 4. A driving license issued for Group B to a person who has been its holder for at least 2 years also authorizes driving vehicles without trailers designed for cargo transport, whose maximum permissible weight exceeds 3,500 kg, but does not exceed 4,250 kg, provided a. The vehicles use at least partially as fuel or energy source electricity, hydrogen, compressed or liquefied natural gas including biomethane, liquefied petroleum gas or mechanical energy from an onboard storage or source, including waste heat. B. The weight exceeding 3,500 kg is caused exclusively by the weight of the propulsion system of the vehicle using fuel or energy source, according to letter A, compared to the weight of the propulsion system of a vehicle of the same dimensions that does not use such fuel or energy source. And C. The weight of transportable cargo in the vehicle using fuel or energy source, according to letter A, is not increased compared to the weight of transportable cargo in a vehicle of the same dimensions that does not use such fuel or energy source. 5. A driving license issued for Group also authorizes driving four-wheeled vehicles with engine power up to 15 kW and weight in unloaded state up to 400 kg. A driving license issued for Group A1 also authorizes driving four-wheeled vehicles with engine power up to 15 kW, weight in unloaded state up to 400 kg, and engine displacement up to 125 cm3. Section 82 Conditions for granting and holding driving licenses. 1. A driving license may be granted only to a person who A. Has reached the age established by this law. B. Is medically fit to drive motor vehicles. C. Is professionally competent to drive motor vehicles. D. Has habitual residence in the Czech Republic or studies there for at least 6 months. E. Has fulfilled other conditions established by this law. F. Is not serving an administrative penalty or criminal penalty of prohibition of activity consisting in prohibition of driving motor vehicles. Is not a debtor in execution by suspension of driving license. Has not been imposed appropriate restriction consisting in refraining from driving motor vehicles in criminal proceedings, and has not reached 12 points in point evaluation in the preceding year. G. Is not a holder of a valid driving license issued by another member state. H. Does not perform an obligation to refrain from driving motor vehicles to which they committed for purposes of conditional deferral of prosecution proposal or conditional suspension of criminal prosecution. 2. A driving license cannot be granted to a person whose driving license was suspended or revoked in another member state, or who was imposed prohibition of activity consisting in prohibition of driving motor vehicles, if the period for re-granting the driving license has not expired. A driving license, furthermore, cannot be granted to a person who lost it and does not meet conditions for its return. 3. Conditions according to paragraph 1 letters B, C, and E must be fulfilled by the driving license holder throughout the entire period of holding the driving license. 4. Study means basic education, secondary education, and higher professional education in full-time form in educational fields in elementary schools, secondary schools, conservatories, or higher professional schools registered in the Register of Schools and Educational Facilities, and full-time study in accredited study programs at universities. The place of study means the address of the place where teaching, or its substantial part, takes place. 5. For the purpose of determining whether the person mentioned in paragraph 1 meets the condition of clean criminal record according to paragraph 1 letter F. The competent authority mentioned in section 92, para. 1 requests an extract from the Criminal Records Register according to special legal regulations. The application for issuing an extract from the Criminal Records Register and the extract from the Criminal Records Register are transmitted electronically in a manner enabling remote access. Section 83 Age 1. A driving license may be granted only to a person who has reached the age of A. 15 years for Group AM, B. 16 years for Group A1, C. 17 years for Groups B1 and T, D. 18 years for Groups A2, B, B plus E, C1 and C1 plus E, E. 21 years for Groups C, C plus E, D1, D1 plus E, F. 24 years for Groups A, D and D plus E. 2. A driving license for Group may also be granted to a person who has reached A. 21 years of age if the driving license is limited only to three-wheeled motor vehicles, or B. 20 years of age if this person has been a holder of a driving license for Group A2 for at least 2 years. 3. A driving license for driving motor vehicles may be granted to persons mentioned in paragraph 1 letters A to C only with written consent of their legal representative. 4. A driving license for Group C may also be granted to a person who has reached 18 years of age, and for Group D to a person who has reached 21 years of age. The municipal office with extended competence limits these driving licenses until reaching the age established in paragraph 1 letters E and F, only to driving vehicles of A. The Ministry of Interior used by police, B. The Prison Service of the Czech Republic, C. The Armed Forces of the Czech Republic, D. Municipal Police, E. The Fire Rescue Service of the Czech Republic or fire protection units that are not part of the Fire Rescue Service of the Czech Republic, F. Customs Administration, G. During test drives in connection with their repair or maintenance. 5. A driving license for Groups C and C plus E may also be granted to a person who has reached 18 years of age, and for Groups D and D plus E to a person who has reached 21 or 23 years of age. This driving license authorizes its holder until reaching the age established in paragraph 1 letters E and F to drive A. Within initial training according to special legal regulations, B. If professionally competent and has undergone initial training according to special legal regulations. 1. In extended scope or 2. In basic scope, in case of driving license for Groups D and D plus E and its holder has reached 23 years of age or, when driving scheduled passenger transport vehicles, and the length of no connection exceeds 50 km, 21 years of age. Section 83 A. Driving with a mentor. 1. A driving license for Group B may, with written consent of their legal representative, also be granted to a person who has reached 17 years of age. The holder of this driving license before reaching 18 years of age, hereinafter 17-year-old driver, is authorized to drive motor vehicles classified in Group B only accompanied by a person registered in the driver's register as their mentor. 2. The competent municipal office with extended competence records in the driver's register as a mentor of this driver, upon application of the 17-year-old driver with written consent of their legal representative, a person who A. was granted a driving license for Group B more than 10 years ago, B. has been a continuous holder of a driving license for Group B for the last 5 years, C. has not lost the right to drive motor vehicles in the Czech Republic in the last 5 years, and was not serving an administrative penalty or criminal penalty of prohibition of activity consisting in prohibition of driving motor vehicles. In case of holders of driving permits or international driving permits according to Section 104 para. 2 letters B, C, or D. D does not have a suspended driving permit, E has no points recorded in point evaluation, and F agrees to such registration. 3. At most 4 mentors of a 17-year-old driver may be registered in the driver's register. 4. If a holder of a driving permit or international driving permit according to Section 104 para. 2 letters B, C, or D is to be registered as a mentor to prove fulfillment of conditions according to paragraph 2 letters A and B. A certificate issued by the competent authority of the state that issued the driving permit must be attached to the application. If such state does not issue certificates, fulfillment of the mentioned conditions is proven by sworn statement of the person to be registered as mentor. This certificate or sworn statement must not be older than 3 months. 5. The competent municipal office with extended competence immediately notifies the 17-year-old driver and the mentor about handling the application for mentor registration in the driver's register. 6. The competent municipal office with extended competence cancels the mentor registration in the driver's register if A. The 17-year-old driver requested it, or B. The mentor ceased to fulfill any of the conditions according to paragraph 2 letters B to F. 7. The competent municipal office with extended competence immediately notifies the 17-year-old driver and the mentor about canceling the mentor registration in the driver's register. The cancellation of mentor registration in the driver's register is effective from delivery of this notification to the 17-year-old driver. 8. When a 17-year-old driver drives a motor vehicle classified in Group B, the mentor is obliged to sit in the seat next to the driver, monitor the road traffic situation and driver behavior, and provide advice to the driver when necessary. 9. A mentor must not perform escort. A. Immediately after consuming alcoholic beverages or using other addictive substances, or at such time after consuming alcoholic beverages or using other addictive substances when they could still be under the influence of alcohol or other addictive substances. For assessing mentor impairment by other addictive substances, Section 5 para. 2 letter B applies accordingly, or B, if their ability to perform this activity is reduced due to their health condition. 10. A mentor is obliged upon request by police officers, military police officers, municipal police officers, or customs officers to prove their identity. A mentor is further obliged upon request by police officers, military police officers, or municipal police officers to undergo examination according to special legal regulations to determine whether they are not under the influence of alcohol or other addictive substances. Medical fitness to drive motor vehicles, Section 84, 1. Medical fitness to drive motor vehicles means physical and mental ability to drive motor vehicles, hereinafter medical fitness. 2. Medical fitness is assessed, and a medical fitness opinion is issued by an examining physician based on a statement by the driving license applicant or driving license holder. Results of medical examination and other necessary specialized examinations. 3. A person who has behavioral disorders caused by addiction to alcohol or other psychoactive substances, according to a medical fitness opinion, is not medically fit to drive motor vehicles. 4. For the purposes of this law, examining physician means A. A physician qualified in general practice or pediatrics of a registering healthcare provider providing outpatient healthcare, hereinafter registering provider. B. A physician of an occupational health service provider. C. A physician mentioned in letter A of any provider of this outpatient health care in case of an examined person who does not have a registering provider or occupational health service provider. 5. A physician of the registering provider is obliged to hand over to a physician of the occupational health service provider upon their request an extract from medical documentation containing data essential for determining medical fitness. 6. For a person who does not have a registering provider, the examining physician must rule out diseases, defects, or conditions that exclude or condition medical fitness to drive motor vehicles. 7. Implementing legal regulations regulate conditions of medical fitness, scope of medical examination and specialized examination, content of statement by driving license applicant or driving license holder, diseases, defects or conditions that exclude or condition medical fitness to drive motor vehicles. Section 85. 1. Assessment of medical fitness is performed by an assessing physician at the request of an applicant for a driving license or holder of a driving license. The costs of assessing medical fitness are borne by the applicant. 2. After conducting a medical examination and, if applicable, a specialist examination, the assessing physician shall issue the applicant a medical fitness assessment. 3. The medical fitness assessment must be in written form. 4. In the medical fitness assessment, the assessing physician shall state the determined health condition from the perspective of medical fitness of the applicant for a driving license or holder of a driving license, and an evaluation of their medical fitness. 5. The applicant for a driving license or holder of a driving license is a. Medically fit to drive motor vehicles. B. Medically fit to drive motor vehicles with conditions. C. Medically unfit to drive motor vehicles. 6. In the assessment of medical fitness according to paragraph 5 letter B, the reason and condition of medical fitness shall be stated, and in the assessment of medical fitness according to paragraph 5 letter C, the reason for medical unfitness to drive motor vehicles shall be stated. 7. The implementing legal regulation shall establish the content and form of the medical fitness assessment and regulate details of medical fitness evaluation. Section 86. If the applicant for a driving license or holder of a driving license is, according to the medical fitness assessment, medically fit to drive motor vehicles with conditions or medically unfit to drive motor vehicles, the assessing physician shall immediately notify this fact to the municipal office with extended competence, competent according to the usual residence or place of study of the applicant for a driving license or holder of a driving license, and send them a copy of the medical fitness assessment. Regular medical examinations. Section 87. 1. Regular medical examinations must be undergone by a driver of a vehicle who, when performing tasks related to the performance of special duties, uses special warning lights of blue or blue and red color too, possibly supplemented with special acoustic warning signals. B. A driver who drives a motor vehicle in an employment relationship, and for whom driving a motor vehicle is a type of work agreed upon in the employment contract. C. A driver for whom driving a motor vehicle is the subject of independent gainful activity carried out according to a special legal regulation too. D. A holder of a driving license for groups C1, C1 plus E, C, C plus E, D1, D1 plus E, D or D plus E, if they drive a motor vehicle classified in one of these vehicle groups. E. A holder of a certificate for driving instructors for training in driving motor vehicles according to a special legal regulation. 2. The person referred to in paragraph 1 must undergo an initial medical examination before starting the performance of the activity referred to in paragraph 1, and then regular medical examinations every 2 years until the age of 50, and annually after the age of 50. 3. A holder of a driving license who is not a person referred to in paragraph 1 must undergo a regular medical examination no earlier than 6 months before reaching the age of 65 and 68 years, and no later than on the day of reaching the specified age, and after the age of 68 every 2 years. 4. The assessing physician may, based on the results of a regular medical examination in justified cases, especially considering the current health condition, determine for the person referred to in paragraph 1 or 3 hereinafter, obliged person, a shorter deadline for the next regular medical examination than the deadlines specified in paragraph 2 or 3. 5. If necessary for determining the medical fitness of the obliged person, the assessing physician may order a specialist examination. 6. The costs of regular medical examinations for persons referred to in paragraph 1 are paid by the employer for persons in employment relationships. For persons referred to in paragraph 1 who are not in employment relationships, and for persons referred to in paragraph 3, these persons pay the costs of regular medical examinations. 7. The implementing legal regulation shall regulate the scope of regular medical examinations. Section 87. A traffic psychology examination. 1. Traffic psychology examination must be undergone by a holder of a driving license for Group C 1 plus E, C or C plus E, if they drive a truck with maximum permissible weight exceeding 7,500 kg, a tractor with maximum permissible weight exceeding 3,500 kg and design speed of 80 km/h or higher, a special purpose vehicle with maximum permissible weight exceeding 7,500 kg, or a vehicle combination consisting of a truck and trailer vehicle or special purpose vehicle and trailer vehicle with maximum permissible weight exceeding 7,500 kg. B. A holder of a driving license for Group D1 plus E, D or D plus E, if they drive a motor vehicle classified in one of these vehicle groups. 2. The holder of a driving license referred to in paragraph 1 must undergo traffic psychology examination before starting the performance of the activity referred to in paragraph 1. And further traffic psychology examination no earlier than 6 months before reaching the age of 50, and no later than on the day of reaching 50 years of age, and then every 5 years. The obligation to undergo traffic psychology examination before starting the activity does not arise if the holder of driving license referred to in paragraph 1 underwent traffic psychology examination before obtaining this driving license, and no more than 6 months have elapsed from the day of the examination to the day of starting the activity. 3. Traffic psychology examination must be undergone by a person who applies for the return of a driving license that they lost as a result of a. Reaching a total of 12 points in the point evaluation, b. A court-imposed penalty of prohibition of activity consisting in prohibition of driving motor vehicles, c. An administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles imposed by an administrative body, if this administrative penalty was imposed for a period of at least 6 months, or d. Conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution, for the purposes of which they undertook to refrain from driving motor vehicles. 4. Traffic psychology examination is performed by a psychologist to whom the ministry has granted accreditation. 5. The ministry shall grant accreditation for conducting traffic psychology examination upon request to a natural person who a. Completed accredited master's degree studies in psychology, b. Completed postgraduate studies in traffic psychology of an accredited study program or lifelong learning program conducted by a university, c. Has at least 3 years of experience in the field of traffic psychology, and d. Has equipment necessary for proper conduct of traffic psychology examination. 6. The ministry shall revoke accreditation for conducting traffic psychology examination if its holder does not meet the condition for its granting specified in paragraph 5 letter D, or has repeatedly, or in a particularly serious manner, violated their obligation under this law that relates to the activity of the accreditation holder. 7. The costs of traffic psychology examination for persons referred to in paragraph 1 are paid by the employer for persons in employment relationships. For persons referred to in paragraph 1 who are not in employment relationships, and for persons referred to in paragraph 3, these persons pay the costs of traffic psychology examination. 8. The obligation of traffic psychology examination according to paragraph 1 does not apply to drivers who perform road transport of a private nature if it is not performed for payment, and also to drivers of fire protection vehicles, drivers of police vehicles, customs administration, prison service of the Czech Republic, intelligence services, and drivers of vehicles of the Czech Armed Forces. 9. Equipment necessary for proper conduct of traffic psychology examination shall be established by implementing legal regulation. Section 87b. 1. Traffic psychology examination determines psychological fitness to drive motor vehicles, hereinafter, psychological fitness. 2. A person undergoing traffic psychology examination according to Section 87. A paragraph 3 shall present to the psychologist conducting the examination a medical fitness assessment that is not older than 30 days, and an extract of their data from the driver's register that is not older than 30 days. 3. About the result of the conducted traffic psychology examination, the psychologist shall issue a written assessment to the examined person. The conclusion of the assessment must clearly indicate whether the examined person is psychologically fit to drive motor vehicles, psychologically fit to drive motor vehicles with conditions, or psychologically unfit to drive motor vehicles. A copy of the assessment shall be sent by the psychologist within 5 working days from the day of the examination to the municipal office with extended competence, competent according to the usual residence or place of study of the examined person. 4. The psychologist keeps records of conducted traffic psychology examinations, in which they record at least the name, possibly names, hereinafter name, surname, residential address and birth, number of the examined person, or date of birth if no birth number was assigned, date and time of commencement and completion of traffic psychology examination, documents and records of the course and results of traffic psychology examination, copy of the issued assessment, and possibly data on sending the copy of assessment to the municipal office with extended competence. Data, documents, and records of traffic psychology examination are kept for at least 5 years from the day of its conduct. 5. The scope, content, and method of conducting traffic psychology examination, and the form of assessment of the result of traffic psychology examination shall be established by implementing legal regulation. Section 87c. 1. If the examined person is, according to the issued assessment of the result of traffic psychology examination, psychologically fit to drive motor vehicles with conditions, or psychologically unfit to drive motor vehicles. Traffic psychology examination conducted before the expiration of 3 months from the day of its issuance shall not be taken into account, except for review of the issued assessment. 2. If the examined person does not agree with the conclusions of the assessment of the result of traffic psychology examination, they may submit a proposal for its review to the Ministry within 10 working days from the day of its issuance. The Ministry shall designate within 15 working days from the delivery of the proposal for review of the issued assessment a commission composed of 3 accredited psychologists, who shall review the conducted traffic psychology examination and either confirm its results or issue a new assessment. A member of the commission cannot be the psychologist who issued the reviewed assessment. 3. The psychologist who issued the reviewed assessment shall, upon request of the Ministry, submit to the Commission all data, documents and records of the conducted traffic psychology examination within 5 working days from the day of delivery of the request. The Commission shall review the conducted traffic psychology examination within 10 working days from the day of handover of materials. If the psychological fitness of the examined person cannot be evaluated based on the submitted materials. The Commission shall conduct a new traffic psychology examination to the necessary extent. 4. If the obligation to submit materials according to paragraph 3 was not fulfilled, the Commission shall, as part of the review, conduct a new traffic psychology examination within 10 working days from the expiration of the deadline for submitting materials. 5. The costs of reviewing the assessment of the result of traffic psychology examination are paid by the examined person. The costs of traffic psychology examination according to paragraph 4 are paid by the psychologist who issued the reviewed assessment. Section 88. 1. After conducting a regular medical examination, the assessing physician issues the obliged person a medical fitness assessment. The medical fitness assessment must be in written form. 2. The obliged person is a. Medically fit to drive motor vehicles. B. Medically fit to drive motor vehicles with conditions. C. Medically unfit to drive motor vehicles. 3. In the assessment of medical fitness according to paragraph 4 letter B, the condition of medical fitness shall be stated. 4. If the obliged person is, according to the result of regular medical examination, medically fit with conditions or medically unfit, the assessing physician shall notify this fact to the municipal office with extended competence, competent according to the usual residence or place of study of the obliged person, and, for persons referred to in Section 87, paragraph 1 who are in employment relationships, also to the employer. 5. The obliged person must undergo regular medical examination no later than the day before the expiration of the validity of the medical fitness assessment. 6. The implementing legal regulation shall establish the form of medical fitness assessment and regulate details of medical fitness evaluation of the obliged person. Section 89. An obliged person who does not have a valid medical fitness assessment is medically unfit to drive motor vehicles. Section 89. A physician who determines that an applicant for a driving license or holder of a driving license is medically fit to drive motor vehicles with conditions, or is not medically fit to drive motor vehicles, is obliged to immediately inform the municipal office with extended competence competent, according to the usual residence or place of study of the applicant for a driving license or holder of a driving license about this fact. Section 89B. If a police officer, military police officer, municipal police officer, or customs officer determines a fact reasonably suggesting that a holder of a driving license is medically unfit to drive motor vehicles, they shall notify it to the municipal office with extended competence, competent according to their usual residence or place of study. Section 90. Professional competence to drive motor vehicles. 1. A driving license may be granted only to a person who has acquired professional competence to drive motor vehicles according to a special legal regulation, hereinafter professional competence. 2. If an applicant for a driving license has completed training and practical driving test with a motor vehicle equipped with automatic transmission, the municipal office with extended competence shall limit the driving license for the respective group only to vehicles with this type of transmission. A vehicle equipped with automatic transmission means a vehicle in which there is no clutch pedal, or in the case of vehicles for which driving license for Group A1, A2 or A authorizes manual clutch lever. The limitation of driving license is not imposed if it concerns driving license. A. For Group AM or B, for Group B plus E, C, C plus E, C1, C1 plus E, D, D plus E, D1 or D1 plus E, if the applicant is already a holder of driving license granted for driving vehicles classified in at least one of Groups B, B plus E, C, C plus E, C1, C1 plus E, D, D plus E, D1 or D1 plus E, which is not limited only to driving vehicles equipped with automatic transmission. 3. When driving rail vehicles that are used in road traffic, The driver of such vehicle must be a holder of authorization to drive a rail vehicle according to a special legal regulation. A trolleybus driver must be a holder of driving license for Group D. Section 91. Additional conditions for granting driving license for A. Group D or D1 may be granted only to an applicant who is already a holder of driving license for Group B. B. Group C or C1 may be granted only to an applicant who is already a holder of driving license for Group B. C. Group B plus E may be granted only to an applicant who is already a holder of driving license for Group B. D. Group C plus E may be granted only to an applicant who is already a holder of driving license for Group C. E. Group C1 plus E may be granted only to an applicant who is already a holder of driving license for Group C1. F. Group D plus E may be granted only to an applicant who is already a holder of driving license for Group D. G. Group D1 plus E may be granted only to an applicant who is already a holder of driving license for Group D1. Section 92. Granting and extension of driving license. 1. Driving license is granted to an applicant for driving license by the competent municipal office with extended competence. 2. Driving license is granted based on an application for driving license, which must be in written form. 3. The application for driving license must state A. Name and surname of the applicant for driving license. B. Address of usual residence of the applicant for driving license in the Czech Republic, or place of study. C. Date and place of birth and birth number of the applicant for driving license. If assigned, D. Group of vehicles for which the applicant applies for granting driving license, and whether they apply for granting driving license according to Section 83, paragraphs 4 or 5. E. Previous usual residences from reaching the age specified in Section 83. If they were located outside the Czech Republic, and current usual residence outside the Czech Republic, if the applicant only studies in the Czech Republic. 4. The following must be attached to the application. A. Valid identity document of the applicant. B. Medical fitness assessment. C. Document on professional competence to drive motor vehicles classified in the respective vehicle group, which must not be older than 6 months. D. Document proving usual residence of the applicant who does not have permanent residence in the Czech Republic, or proposal of another means of evidence to prove it, or confirmation of study according to Section 82, paragraph 4. Documents proving usual residence of the applicant are especially 1. Certificate of registration according to the law on residence of foreigners in the Czech Republic. 2. Extract from the real estate cadaster confirming ownership rights to real estate. 3. Lease agreement for real estate. 4. Employment confirmation. 5. Extract from the trade register. E. Statutory declaration of the applicant that 6. They are not a holder of valid driving license granted by another member state, and 7. Another member state has not imposed on them a prohibition of activity consisting in prohibition of driving motor vehicles, or their driving license has not been suspended or revoked, or that the period for which the prohibition of activity was imposed or the period for re-granting driving license has already expired. F. Document on fulfilling additional conditions according to Section 91. 5. After submitting the application, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 3 that are stated in it, and return the identity document to the applicant. If the municipal office with extended competence has doubts about the truthfulness of data stated in the statutory declaration according to paragraph 4, it shall verify their truthfulness with the competent authority of the state in which the applicant had previous usual residence. 6. The procedure according to paragraphs 1 to 5 is also followed in case of extension of driving license for additional vehicle groups. 7. If the application for granting or extending driving license is approved in full scope, instead of written preparation of decision. Data on this fact are recorded in the driver's register, and the applicant is issued a driving license with granted or extended driving license. 8. The form of application for driving license shall be established by implementing legal regulation. Section 93. Conditioning and limitation of driving license. 1. The competent municipal office with extended competence shall condition driving license if the holder of driving license is medically or psychologically fit to drive motor vehicles with conditions. 2. The competent municipal office with extended competence shall limit driving license if the holder of driving license a. Partially lost professional competence, b. Cease to fulfill one of the additional conditions according to Section 91, c. Renounced driving license for some vehicle group. 3. The fact according to paragraph 2 letter c must be reported in writing by the holder of driving license to the competent municipal office with extended competence. The notification must state a. Name and surname of the holder of driving license, b. Address of usual residence of the holder of driving license, c. Date and place of birth and birth number of the holder of driving license if assigned, d. Vehicle group for which the holder of driving license renounces. 4. A valid identity document of the holder of driving license must be attached to the notification according to paragraph 3. After submitting the notification, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 2 that are stated in it, and return the identity document to the holder of driving license. 5. In the decision on conditioning driving license according to paragraph 1, or on limiting driving license according to paragraph 2 letters A and B, the competent municipal office with extended competence shall state the scope of conditioning or limitation of driving license, and possibly other conditioning or limiting conditions for the exercise of driving license that the holder of driving license must fulfill. The limitation of driving license according to paragraph 2 letter C is acknowledged by the competent municipal office with extended competence based on the notification according to paragraph 3 and does not decide on limitation of driving license. Section 94. Revocation of driving license and renunciation of driving license. 1. The competent municipal office with extended competence shall revoke driving license if its holder a. Completely lost medical fitness, b. Completely lost professional competence, or c. Did not fulfill the conditions stated in Section 82 when granting driving license. In case of non-fulfillment of the conditions stated in Section 82, paragraph 1 letter D, driving license is not revoked if it becomes apparent in the proceedings that the holder of driving license already fulfills this condition. 2. A holder of driving license may renounce driving license. 3. Renunciation of driving license must be reported in writing by the holder of driving license to the competent municipal office with extended competence. The notification must state a. Name and surname of the holder of driving license, b. Address of usual residence of the holder of driving license or place of study, c. Date and place of birth and birth number of the holder of driving license if assigned, d. Date of granting driving license. 4. A valid identity document of the holder of driving license must be attached to the notification according to paragraph 3. After submitting the notification, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 3 that are stated in it, and return the identity document to the holder of driving license. 5. Renunciation of driving license according to paragraph 2 is acknowledged by the competent municipal office with extended competence based on the notification according to paragraph 3, and does not decide on revocation of driving license. Section 94. A loss of driving license. 1. A holder of driving license loses driving license on the day of final validity of a decision by which a. A court imposed a penalty or a competent administrative authority imposed an administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles. B. An adequate restriction consisting in refraining from driving motor vehicles was imposed in criminal proceedings. Or C. It was decided on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution, for the purposes of which the holder of driving license undertook to refrain from driving motor vehicles, or by which it was decided, on accepting a new commitment to refrain from driving motor vehicles during the probation period of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. 2. The holder of driving license is obliged to surrender the driving license to the competent municipal office with extended competence within 5 working days from the day when the decision according to paragraph 1 became final. 3. For surrendering driving license, Section 113, paragraph 4 applies accordingly. 4. If driving license that the holder lost according to paragraph 1 or renounced conditions granting driving license for another vehicle group, the holder simultaneously loses driving license for this vehicle group. Section 95, suspension of driving license. 1. As part of proceedings on conditioning, limitation, or revocation of driving license, the competent municipal office with extended competence may decide on suspension of driving license as a preliminary measure according to Special Legal Regulation 3. 2. Suspension of driving license means that the holder of driving license must not drive motor vehicles during the validity of this suspension. Section 96, review of medical fitness. 1. Conditioning of medical fitness according to Section 93, paragraph 1 or loss of medical fitness according to Section 94, paragraph 1 letter A, is determined by review of medical fitness. 2. For review of medical fitness, provisions Section 84 to 86 apply accordingly. 3. The competent municipal office with extended competence, as part of proceedings on conditioning, limitation, or revocation of driving license, shall order the holder of driving license to undergo review of medical fitness according to paragraph 2 within a specified period. If facts reasonably suggesting that the holder of driving license is medically fit to drive motor vehicles with conditions, or medically unfit to drive motor vehicles, come to light. 4. The holder of driving license is obliged to undergo review of medical fitness within the specified period. If the holder of driving license cannot undergo review of medical fitness within the specified period for serious reasons, they shall immediately notify this fact to the competent municipal office with extended competence, which shall set an alternative deadline. 5. If the holder of driving license does not undergo review of medical fitness without serious reason within the specified period or within the alternative deadline, they are considered medically unfit to drive motor vehicles. 6. The specified deadline for review of medical fitness according to paragraph 3 must not be shorter than 15 days. The alternative deadline according to paragraph 4 must not be shorter than 10 days. Section 97, re-examination of professional competence. 1. Loss of professional competence according to Section 93, paragraph 2 letter A, or Section 94, paragraph 1 letter B, is determined by re-examination of professional competence. Re-examination of professional competence also verifies the continuation of professional competence of an applicant for driving license, whose document on professional competence is older than 6 months. 2. Re-examination of professional competence is conducted according to special legal regulation. 3. The competent municipal office with extended competence, as part of proceedings on limitation or revocation of driving license, shall order the holder of driving license to undergo re-examination of professional competence according to paragraph 2, within a specified period. If facts reasonably suggesting that the holder of driving license partially or completely lost professional competence come to light. 4. The holder of driving license is obliged to undergo re-examination of professional competence within the specified period. If the holder of driving license cannot undergo re-examination of professional competence within the specified period for serious reasons, they shall immediately notify this fact to the competent municipal office with extended competence, which shall set an alternative deadline. 5. If the holder of driving license does not undergo re-examination of professional competence without serious reason within the specified period, or does not undergo re-examination of professional competence within the alternative deadline, they are considered professionally unfit to drive motor vehicles. 6. The specified deadline for re-examination of professional competence, according to paragraph 3, must not be shorter than 30 days. The alternative deadline, according to paragraph 4, must not be shorter than 15 days. Cancellation of conditioning or limitation of driving license, section 98. 1. If reasons for conditioning driving license, according to section 93, paragraph 1, have ceased, the competent municipal office with extended competence shall decide based on an application for cancellation of conditioning of driving license. 2. An application for cancellation of conditioning of driving license is submitted by the holder of driving license to whom driving license was conditioned, to the competent municipal office with extended competence. 3. The application according to paragraph 2 must be in written form and must state: A. Name and surname of the applicant. B. Address of usual residence of the applicant in the Czech Republic or place of study. C. Date and place of birth and birth number of the applicant if assigned. D. Date of final validity of the decision on conditioning driving license. E. Conditioning of driving license for which cancellation is requested. 4. The following must be attached to the application according to paragraphs 2 and 3. A. Valid identity document of the applicant. B. Medical fitness assessment of the applicant issued by an assessing physician, which must not be older than 30 days on the day of submitting the application. 5. After submitting the application, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 3 that are stated in it, and return the identity document to the applicant. 6. For determining whether reasons for conditioning driving license according to section 93, paragraph 1 have ceased, provisions section 84 to 86 apply accordingly. Section 99. 1. If reasons for limitation of driving license for partial loss of professional competence, according to section 93, paragraph 2 letter B, have ceased, the competent municipal office with extended competence shall decide based on an application for cancellation of limitation of driving license. 2. An application for cancellation of limitation of driving license is submitted by the holder of driving license to whom driving license was limited for partial loss of professional competence, to the competent municipal office with extended competence. The application may be submitted no sooner than after the expiration of 6 months from the day when the decision on limitation of driving license for partial loss of professional competence became enforceable, or when the decision on suspension of driving license became enforceable. 3. The application according to paragraph 2 must be in written form and must state: A. Name and surname of the applicant. B. Address of usual residence of the applicant in the Czech Republic or place of study. C. Date and place of birth and birth number of the applicant if assigned. D. Date of enforceability of the decision on limitation of driving license for partial loss of professional competence. E. Vehicle group for which return of driving license is requested. 4. The following must be attached to the application according to paragraphs 2 and 3. A. Valid identity document of the applicant. B. Document on professional competence to drive motor vehicles classified in the respective group, which must not be older than 30 days on the day of submitting the application. 5. After submitting the application, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 3 that are stated in it, and return the identity document to the applicant. 6. Cessation of reasons for limitation of driving license for partial loss of professional competence is determined by re-examination of professional competence according to special legal regulation. Return of driving license section 101. If reasons for revocation of driving license for loss of medical fitness according to section 94, paragraph 1, letter A, have completely or partially ceased, the competent municipal office with extended competence shall decide based on an application for return of driving license. 2. An application for return of driving license is submitted by a person whose driving license was revoked for loss of medical fitness to the competent municipal office with extended competence. 3. If more than 3 years have elapsed since the final validity of the decision on revocation of driving license for loss of medical fitness, the applicant, according to paragraph 2, must prove professional competence. 4. The application according to paragraph 2 must be in written form and must state a. Name and surname of the applicant. B. Address of usual residence of the applicant in the Czech Republic or place of study. C. Date and place of birth and birth number of the applicant if assigned. D. Date of final validity of the decision on revocation of driving license for loss of medical fitness. E. Vehicle group for which return of driving license is requested. 5. The following must be attached to the application according to paragraphs 2 and 4. A. Valid identity document of the applicant. B. Medical fitness assessment issued by an assessing physician, which must not be older than 30 days on the day of submitting the application. C. Document on professional competence of the applicant, which must not be older than 30 days on the day of submitting the application, if the application is submitted during the period according to paragraph 3. 6. After submitting the application, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 4 that are stated in it, and return the identity document to the applicant. 7. For determining whether reasons for revocation of driving license for loss of medical fitness have completely or partially ceased, provisions section 84 to 86 apply accordingly. 8. Professional competence according to paragraph 3 is determined by re-examination of professional competence according to special legal regulation. 9. If the determination according to paragraph 7 or re-examination of professional competence according to paragraph 8 proves that the applicant for return of driving license is medically fit to drive motor vehicles only with conditions or only partially professionally competent to drive motor vehicles, the competent municipal office with extended competence shall condition or limit the returned driving license. For this conditioning or limitation, provisions section 93, paragraph 5 applies accordingly. Section 101. 1. If reasons for revocation of driving license for loss of professional competence, according to section 94, paragraph 1, letter B, have completely or partially ceased, the competent municipal office with extended competence shall decide based on an application for return of driving license. 2. An application for return of driving license is submitted by a person whose driving license was revoked for loss of professional competence to the competent municipal office with extended competence. The application may be submitted no sooner than after the expiration of 6 months from the day when the decision on revocation of driving license for loss of professional competence became enforceable, or when the decision on suspension of driving license became enforceable. 3. The application according to paragraph 2 must be in written form and must state: A. Name and surname of the applicant. B. Address of usual residence of the applicant in the Czech Republic or place of study. C. Date and place of birth and birth number of the applicant if assigned. D. Date of enforceability of the decision on revocation of driving license for loss of professional competence. E. Vehicle group for which return of driving license is requested. 4. The following must be attached to the application according to paragraphs 2 and 3. A. Valid identity document of the applicant. B. Document on professional competence to drive motor vehicles classified in the respective group, which must not be older than 30 days on the day of submitting the application. 5. After submitting the application, the competent municipal office with extended competence shall immediately verify according to the identity document the data according to paragraph 3 that are stated in it, and return the identity document to the applicant. 6. Complete or partial cessation of reasons for revocation of driving license for loss of professional competence is determined by re-examination of professional competence according to special legal regulation. 7. If the re-examination of professional competence according to paragraph 6 proves that the applicant for return of driving license is only partially professionally competent to drive motor vehicles, the competent municipal office with extended competence shall limit the returned driving license. For this limitation, provision section 93 paragraph 5 applies accordingly. Section 102. 1. The competent municipal office with extended competence shall decide upon application by a person who lost driving license according to section 94A on its return after A. Serving a penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles. B. Waiver or conditional waiver from serving the remainder of penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles. C. Serving a penalty or after expiration of the probation period of conditional waiver from punishment with supervision, within which an adequate restriction consisting in refraining from driving motor vehicles was imposed, or after a decision on waiver from this adequate restriction. D. Decision on failure to prove oneself during the probation period of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. E. Expiration of the period of commitment to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. Or F. Decision that the remainder of commitment to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution shall not be served. 2. An application for return of driving license is submitted by a person referred to in paragraph 1 to the competent municipal office with extended competence. The application must be in written form and must state: A. Name and surname of the applicant. B. Address of usual residence of the applicant in the Czech Republic or place of study. C. Date, place of birth and birth number of the applicant if assigned. D. Date of 1. Completion of serving penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles. 2. Final validity of decision on waiver or conditional waiver from serving the remainder of this penalty or administrative penalty. 3. Completion of serving penalty within which an adequate restriction consisting in refraining from driving motor vehicles was imposed, or date of final validity of decision on waiver from this adequate restriction. 4. Final validity of decision on proving oneself during the probation period of conditional waiver from punishment with supervision, within which an adequate restriction consisting in refraining from driving motor vehicles was imposed, or date when it is considered that proving occurred. 5. Final validity of decision on failure to prove oneself during the probation period of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. Or 6. Completion of duration of commitment to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. Or date of final validity of decision that the remainder of this commitment shall not be served. Vehicle group for which return of driving license is requested. 3. The following must be attached to the application according to paragraph 2. A valid identity document of the applicant. B. Document consisting of 1. Decision by which administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles was imposed on the applicant, or decision by which waiver from serving the remainder of this administrative penalty was granted. 2. Decision by which penalty of prohibition of activity consisting in prohibition of driving motor vehicles was imposed on the applicant, or penalty within which an adequate restriction consisting in refraining from driving motor vehicles was imposed on the applicant. Decision by which waiver from punishment with supervision within which an adequate restriction consisting in refraining from driving motor vehicles was imposed was granted. Or decision by which waiver or conditional waiver from serving the remainder of this penalty, or from adequate restriction consisting in refraining from driving motor vehicles was granted. Or 3. Decision on failure to prove oneself during the probation period of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. Or decision that the remainder of commitment to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution shall not be served. And if this decision was not issued, decision on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. C. In case of application according to paragraph 5, document on professional competence to drive motor vehicles classified in the respective vehicle group, which must not be older than 60 days on the day of submitting the application. 4. After submitting the application, the competent municipal office with extended competence shall immediately verify the applicant's data according to the identity document and return the identity document to the applicant. 5. If more than 1 year has elapsed from the day of final validity of judgment or decision, by which penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles, penalty within which an adequate restriction consisting in refraining from driving motor vehicles was imposed on the applicant, or by which waiver from punishment with supervision within which an adequate restriction consisting in refraining from driving motor vehicles was imposed was granted. Or decision on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution for the purposes of which they committed to refrain from driving motor vehicles was imposed, the applicant must prove medical and professional competence. If the judgment or decision relates to an act for which the applicant's driving license was detained, this period runs from the day of detention of the driving license. An applicant who is imposed penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles for a period of at least 18 months, who committed within conditional suspension of criminal prosecution or conditional postponement of motion for punishment, that for a period of at least 18 months they will not perform such activity, or who was imposed administrative penalty of prohibition of activity for offense according to section 125 C paragraph 1 letter D, must also prove completion of therapeutic program according to section 102A. The applicant must also prove completion of therapeutic program if its completion was imposed by public prosecutor or court according to special legal regulation. 6. The applicant must prove psychological competence if they apply for return of driving license that they lost as a result of a court-imposed penalty of prohibition of activity consisting in prohibition of driving motor vehicles. B. Administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles imposed by administrative body, if this administrative penalty was imposed for a period of at least 6 months. Or C. Conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution, for the purposes of which they committed to refrain from driving motor vehicles. 7. An applicant for whom obligation according to Section 102F arose is obliged to prove that they completed traffic psychology interview and training of beginning drivers according to special legal regulation. Completion of traffic psychology interview is not proven if obligation to prove completion of therapeutic program arose. Section 102. A therapeutic program. 1. Therapeutic program is a social training program intended especially for persons who lost driving license according to Section 94A. Completion of therapeutic program is a condition for return of driving license in cases specified in Section 102, Paragraph 5. Completion of therapeutic program may also be ordered by public prosecutor or court, according to special legal regulation. 2. Organization of therapeutic programs is ensured by the Transport Research Center, VI, hereinafter Methodological Center. The superior administrative body of the Methodological Center is the Ministry. 3. Therapeutic program consists of group therapy led by a lecturer who has been granted accreditation according to Section 102. See Paragraph 1. The content of therapeutic program is analysis of topics focused on risky behavior in transport and its prevention, rights and duties of traffic participants and traffic rules and their observance. Therapeutic program is divided into 5 parts, each lasting 4 hours. Additional details of content and conduct of therapeutic program and number of therapeutic program participants shall be established by implementing legal regulation. 4. A condition for participation in therapeutic program is payment of fee, the amount of which is established by implementing legal regulation. The fee is revenue of the Methodological Center. 5. Document on completion of therapeutic program is a certificate whose form is established by implementing legal regulation. Section 102B Methodological Center. 1. The Methodological Center ensures financing of therapeutic programs. For each conducted therapeutic program, it provides the lecturer with a lump sum compensation established including all costs connected with conducting therapeutic program and lecturer's remuneration. The lump sum amount of cost compensation and details of its provision are established by implementing legal regulation. 2. The Methodological Center. A. Grants and revokes accreditation to lecturers. B. Ensures initial and continuous education of lecturers. C. Grants certificates. D. Performs control of conducting therapeutic programs. E. Ensures methodological guidance of therapeutic programs. 3. The Methodological Center ensures availability of therapeutic programs. 4. If therapeutic program cannot be completed in the planned term due to impediment on the lecturer's side, upon request of one of its participants, the Methodological Center shall designate another lecturer who is obliged to complete this therapeutic program without undue delay. When designating a lecturer, the Methodological Center considers territorial accessibility of therapeutic program for its participants and lecturers' capacity possibilities. Section 102, C. Lecturer. 1. The Methodological Center shall grant lecturer accreditation to a natural person who a. Obtained university education by studying in master's degree program. B. Successfully completed at their own expense qualification course for lecturers concluded with examination and organized by Methodological Center or public university, in cooperation with methodological center. And C. Documents at least 3 years of therapeutic practice or completion of accredited psychotherapeutic training. 2. Details on content and conduct of qualification course for lecturers and examination and requirements for accredited psychotherapeutic training, completion of which can prove fulfillment of condition according to paragraph 1 letter C, are established by implementing legal regulation. 3. A lecturer who has been granted accreditation according to paragraph 1 is obliged to continuously educate themselves at their own expense in course organized by Methodological Center. The scope and content of continuous education are established by implementing legal regulation. The lecturer is obliged to document completion of mandatory education by January 31 of calendar year in the previous calendar year. This does not apply if accreditation was granted in the previous calendar year. 4. The Methodological Center shall revoke accreditation to a lecturer who fails to fulfill obligation of continuous education according to paragraph 3. A new application for granting accreditation may be submitted after completing continuous education. 5. When conducting therapeutic program, the lecturer is obliged to observe methodology of therapeutic program issued by Methodological Center and published through Information Internet Portal. Section 102. D. Information Internet Portal. 1. Information Internet Portal is an information system of public administration through which organization of therapeutic programs is ensured. The administrator of Information Internet Portal is Methodological Center. The Information Internet Portal includes a register of therapeutic program participants, hereinafter participants register. B. List of accredited lecturers. C. Database of therapeutic programs. D. Portal for registration to therapeutic programs. 2. The participants register contains structured data on therapeutic program participants in scope. A. Name and surname. B. Address of residence. C. Date of birth. D. Reason for participation in therapeutic program. E. Record of participation in therapeutic program, including data on its completion. F. Certificate in electronic form. 3. The list of accredited lecturers contains name and surname, date of birth and address of residence, and also data on initial and continuous education of lecturer, list of conducted therapeutic programs and address of their conduct. 4. In the database of therapeutic programs, data on planned and ongoing therapeutic programs are kept. Conduct of therapeutic program is announced by lecturer and published through database of therapeutic programs. 5. A person who intends to participate in therapeutic program registers to therapeutic program through portal for registration to therapeutic programs. If they do not do so, the lecturer registers them no later than before commencement of therapeutic program through portal for registration to therapeutic programs. For this purpose, the lecturer verifies identity of this person. 6. Content of Information Internet Portal is accessible in manner enabling remote access to a. Municipal offices with extended competence, authorities active in criminal proceedings and probation and mediation service. B. Therapeutic program participant in scope of data kept about them. C. Lecturer in scope of data kept about them, and in scope of data kept about participants of therapeutic program conducted by them. D. Public in scope of database of therapeutic programs. 7. Editor of data in participants register according to paragraph 2, and in list of accredited lecturers according to paragraph 3 is Methodological Center. Data are kept in Information Internet Portal for 10 years. Editor of data in database of therapeutic programs is lecturer who announced therapeutic program. Section 102E. Control of conducting therapeutic programs. 1. Methodological Center controls activity of lecturers when conducting therapeutic programs. During control, It determines especially compliance of conducting therapeutic program with data announced in database of therapeutic programs and observance of requirements placed on scope, content, and conduct of therapeutic program. Methodological Center also assesses whether therapeutic program is conducted professionally and corresponds to methodology of therapeutic programs. 2. If Methodological Center determines deficiencies in conducting therapeutic program during control, it shall impose measures for remediation, which must be carried out without undue delay or within deadlines set by Methodological Center. 3. Methodological Center may revoke accreditation to lecturer who does not remedy according to paragraph 2. A new application for granting accreditation may be submitted no sooner than after expiration of 2 years from its revocation. 4. When controlling activity of lecturers in conducting therapeutic programs, Methodological Center proceeds according to Control Code. Obligation to complete traffic psychology, interview and training of beginning drivers Section 102F. 1. A driver who within 2 years from the day of granting driving license committed offense or crime for which 6 points were recorded in driver's register is obliged to complete traffic psychology interview and training of beginning drivers according to special legal regulation. 2. Traffic psychology interview and training of beginning drivers according to special legal regulation must also be completed by person who applies for return of driving license that they lost according to Section 94A in connection with offense or crime that they committed within 2 years from the day of granting driving license. Traffic psychology interview is not completed by person for whom obligation to complete therapeutic program arose. 3. During the period of loss, suspension or revocation of driving license or detention of driving license, the running of deadline according to paragraph 1 or 2 is stayed. 4. Completion of traffic psychology, interview or training of beginning drivers according to special legal regulation before the day of committing offense or crime according to paragraph 1 or 2 is not considered. Section 102G. 1. If competent municipal office with extended competence records points in driver's register for crime or offense according to Section 102F paragraph 1, it shall call upon driver to complete traffic psychology, interview, and training of beginning drivers according to special legal regulation, and to submit confirmation of their completion. This does not apply if driver is not holder of driving license at the moment of making point record. 2. If driver does not submit confirmation within 3 months from the day of delivery of call according to paragraph 1, they lose driving license upon expiration of last day of this deadline and are obliged to surrender driving license to competent municipal office with extended competence no later than on this day. The competent municipal office with extended competence shall instruct them about this in the call. For surrendering driving license, Section 113, paragraph 4 applies accordingly. 3. The competent municipal office with extended competence shall decide upon application by person who lost driving license according to paragraph 2 on its return, if applicant completed traffic psychology, interview, and training of beginning drivers according to special legal regulation. If more than 1 year has elapsed from the day of loss of driving license, applicant is obliged to prove professional, medical, and psychological competence. Section 102H. 1. Subject of traffic psychology interview is obtaining and deepening knowledge about most frequent causes of traffic accidents and their prevention, and about prevention and solution of extraordinary situations in road traffic. 2. Traffic psychology interview is conducted by psychologist who is holder of accreditation for conducting traffic psychology examination in scope of 4 hours. 3. Participant of traffic psychology interview shall submit to psychologist extract of their data from driver's register that is not older than 30 days. 4. About completion of traffic psychology interview, Psychologist issues confirmation. 5. Psychologist keeps records of conducted traffic psychology interviews, in which they record at least name, surname, residential address, and date of birth of traffic psychology, interview participant and date and time of commencement and completion of traffic psychology interview. Data about traffic psychology interview are kept by psychologist for at least 5 years from the day of its conduct. 6. Content of traffic psychology interview, method of its conduct, maximum number of traffic psychology interview participants and form of confirmation of its completion are established by implementing legal regulation. Division 2 Driving License Section 103, 1. A driving license is a public document that certifies the driving license of its holder and its scope, and by which the holder proves their name, surname, and appearance, as well as other data recorded in it according to this law. 2. A driving license must not be left or accepted as collateral and must not be taken away when entering buildings or premises. Section 104 Types of driving licenses. 1. In the Czech Republic, a Czech Republic driving license, hereinafter driving license, and an international driving license issued by the Czech Republic, hereinafter international driving license, are issued. 2. Driving license in the Czech Republic is certified by a. Driving license. B. Driving license issued by another member state. C. Driving license issued by foreign state according to Convention on Road Traffic, Vienna 1968, and Convention on Road Traffic, Geneva 1949, hereinafter. Driving license issued by foreign state. D. International driving license issued by foreign state according to Convention on Road Traffic, Vienna 1968, and Convention on Road Traffic, Geneva 1949, hereinafter international driving license issued by foreign state. E. Driving license issued by state other than member state that does not comply with requirements of Convention on Road Traffic, Vienna 1968, or Convention on Road Traffic, Geneva 1949, hereinafter driving license not complying with conventions. To which officially verified translation into Czech language and identification card issued by Ministry of Foreign Affairs, documenting that its holder enjoys privileges and immunities in the Czech Republic, according to international law or law on foreign service, are attached, if they are valid at the time of driving motor vehicle in the Czech Republic. 3. International driving license does not certify driving license in the Czech Republic. 4. International driving license issued by foreign state according to Convention on Road Traffic, Vienna 1968, is valid for driving motor vehicles in the Czech Republic for 3 years from the date of issue. International driving license issued by foreign state according to Convention on Road Traffic, Geneva 1949, is valid for driving motor vehicles in the Czech Republic for 1 year from the date of issue. 5. Implementing legal regulation shall establish form of driving license, international driving license and international driving license issued by foreign state, and requirements of driving license issued by foreign state. Section 105 Data recorded in driving license. 1. Driving license contains the following data: A. Name and surname of holder. B. Date and place of birth of holder. C. Birth number of holder if assigned. D. Photograph of holder. E. Signature of holder. F. Vehicle groups that holder is authorized to drive, and date of origin of driving license for each of these vehicle groups. G. Date of issue of driving license. H. Date of validity of driving license. I. Name and seat of office that issued driving license. J. Series and number of driving license. K. Records on conditioning, limitation or extension of scope of driving license or on professional competence of driver. 2. Upon request of holder of driving license, designation of graduate of higher professional school, hereinafter designation. Academic title, professional designation, other title of university graduate, hereinafter title. or scientific degree 3 may be recorded in driving license. If citizen obtained more designations, titles or scientific degrees, only one designation, one title or one scientific degree determined by citizen shall be recorded upon their proposal. 3. Driving license contains place for data chip into which machine-readable data about name of document, Code of Czech Republic as issuing state, name and surname of holder, number and series of driving license, vehicle groups that holder is authorized to drive, and about conditioning. Limitation or extension of scope of driving license, or about professional competence of driver, are recorded. 4. Implementing legal regulation shall regulate method of recording data according to paragraphs 1 and 2 in driving license and details about size and placement of place for data chip in driving license. Data recorded in International Driving License Section 106. 1. International Driving License contains the following data. A. Name and surname of holder. B. Date and place of birth of holder. C. Photograph of holder. D. Municipality of usual residence of holder in the Czech Republic. E. Vehicle groups that holder is authorized to drive. F. Date of issue of international driving license. G. Date of validity of international driving license. H. Name, seat and seal imprint of office that issued international driving license. I. Series and number of international driving license. J. Series and number of driving license based on which international driving license was issued. K. Records on conditioning or limitation of driving license. 2. Upon request of holder of driving license, designation, title or scientific degree may be recorded in international driving license. If citizen obtained more designations, titles or scientific degrees, only one designation, one title or one scientific degree determined by citizen shall be recorded upon their proposal. 3. Validity of international driving license is established identically with validity period of driving license based on which international driving license was issued. For maximum 3 years from the date of issue, if it concerns international driving license issued according to Convention on Road Traffic, Vienna 1968. And for 1 year from the date of issue, if it concerns international driving license issued according to Convention on Road Traffic, Geneva 1949. 4. Implementing legal regulation shall establish method of recording data according to paragraphs 1 and 2. Section 107. 1. If holder of international driving license issued by foreign state was imposed by court or competent administrative authority penalty of prohibition of activity consisting in prohibition of driving motor vehicles, or their driving license was conditioned or limited according to Section 93, or revoked according to Section 94 by final decision of municipal office with extended competence. Municipal office with extended competence shall record this fact in international driving license issued by foreign state. Municipal office with extended competence shall simultaneously notify this fact to authority of foreign state that issued international driving license. 2. Municipal office with extended competence competent to make record and notification according to paragraph 1 is municipal office with extended competence that issued decision on conditioning, limitation or revocation of driving license, or that imposed penalty of prohibition of activity consisting in prohibition of driving motor vehicles, or in whose territorial district is court that imposed penalty of prohibition of activity consisting in prohibition of driving motor vehicles. 3. Implementing legal regulation shall regulate method of recording penalty of prohibition of activity consisting in prohibition of driving motor vehicles, and record on conditioning, limitation or revocation of driving license in international driving license issued by foreign state and form and method of notification according to paragraph 1. Section 108. Change of data in driving license or international driving license. 1. Holder of driving license is obliged to notify change of data that are recorded in driving license to competent municipal office, with extended competence within 5 working days from the day when change occurred. 2. When data recorded in driving license change, competent municipal office with extended competence shall issue new driving license to holder of driving license. 3. Procedure according to paragraphs 1 and 2 is also followed in case of change of data recorded in international driving license. Issue of driving license section 109. 1. Driving license is issued to person who was granted driving license. 2. Driving license is also issued to holder of driving license. A. Whose driving license was extended for additional vehicle group. B. Whose driving license was conditioned or limited, or who renounced driving license for some vehicle group. C. Whose conditioning or limitation of driving license was cancelled according to Section 98 or Section 99. D. Whose driving license validity expires, or whose driving license is invalid according to Section 118, paragraph 1, letters A to E. E. Who applies for exchange of member state driving license. Driving license issued by foreign state, or driving license not complying with conventions for driving license. F. Who applies for issue of driving license due to change of data stated in driving license according to Section 108, or record of their professional competence. G. Who applies for issue of driving license in replacement of member state driving license that was lost, stolen, destroyed, or damaged. 3. Driving license is issued by competent municipal office with extended competence upon application of holder of driving license. 4. Basis for issue of driving license for holder of driving license, according to paragraph 2 letter B, is decision by which driving license was conditioned or limited. 5. Basis for issue of driving license for holder of driving license, according to paragraph 2 letter C, is decision on cancellation of conditioning or limitation of driving license, according to Section 98 and 99. 6. Basis for issue of driving license for holder of driving license, according to paragraph 2 letters B to G, is application for issue of driving license. 7. Application for issue of driving license according to paragraph 6 must be in written form and must state A. Name and surname of applicant. B. Address of usual residence of applicant in the Czech Republic or place of study. C. Date and place of birth and birth number of applicant if assigned. 8. The following must be attached to application for issue of driving license according to paragraphs 6 and 7. A. Valid identity document of applicant. B. Member state driving license. Driving license issued by foreign state, or driving license not complying with conventions for which exchange is requested, if it concerns issue of driving license according to paragraph 2 letter E. C. Damaged member state driving license. If it concerns issue of driving license according to paragraph 2 letter G. D. Document proving usual residence of applicant who does not have permanent residence in the Czech Republic, or proposal of other means of evidence to prove it. Documents proving usual residence of applicant are especially 1. Certificate of registration according to law on residence of foreigners in the Czech Republic. 2. Extract from real estate cadastre confirming ownership rights to real estate. 3. Lease agreement for real estate. 4. Employer's confirmation of employment. 5. Extract from trade register. E. Statutory declaration of applicant that another member state has not imposed on them prohibition of activity consisting in prohibition of driving motor vehicles, and their driving license has not been suspended or revoked, or that period for which prohibition of activity was imposed or period for re-granting driving license has already expired, if it concerns issue of driving license according to paragraph 2 letters E and G. If driving license was limited or conditioned by another member state to applicant. They shall state this fact, and scope of limitation or conditioning in statutory declaration. 9. After submitting application for issue of driving license, competent municipal office with extended competence shall immediately a. Verify according to identity document data according to paragraph 7 that are stated in it, and return identity document to applicant. B. Record from attached driving license, member state driving license issued by foreign state, or driving license not complying with conventions data necessary for issue of driving license, and return document to applicant. 10. Person who has permanent residence in the Czech Republic may submit application for issue of driving license according to paragraph 2 letters D or F. Also in manner enabling remote access through user interface established by ministry. In such case, applicant must be identified through means of electronic identification, according to legal regulations governing electronic identification, and paragraphs 8 and 9 are not used. 11. If application for issue of driving license is submitted according to paragraph 10, applicant shall simultaneously choose method of delivery of driving license through manner enabling remote access through user interface established by ministry, which may be delivery through distribution point or collection at competent municipal office with extended competence. In this manner, applicant also chooses date of commencement of validity of driving license. This does not apply in case of application for issue of driving license due to invalidity of existing driving license, when driving license becomes valid on the day of its issue. 12. If conditions for approval of application submitted by procedure according to paragraph 10 in full scope are not met, applicant is immediately informed in manner enabling remote access through user interface established by ministry and competent municipal office with extended competence does not process application. 13. Implementing legal regulation shall establish content and form of application for issue of driving license, details on delivery through distribution point and time range for choice of date of commencement of validity of driving license. Section 110. 1. Driving license is issued to holder of driving license by competent municipal office with extended competence. 2. If conditions for issue of driving license are met, competent municipal office with extended competence shall issue driving license no later than 20 days from the day of submitting application for issue of driving license. 3. Driving license issued according to paragraph 2 is valid for driving motor vehicles for period of a. 5 years from the day of its issue, if it also certifies driving license granted for Group C1, C1 plus E, C, C plus E, D1, D1 plus E, D or D plus E, B, 10 years from the day of its issue and other cases. 4. Exchange of driving license in case of expiration of its validity is performed free of charge. If holder of driving license applies for issue of driving license within deadline shorter than deadline specified in paragraph 2, driving license may be issued within 5 working days. 5. If driving license was not delivered through distribution point, holder of driving license is obliged to collect driving license personally or through authorized person based on power of attorney at municipal office with extended competence where they submitted application. Power of attorney must be recorded in information system of authorization for representation or signed with officially verified signature of principal. Holder of driving license is obliged when collecting driving license to surrender member state driving license issued by foreign state, or driving license not complying with conventions of which they are holder, if they did not surrender it earlier, or if they did not report its loss. Theft or destruction. 6. Holder of driving license must not have more than one valid driving license, member state driving license issued by foreign state, or driving license not complying with conventions. 7. Holder of driving license or other unauthorized person must not make any entries, changes, corrections, or modifications in driving license. 8. Implementing regulation shall regulate method of handling driving license forms when issuing driving licenses. Section 110. A driver card. 1. Competent municipal office with extended competence shall issue within 15 working days from the day of submitting application driver card according to directly applicable regulation of European Union governing tachographs in Road Transport 32, letter 1D47 right paren, to applicant who a. has usual residence in the Czech Republic, b. is holder of driving license, except for driving license for vehicle groups AM, A1, A2, or B1, and c. is not holder of valid driver card issued by Czech Republic. Another member state, or another contracting state of European agreement concerning the work of crews of vehicles engaged in international road transport, either. 2. If applicant for issue of driver card does not have permanent residence in the Czech Republic, they attach to application document proving usual residence according to Section 92, paragraph 4, letter D, or proposal of other means of evidence to prove it. If driving license according to paragraph 1, letter B, was not granted to applicant by Czech Republic, they attach driving license to application. If driving license was granted to applicant by Czech Republic, fulfillment of condition according to paragraph 1, letter B, is verified in driver's register. 3. Competent municipal office with extended competence shall issue according to directly applicable legal regulation of European Union governing tachographs in Road Transport 32, letter 1D47 right paren driver card in case of damage, loss, theft or expiration of validity period of driver card or arising of usual residence of driver in the Czech Republic. If a. conditions according to paragraph 1 letters A and B are met, and b. driver card was surrendered to competent municipal office with extended competence. If it concerns issue of driver card in case of damage of driver card or arising of usual residence of driver in the Czech Republic. 4. Application for issue of driver card due to expiration of validity period of driver card may be submitted no earlier than 2 months before expiration of its validity. 5. Holder of driver card is obliged to notify within 5 working days to competent municipal office with extended competence that change of data stated on it occurred, and surrender driver card within 2 months from the day of submitting this notification. 6. Person who has permanent residence in the Czech Republic and is holder of Czech Republic driving license may submit application for issue of driver card also in manner enabling remote access through user interface established by Ministry. In such case, applicant must be identified through means of electronic identification according to legal regulations governing electronic identification. If it concerns issue of driver card according to paragraph 1 or 3 due to loss or theft of driver card or expiration of its validity, applicant simultaneously chooses method of delivery of driver card through manner enabling remote access through user interface established by Ministry, which may be delivery through distribution point or collection at competent municipal office with extended competence. 7. If conditions for approval of application submitted by procedure according to paragraph 6 in full scope are not met, applicant is immediately informed in manner enabling remote access through user interface established by Ministry and competent municipal office with extended competence does not process application. 8. If applicant for issue of driver card simultaneously applies at same municipal office with extended competence for granting or extension of driving license, or for issue of driving license, municipal office with extended competence shall issue driver card simultaneously with driving license within deadline for issue of driver card, if conditions for this are met. 9. If driver card was not delivered through distribution point, applicant is obliged to collect it personally or through authorized person based on power of attorney at municipal office with extended competence where they submitted application. Power of attorney must be recorded in information system of authorization for representation or signed with officially verified signature of principal. 10. Data on issue of driver card and its surrender are recorded by municipal office with extended competence in information system of digital tachograph. 11. Details on delivery of driver card through distribution point are established by implementing legal regulation. Section 111. Issue of international driving license. 1. International driving license is issued to holder of driving license based on their application. 2. With application for issue of international driving license, holder of driving license must present a. Valid identity document of applicant, b. Valid driving license of applicant or valid driving license of applicant issued by foreign state. c. One photograph that corresponds in its execution to requirements of law on identity cards. 3. Holder of driving license has legal claim to issue of international driving license, certifying driving license, to drive motor vehicles in scope of their driving license, when conditions according to paragraph 2 are fulfilled. 4. International driving license is issued to holder of driving license by competent municipal office with extended competence. 5. If conditions for issue of international driving license are met, competent municipal office with extended competence shall issue international driving license immediately after submitting application for issue of international driving license. 6. Applicant for issue of international driving license is obliged to collect international driving license personally at competent municipal office with extended competence. 7. Holder of driving license must not have more than one valid international driving license issued according to Convention on Road Traffic, Vienna 1968, and more than one valid international driving license issued according to Convention on Road Traffic, Geneva 1949. 8. Holder of international driving license or other unauthorized person must not make any entries, changes, corrections, or modifications in international driving license. 9. Implementing legal regulation shall regulate method of handling international driving license forms when issuing international driving licenses. Section 113. Surrender of driving license and international driving license. 1. Holder of driving license whose driving license was conditioned, limited or revoked or suspended according to Section 95, or according to Execution Code, is obliged to surrender driving license to competent municipal office with extended competence within 5 working days from the day when decision on conditioning, limitation, revocation or suspension of driving license became final, or when execution order was delivered. 2. Invalid driving license must be disposed of without undue delay by its holder or surrendered to competent municipal office with extended competence, unless otherwise established in this law. This does not apply if they reported its loss, destruction, or theft. 3. In case of renunciation of driving license for some vehicle group or renunciation of driving license according to Section 94, Paragraph 2, holder of driving license is obliged to surrender driving license together with notification on renunciation of driving license for some vehicle group according to Section 93, Paragraph 3, or with notification on renunciation of driving license according to Section 94, Paragraph 3. 4. When surrendering driving license, competent municipal office with extended competence shall issue document on surrender of driving license. The document must state a. Name and surname of holder of driving license, b. Municipality of usual residence of holder in the Czech Republic, c. Date and place of birth and birth number of holder of driving license, d. series, number and date of issue of surrendered driving license. E. Date of surrender of driving license. 5. Paragraphs 1 to 4 also apply to surrender of international driving license. 6. Implementing legal regulation shall regulate procedure of municipal office with extended competence when surrendering driving license and international driving license. Handling surrendered driving licenses and international driving licenses, and establish form of document on surrender of driving license and international driving license. Section 114, Return of driving license and international driving license. 1. If it was decided on return of driving license according to Section 100, 101, 102 or 123d, or if suspension of driving license according to Section 95 was cancelled or lost effect, or if effective execution, order in execution by suspension of driving license ceased. Competent municipal office with extended competence shall return to holder of driving license surrendered according to Section 113, paragraph 1, or according to Section 123c immediately after decision on return of driving license or cancellation of suspension of driving license became final. After delivery of notification on cancellation of execution order or on termination of execution by suspension of driving license, or after suspension of driving license lost effect. Driving license is not returned if it is invalid. 2. Paragraph 1 also applies to return of international driving license. Section 115, Loss, Theft, Damage or destruction of driving license and international driving license loss, theft. Damage or destruction of valid driving license or international driving license must be reported immediately by holder of driving license to competent municipal office with extended competence. When reporting, they are obliged to prove their identity. Section 116, Exchange of Member State Driving License. Driving license issued by foreign state and driving license not complying with conventions. 1. Holder of valid member state driving license who has usual residence in the Czech Republic may request competent municipal office with extended competence to issue driving license in exchange for member state driving license. If municipal office with extended competence has doubts about validity of member state driving license or truthfulness of data stated in statutory declaration, according to Section 109, paragraph 8 letter E, it shall verify with competent authority of member state that issued member state driving license validity of this driving license, and whether applicant's driving license was not suspended or revoked. 2. Holder of valid member state driving license who has usual residence in the Czech Republic may request competent municipal office with extended competence to issue driving license in replacement of member state driving license that was lost, stolen, destroyed, or damaged. Applicant for issue of driving license in replacement of member state driving license that was lost, stolen, destroyed, or damaged shall provide to competent municipal office with extended competence all data necessary for issue of driving license. Municipal office with extended competence shall verify provided data with competent authority of member state that issued this member state driving license, and notify them of loss, theft, damage, or destruction of this driving license. 3. Holder of valid driving license issued by foreign state, who has permanent residence or temporary residence for period longer than 1 year in the Czech Republic, according to law on residence of foreigners in the Czech Republic 3.3, is obliged to request competent municipal office with extended competence to issue driving license in exchange for driving license issued by foreign state within 3 months from the day of return to Czech Republic if it concerns citizen of Czech Republic, or from the day when permanent residence or temporary residence for period longer than 1 year 3.3 was permitted if it concerns foreigner. 4. If holder of valid driving license not complying with conventions has usual residence in the Czech Republic, they may request competent municipal office with extended competence to issue driving license in exchange for this driving license. Competent municipal office with extended competence shall issue driving license if vehicle group stated in driving license not complying with conventions, or an international driving license issued by foreign state of which applicant is holder correspond to vehicle groups according to this law, and applicant successfully underwent re-examination of professional competence according to special legal regulation and proved medical fitness. Applicant attaches to application document on professional competence to drive motor vehicles classified in respective group and medical fitness assessment issued by assessing physician, which must not be older than 30 days on day of submitting application, and possibly international driving license issued by foreign state of which they are holder. 5. If holder of valid driving license not complying with conventions that was issued by state that recognizes driving licenses based on reciprocity, has usual residence in the Czech Republic, they may request competent municipal office with extended competence to issue driving license in exchange for this driving license. Competent municipal office with extended competence shall issue driving license if applicant proved medical fitness. Applicant attaches to application medical fitness assessment issued by assessing physician that must not be older than 30 days on day of submitting application. List of states that recognize driving licenses based on reciprocity and vehicle groups that correspond to vehicle groups according to this law are established by implementing legal regulation. 6. When exchanging driving license according to paragraphs 1 to 5, competent municipal office with extended competence shall record in driving license for vehicle groups that are identical with vehicle groups stated in exchanged driving license or an international driving license or correspond to these vehicle groups. If municipal office with extended competence has doubts about validity of driving license exchanged according to paragraphs 3 to 5, it shall verify its validity at diplomatic mission of state that issued this driving license. For issue of driving license according to paragraphs 1 to 5, Section 109, paragraphs 7 to 9, and Section 110 apply accordingly. 7. Competent municipal office with extended competence shall return exchanged driving license to state that issued it. Upon request of holder according to paragraph 3, 4, or 5, competent municipal office with extended competence shall store exchanged driving license until its re-exchange for issued driving license. 8. Obligation to exchange driving license issued by foreign state according to paragraph 3 does not apply to holder of identification card issued by Ministry of Foreign Affairs, documenting that they enjoy privileges and immunities in the Czech Republic, according to international law or law on foreign service. Section 117 Applications and notifications according to Section 92 to 94, Section 98 to 102, Section 108 to 111, Section 114 to 116, Section 123b paragraph 7, Section 123d and 123e may be submitted by applicant or holder of driving license, also by, in such case, signature of applicant or holder of driving license on application or notification in documentary form must be officially verified. Applicant or holder of driving license does not attach identity document. Section 118 Invalidity of driving licenses. 1. Driving license or international driving license is invalid if a. Its validity period expired, b. Data on driving license stated in it do not correspond to reality, c. Unauthorized entries, changes, corrections, or modifications were made in it, d. It is damaged so that records stated in it are illegible, e. Its loss, theft, damage, or destruction was reported, or F. New driving license issued to its holder became valid. 2. Driving license issued by foreign state, whose holder has permanent residence or temporary residence on long-term visa 3-3 for period longer than 1 year in the Czech Republic, does not authorize to drive motor vehicle in the Czech Republic, if this holder did not request exchange of driving license. Issued by foreign state for driving license according to Section 116, Paragraph 3. This does not apply if exception according to Section 116, Paragraph 8 applies to holder of driving license issued by foreign state. Division 3, Preventing Driving and Detention of Driving License, Section 118, A. Preventing driving. 1. Police officer may, when supervising safety and flow of road traffic, order driver of motor vehicle to drive to nearest suitable place for parking vehicle in terms of safety and flow of road traffic, and prevent them from driving using technical means, to prevent vehicle departure, hereinafter technical means, or by towing vehicle if, A. Their driver 1. Is suspected of having immediately before caused traffic accident in which death or serious injury to health of another person occurred. 2. Fled from scene of traffic accident in which they immediately before participated, and which they were obliged to report to police, according to Section 47, Paragraph 3, letter B. 3. Is suspected of having driven motor vehicle immediately after consuming alcoholic beverage or using other addictive substance, or during such time after consuming alcoholic beverage or using other addictive substance, when they were still under influence of alcohol or other addictive substance. 4. Refused, despite summons according to Section 5, Paragraph 1, letter F, to undergo examination according to special legal regulation to determine whether they are not influenced by alcohol. 5. Refused, despite summons according to Section 5, Paragraph 1, letter G, to undergo examination according to special legal regulation to determine whether they are not influenced by other addictive substance. 6. Drove motor vehicle without being holder of driving license for respective vehicle group, or 7. Drove motor vehicle, although court imposed penalty or administrative authority. 3. Imposed administrative penalty of prohibition of activity, consisting in prohibition of driving motor vehicles. Or B. Vehicle operation does not meet insurance liability condition according to law regulating liability insurance from vehicle operation, if it concerns vehicle whose operation is subject to obligation to conclude this insurance. 2. Police officer may, when supervising safety and flow of road traffic, prevent motor vehicle from driving using technical means or by towing vehicle, if A. There is reasonable suspicion that vehicle was stolen. B. Vehicle is technically unfit for road traffic. 3. Letter 1D43 right paren due to dangerous defect. 2. C. Driver refused to subject vehicle to roadside technical inspection. Or D. There is reasonable suspicion that vehicle was used in violation of Section 47A. 3. Road transport inspector may prevent motor vehicle from driving using technical means or by towing vehicle, if A. Vehicle is technically unfit for road traffic. 3. Letter 1D43 right paren due to dangerous defect. 2. Or B. Driver refused to subject vehicle to roadside technical inspection. 4. Police officer may, when supervising safety and flow of road traffic, prevent driving school vehicle from driving using technical means to prevent vehicle departure or by towing vehicle, if driving instructor A. Consumed alcoholic beverage or used other addictive substance during driving or immediately before driving or at such time before commencing driving that during driving they could still be under influence of alcohol or other addictive substance. B. Refused, despite summons according to Section 8, a Paragraph 2, letter A, to undergo examination according to special legal regulation to determine whether they are not influenced by alcohol. C. Refused, despite summons according to Section 8, A paragraph 2 letter B. To undergo examination according to special legal regulation to determine whether they are not influenced by other addictive substance. 5. Municipal police officer is obliged in cases specified in paragraphs 1 and 2 to call police, and driver is obliged to remain at place until police arrival. 6. Police officer or road transport inspector shall ensure prevention of vehicle driving at expense of driver or vehicle operator. 7. Police or road transport inspectorate shall ensure vehicle release if reasons for preventing vehicle driving ceased. If reasons for preventing driving were on driver's side, another competent driver may continue driving with vehicle. If prevention of driving occurred according to paragraph 2 letter C or paragraph 3 letter B, police or road transport inspectorate shall release vehicle no later than after 48 hours. If prevention of driving occurred according to paragraph 2 letter D, police shall release vehicle only when danger of its further use in violation of section 47A ceases, but no later than after expiration of 48 hours from prevention of driving. 8. Technical means to prevent driving cannot be used if vehicle would create traffic obstacle. 9. In case of incorrect procedure by police officer or road transport inspector, injured party may proceed according to Act No. 82/1998 Call on liability for damage caused in exercise of public power by decision or incorrect official procedure, and on amendment of Act No. 358/1992 Call on notaries and their activities, Notary Code. Detention of driving license section 118B. 1. Police officer may detain driving license if driver of motor vehicle is suspected of offense or crime committed by A. Driving vehicle immediately after consuming alcoholic beverage or after using other addictive substance, or during such time after consuming alcoholic beverage or using other addictive substance during which they were still under influence of alcohol or other addictive substance. B. Refusing despite summons according to Section 5 Paragraph 1 letters F or G to undergo examination whether when driving vehicle they were not influenced by alcohol or other addictive substance. C. Driving vehicle without being holder of driving license for respective vehicle group. D. When driving vehicle exceeding maximum permitted speed in municipality by 40 km/h or more or outside municipality by 50 km/h or more, or E. Causing traffic accident in which death or serious injury to health of another person occurred. 2. During detention of driving license, holder of driving license must not drive motor vehicle. 3. Police officer who detained driving license shall instruct holder of driving license about consequence of detention of driving license and issue to holder of driving license confirmation of detention of driving license. 4. Police shall notify in writing detention of driving license to municipal office with extended competence, competent according to place of committing act. Notification is sent together with detained driving license without undue delay, no later than following working day after day of detention of driving license. For driver who does not have residence in the Czech Republic, police sends detained driving license to municipal office with extended competence, competent according to place of committing act, which immediately sends it to competent authority of state that issued driving license. Police shall notify detention of driving license without undue delay also to municipal office with extended competence, competent for keeping data about driver in driver's register, which makes record about this in driver's register. 5. If driving license of member of intelligence service is detained, police shall notify in writing detention of driving license to competent authority. Notification is sent together with detained driving license without undue delay, no later than following working day from day of detention of driving license. 6. If there is reason for detention of driving license according to paragraph 1 and driver did not present it to police officer, police officer may declare this driving license as detained. Paragraphs 2 to 5 apply accordingly, with the fact that driving license is not attached to notification, and its holder has obligation to surrender it within 5 working days from day of its declaration, as detained to municipal office with extended competence, competent according to place of committing. Act 7. Form and requirements of confirmation of detention of driving license are established by implementing legal regulation. Section 118C. 1. Municipal office with extended competence competent according to place of committing act shall within 5 working days from day of delivery of notification on detention of driving license according to Section 118. B. Make act to commence proceedings on detention of driving license until final decision on offense or crime. This act may be issuing decision. If it concerns suspicion of committing crime, proceedings are commenced after prior consent of public prosecutor. Municipal office with extended competence shall not commence proceedings according to first sentence, or shall stop them if detention of driving license would be disproportionate considering circumstances under which it was detained according to Section 118b. 2. If municipal office with extended competence decided on detention of driving license, it shall notify this without undue delay to municipal office with extended competence, competent for keeping data about driver in driver's register, and hand over detained driving license for safekeeping. 3. Municipal office with extended competence shall return detained driving license without undue delay to its holder, if a. Proceedings according to paragraph 1 were not commenced or were stopped. B. In finally concluded proceedings on act for which driving license was detained, penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles was not imposed. Or C. Proceedings on act for which driving license was detained were not finally concluded, and from day of detention of driving license period elapsed for which 1. Penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles was imposed by decision issued in first instance of proceedings on this act, or 2. Penalty or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles may be imposed for this act. 4. Period of detention of driving license is counted into period of serving administrative penalty or penalty of prohibition of activity consisting in prohibition of driving motor vehicles, if this administrative penalty or penalty was imposed on driver for act for which driving license was detained. Chapter Roman 4 Drivers Register Section 119. 1. Records of data about drivers are kept in Drivers Register, which is information system whose administrator is municipal office with extended competence. Drivers Register is information system of public administration according to Special Law 3 Letter 1D43 right paren. 2. Drivers Register contains a. Personal data about motor vehicle driver stated in driving license and international driving license, including digitalized photograph and digitalized signature of driver. B. Records of issued driving licenses. C. Records of vehicle groups for which driving licenses were granted. D. Records of issued international driving licenses. E. Records of driving licenses issued in exchange for driving license issued by foreign state, member state driving license or driving license not complying with conventions. F. Records of surrendered driving licenses and international driving licenses. G. Records of committed offenses according to this law. H. Records of number of points achieved by driver in point evaluation, and records of point deduction. I. Data on revocation of driving licenses for loss of medical or professional competence to drive motor vehicles and their return. J. Data on prohibitions of activity consisting in prohibition of driving motor vehicles imposed by court for committed crimes or by administrative authority for committed offenses. On adequate restrictions consisting in refraining from driving motor vehicles, imposed in criminal proceedings, and data on commitment to refrain from driving motor vehicles, for purposes of conditional postponement of filing motion for punishment or conditional suspension of criminal prosecution. K. Records of lost, stolen, damaged, and destroyed driving licenses and international driving licenses. L. Records of manufactured and unissued international driving license forms. M. Records of issued driving licenses for licenses lost, destroyed, or unusable. N. Data on loss of driving license and data on return of driving license. O. Data on loss of right to drive motor vehicle in the Czech Republic for period of 1 year by reaching 12 points in point evaluation, if it concerns driver who is holder of member state driving license. Driving license issued by foreign state, international driving license issued by foreign state. P. Data on professional competence of driver and records of issued driver professional competence certificates according to special legal regulation. Q. Records of issued certificates for teaching and training instructors according to special legal regulation. R. Records of participation in regular driver training. S. Data on execution order and execution by suspension of driving license delivered to administrator of driver's register. T. Records of conducted traffic psychology examinations. U. Data on detention of driving license. And V. Data on mentor in scope of data stated in their driving license. Section 120. 1. In case of driver who is holder of driving license who does not have permanent residence or temporary residence on long-term visa 3-3 for period longer than 1 year in the Czech Republic. Driver's register is kept by municipal office with extended competence in whose administrative district act was first committed based on which driver was included in driver's register. 2. Records of committed offenses against road traffic safety. Records of revocation of driving license for loss of medical or professional competence, and records of prohibitions of activity consisting in prohibition of driving motor vehicles imposed by court or administrative authority are recorded in driver's register only after final validity of respective decisions. Respective decisions mentioned in previous sentence are obliged to be sent by authorities that issued them to municipal office with extended competence, competent according to place of permanent residence of citizen. Section 121 Data output from driver's register. 1. Competent municipal office with extended competence is authorized to provide data from driver's register based on written application only to a. State administration authorities in scope necessary for fulfilling their tasks. B. Courts of all levels. Public prosecutor offices of all levels. C. Authorities and organizations that are entrusted by special regulations to work with this data. For example, insurance company, for determining data about driver who was participant of traffic accident or caused such accident. D. Authorities active in criminal proceedings. E. Municipalities in scope necessary for their activity. F. Natural persons, if it concerns data kept about them. If they submit application through authorized person based on power of attorney. Power of attorney must be recorded in information system of authorization for representation, or signed with officially verified signature of principal. G. Other natural or legal persons based on written consent of person about whose data natural or legal person applies. Verified by competent authority. 2. Extract of data from driver's register is governed, unless otherwise established in this law, by Special Legal Regulation 3. Section 122 Central Register of Drivers. 1. Records of driver data collected from the Register of Drivers are maintained in a Central Register of Drivers. Hereinafter, Central Register, which is an information system administered by the Ministry. The Central Register is an information system of public administration according to special law. 2. The ministry processes data in the central register transferred by municipal offices with extended powers from the register of drivers in accordance with special law. 3. The ministry provides data from the central register based on written request only to subjects and under conditions specified in Section 121. 4. The ministry provides only those personal data of the driver from the central register that are maintained in the driving license, except for the birth number. 5. The Ministry of the Interior. General inspection of security forces, police, military police, municipal police. Offices of city districts determined by the statute of the capital city of Prague for dealing with offenses under this law and conducting proceedings on driving license retention. Courts, public prosecutors' offices, and the Security Information Service must have direct access to the central register of drivers. 6. The ministry provides from the central register through remote access to the Czech Insurers Bureau for the purposes of managing the user interface for creating a joint record of traffic accidents. Data according to Section 119 para. 2 letter A and J, and information on whether and for which vehicle groups the driver holds a driving license. 7. Extracts from data from the central register are governed by special legal regulation, unless this law provides otherwise. 8. Certified outputs from the Public Administration Information System are issued from the central register. Section 122b, the implementing legal regulation, establishes technical means and methods of data processing in the register of drivers and in the central register, and the method of transferring data from the register of drivers to the central register. Section 122c, Digital Tachograph Information System. 1. The Digital Tachograph Information System is an information system of public administration, administered by the ministry. 2. The Digital Tachograph Information System contains data on issued and surrendered driver cards, company cards, workshop cards, and control cards, which are a. Name and surname, business name or name of the card holder or other person indicated on the card and address of residence or registered office of the card holder, b. Date and place of birth and digitized photograph of the card holder, number of their driving license and information about the administrative body and state that issued it, in the case of a driver card, c. Data on the validity and status of the card and official procedures related to the card, d. Card number, e. Designation of the administrative body that issued the card, f. Digitized signature of the card holder, in the case of a driver card. 3. The ministry ensures remote and continuous access to data contained in the Digital Tachograph Information System to municipal offices with extended powers, regional offices, police, road transport inspection, customs authorities, and the Office for Technical Standardization. Metrology and state testing. 4. Data are maintained in the Digital Tachograph Information System for the purpose of exercising control and verifying conditions for issuing driver cards, company cards, workshop cards, or control cards for a period of 10 years from the end of the card's validity. 5. The ministry ensures automated exchange of data on driver cards and their holders through remote and continuous access. For this purpose, the ministry ensures a. Provision of data on driver cards and their holders from the Digital Tachograph Information System to the competent authority of another member state or another contracting state of the European Agreement concerning the work of crews of vehicles engaged in international road transport, EITER, based on its request, and b. Transmission of a request from a municipal office with extended powers, police, road transport inspection, or customs office for providing data on driver cards and their holders from the relevant register of another member state or another contracting state of the European Agreement concerning the work of crews of vehicles engaged in international road transport, either to the competent authority of that state and transmission of provided data to the competent municipal office with extended powers, police, road transport inspection, or customs office. 6. Data on driver cards and their holders may be requested and provided according to paragraph 5 only for the purposes of exercising control and verifying conditions for issuing driver cards. Section 122d(1). The Ministry ensures automated exchange of data on drivers, driving licenses, driving permits, and professional competence of drivers through remote and continuous access. For this purpose, the Ministry ensures a. Provision of data according to Section 119 para. 2 letters A, B, C, E, F, I, J, K, M, N, O, P, R, or S from the Central Register to the competent authority of another member state based on its request, and B. Transmission of a request from a municipal office with extended powers or police for providing data according to letter A from the relevant register of another member state to the competent authority of that member state, and transmission of provided data to the competent municipal office with extended powers or police. 2. Data on drivers, driving licenses, driving permits, or professional competence of drivers may be requested and provided only for the purposes of exercising control and conducting administrative proceedings concerning driving licenses, driving permits, or professional competence of drivers. Section 123. Traffic Accident Records. 1. Traffic accident records are maintained by the police. 2. Traffic accident records contain a. Data on participants in traffic accidents. B. Data on vehicles that were involved in traffic accidents. C. Data on the place and time of traffic accidents. D. Data on causes of traffic accidents. 3. For the provision of data from traffic accident records, the provisions of Section 121 apply accordingly. 4. The implementing legal regulation establishes the method of maintaining records in traffic accident records and details on data maintained in traffic accident records. Chapter V. Point Assessment of Violations of Obligations established by law. Section 123. A point assessment ensures monitoring of repeated commission of offenses, conduct that has characteristics of an offense under other legal regulation, or criminal offenses committed by violating selected obligations established by regulations on road traffic by a motor vehicle driver, or that the driver does not commit violations of these obligations. The overview of conduct consisting in violation of selected obligations established by regulations on road traffic, and the number of points for such conduct, is established in the annex to this law. Assessment of points. Section 123b. 1. A motor vehicle driver who has been imposed an administrative penalty for an offense, or for conduct of a soldier designated as an offense in special legal regulation by the competent administrative body, or who has been imposed a disciplinary penalty for conduct having characteristics of an offense, or who has been imposed a punishment by a court for a criminal offense, or whose criminal prosecution was conditionally suspended, or who was subject to conditional postponement of filing a motion for punishment, and the offense, conduct of a soldier designated as an offense in special legal regulation, conduct having characteristics of an offense, or criminal offense for which the punishment was imposed or for which criminal proceedings were conducted, was committed by conduct classified in the point assessment, shall have the established number of points recorded in the Register of Drivers. 2. The record in the Register of Drivers is made by the competent municipal office with extended powers on the day of legal validity of the decision on imposing an administrative penalty for an offense, or for conduct of a soldier designated as an offense in special legal regulation. Decision on imposing a disciplinary penalty for conduct having characteristics of an offense, or decision imposing punishment for a criminal offense, or on the day of legal validity of a decision on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution, and that no later than 5 working days from the day when it was delivered. A. Notification of imposing a fine for an offense by order on the spot. B. Decision on imposing an administrative penalty for an offense, or for conduct of a soldier designated as an offense in special legal regulation, or decision on imposing a disciplinary penalty for conduct having characteristics of an offense. Or C. Decision by which punishment was imposed for a criminal offense. D. Decision on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. 3. The notification or decisions specified in paragraph 2 shall be delivered to the competent municipal office with extended powers by A. Police, municipal police, road transport inspection, or military police, in the case of notifications specified in paragraph 2 letter A, within 3 working days from the day of imposing the fine by order on the spot. B. The body that imposed the administrative penalty for an offense, or for conduct of a soldier designated as an offense in special legal regulation or penalty for a disciplinary offense in first instance proceedings. In the case of decisions specified in paragraph 2 letter B, within 1. 5 working days from the day the decision became legally valid, if the decision became legally valid in first instance proceedings, or 2. 5 working days from the day it received the decision accompanied by a clause of legal validity from the body that dealt with the matter in second instance proceedings. C. Court or public prosecutor who decided in first instance proceedings. In the case of decisions specified in paragraph 2 letters C and D, within 1. 5 working days from the day the decision became legally valid, if the decision became legally valid in first instance proceedings, or 2. 5 working days from the day it received the decision accompanied by a clause of legal validity from the body that dealt with the matter in second instance proceedings. 4. The notifications or decisions specified in paragraph 2 are considered delivered on the day the competent municipal office with extended powers receives them. If the decision is not accompanied by a clause of legal validity, it is considered undelivered. Instead of the decision, a notification of the decision becoming legally valid may be delivered, which is to be delivered. If the notification, according to the third sentence, does not contain data necessary for making a record in the register of drivers, the municipal office with extended powers requests delivery of the decision. 5. The competent municipal office with extended powers issues an extract from the register of drivers on the driver's point assessment records upon the driver's request. 6. A public administration contact point issues a certified output from the register of drivers on the driver's point assessment records upon the driver's request, according to special legal regulation. 7. Upon a driver's request submitted to the competent municipal office with extended powers, information about each change in their point assessment is sent to the driver. The request may also be submitted through remote access via a user interface established by the ministry. In this case, the applicant must be identified through electronic identification means according to legal regulations governing electronic identification. 8. In the case of a driver who is a member of an intelligence service, paragraphs 1 to 4 do not apply. 9. The method of sending information about each change in point assessment is established by implementing legal regulation. Section 123C. 1. The competent municipal office with extended powers records points achieved by the driver only up to a total of 12 points. 2. If a driver committed multiple offenses or criminal offenses committed by conduct classified in point assessment and dealt with in joint proceedings, the competent municipal office with extended powers records the number of points established for the most serious of them. 3. The competent municipal office with extended powers when making a record of points by which the driver reached a total of 12 points. Immediately notifies this fact to the driver in writing or electronically, and calls upon them to surrender the driving license and international driving license no later than 5 working days from the day of delivery of this notification. The driver loses driving authorization upon the expiration of 5 working days from the day this notification was delivered to them. If the driver reached a total of 12 points by recording points for an act for which they lost driving authorization according to Section 94A, the day of losing driving authorization is considered the day when driving authorization was lost according to Section 94A. 4. The competent municipal office with extended powers, when making a record of points by which a driver who is a holder of a driving license of a member state, driving license issued by a foreign state, international driving license issued by a foreign state, reached a total of 12 points. Immediately notifies this fact in writing to the driver and to the ministry. 5. A driver who reached a total of 12 points is obliged to comply with the summons according to paragraph 3. 6. For surrendering the driving license and international driving license according to paragraph 3, Section 113 para. 4 applies accordingly. 7. If a driver who is a holder of a driving license of a member state, driving license issued by a foreign state, international driving license issued by a foreign state reaches a total of 12 points, they lose the right to drive a motor vehicle on the territory of the Czech Republic for a period of 1 year. The ministry communicates this fact to the body that issued the driving license after receiving documents sent by the competent municipal office with extended powers. 8. The 1-year period specified in paragraph 7 begins to run from the day of legal validity of the decision on an offense or criminal offense committed by conduct classified in point assessment, based on which the driver reached a total of 12 points. 9. On the day of losing driving authorization according to paragraph 3 or the right to drive a motor vehicle according to paragraph 7. The competent municipal office with extended powers records in the register of drivers the deduction of all achieved points. Points for conduct classified in point assessment by which an offense or criminal offense was committed before the day of losing driving authorization according to paragraph 3 or the right to drive a motor vehicle according to paragraph 7. Recorded in the register of drivers after the day of losing driving authorization according to paragraph 3 or the right to drive a motor vehicle according to paragraph 7 are not taken into account. However, points recorded in the case according to paragraph 3 last sentence are taken into account. 10. If a driver who reached a total of 12 points is not a holder of driving authorization, the competent municipal office with extended powers records in the register of drivers on the day of making the record of points by which the driver reached a total of 12 points, the deduction of all achieved points. Section 123D Return of driving authorization. 1. A driver who lost driving authorization according to Section 123C para. 3. Is entitled to request return of driving authorization no earlier than after the expiration of 1 year from the day of losing driving authorization according to Section 123C para. 3. 2. If a driver was imposed a punishment or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles for an offense or criminal offense committed by conduct classified in point assessment, based on which they reached a total of 12 points, the driver is entitled to request return of driving authorization no earlier than after serving the punishment or administrative penalty of prohibition of activity, if the imposed period of prohibition of activity is longer than the period according to paragraph 1. 3. An application for return of driving authorization is submitted in writing by the applicant to the competent municipal office with extended powers. A condition for return of driving authorization is proving that the applicant successfully underwent re-examination of professional competence according to special legal regulation, and further proving health and psychological fitness. If the applicant has an obligation according to Section 102F, proving completion of traffic psychological interview and training for beginning drivers according to special legal regulation, is also a condition for return of driving authorization. For return of driving authorization, Section 101 applies accordingly. 4. Driving authorization cannot be returned to a person who reached 12 points in point assessment in the preceding one-year period. Section 123E point deduction. 1. For a driver who has not been legally imposed an administrative penalty for an offense, or for conduct of a soldier designated as an offense in special legal regulation, disciplinary penalty for conduct having characteristics of an offense, or punishment for a criminal offense committed by conduct classified in point assessment since the day of legal validity of the decision based on which the established number of points was last recorded in the Register of Drivers. A. After a period of 12 consecutive calendar months. 4 points are deducted from the total number of achieved points. B. After a period of 24 consecutive calendar months, 4 points are deducted from the total number of achieved points remaining after deduction of points according to letter A. C. After a period of 36 consecutive calendar months, all remaining points are deducted. On this day, the competent municipal office with extended powers makes a record in the Register of Drivers of deducting points from the achieved number of established points to the driver, no later than 3 working days from the day the driver's right to point deduction arose. 2. Points that were recorded based on a legally valid decision on A. An offense or criminal offense after legal cancellation of this decision, or B. Conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. If in criminal proceedings in which proceedings continued, the driver was not convicted of a criminal offense committed by conduct classified in point assessment, are also deducted from the driver. 3. During the period of serving punishment or administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles, or during the period of fulfilling the commitment to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. The period for point deduction, according to paragraph 1, does not run. 4. The competent municipal office with extended powers also makes a record in the Register of Drivers of deducting 4 points from the achieved number of points to a driver who submitted a written application for point deduction, and A. Documented the application with confirmation of completed safe driving training at a safe driving center according to special legal regulation, which is not older than 1 month from submission of the application, and B. Did not have more than 10 points recorded in the Register of Drivers on the day of completion of safe driving training at the safe driving center for violation of legal regulations, assessed with less than 6 points. 5. The competent office with extended powers makes a record of point deduction on the day of completion of training at the safe driving center, no later than 3 working days from submission of the application. The competent office with extended powers may make a record of point deduction to a driver based on confirmation of completed safe driving training only once per calendar year. Section 123F. 1. If a driver disagrees with a point record made in the Register of Drivers, they may file written objections against making the record to the municipal office with extended powers competent to make the record. 2. If the municipal office with extended powers finds the objections justified, no later than 10 working days from the day the objections were delivered, it corrects the record of the achieved number of established points in the Register of Drivers, and immediately notifies the driver in writing of the correction made to the record. 3. If the competent municipal office with extended powers finds the driver's objections unjustified, it rejects the objections by decision and confirms the made record. Issuing the decision may be the first act of the administrative body in proceedings. 4. If a driver files objections against a point record after reaching a total of 12 points, the running of periods established in Section 123, see para. 3 is interrupted from the day of delivery of objections to the competent municipal office with extended powers, until the day the decision according to paragraph 3 becomes legally valid. Chapter VI State Administration Section 124 Competence. 1. State administration in matters of road traffic is exercised by the Ministry, which is the central body of state administration in matters of road traffic, regional office, municipal office with extended powers, Ministry of the Interior. Police and road transport inspection. 2. The Ministry. A. Grants exceptions according to Section 43 para. 5 or 6. B. Establishes after written statement from the Ministry of the Interior, local and temporary regulation of road traffic on highways and use of operational information equipment on highways. C. Decides on appeals against decisions of regional offices issued according to this law. D. Maintains the central register of drivers and digital tachograph information system. E. Ensures production and distribution of driving licenses, international driving licenses, and other documents established by this law, including delivery of driving licenses through distribution points. F. Ensures production and distribution of driver cards, including delivery of driver cards through distribution points. G. Conducts prevention in the field of road traffic safety. H. Upon request of the competent body of another member state verifies and communicates data on validity and scope of driving authorizations. 3. The Ministry or a person authorized by it ensures public information about situations in road traffic that affect safety and smooth flow of road traffic. For this purpose, police, municipal police, road administrative authorities, road administrators and fire rescue service of the Czech Republic are obliged to provide current information to the Ministry that affects safety and smooth flow of road traffic. Implementing legal regulation establishes the type of information affecting safety and smooth flow of road traffic, method of information transfer, method of information collection, and method of information publication for the needs of the traffic public. 4. Regional office. A. Grants exceptions according to Section 43 para. 5. B. Establishes local and temporary regulation of road traffic on Class I roads and use of operational information equipment on Class I roads. The competent regional office is the one in whose territorial district the Class I road is located. C. Conducts prevention in the field of road traffic safety. 5. Municipal office with extended powers. A. Authorizes persons entitled to stop vehicles according to Section 79 para. 1 letter K. B. Grants conditions, limits, withdraws and returns driving authorization, and cancels conditioning or limitation of driving authorization. C. Orders review of health fitness of the driving authorization holder. D. Orders re-examination of professional competence of the driving authorization holder. E. Issues and exchanges driving licenses and international driving licenses. F. Exchanges driving licenses of member states. Driving licenses issued by foreign states, and driving licenses not corresponding to conventions according to Section 116. G. Records in international driving licenses issued by foreign states facts according to Section 107, and reports them to the body of the foreign state that issued this international driving license. H. Maintains register of drivers and issues data from register of drivers. I. Issues driver cards and accepts surrendered driver cards. J. Issues special vehicle markings according to Section 67. K. Deals with offenses according to this law and conducts proceedings on driving license retention. L. Makes records in the register of drivers of numbers of points achieved by drivers in point assessment and of point deduction. M. Deals with objections and decides on the record of the number of points achieved by a driver in point assessment. N. Conducts prevention in the field of road traffic safety. O. Informs the body active in criminal proceedings that decided on conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution about 1. Surrender of driving license by the driving license holder who committed to refrain from driving motor vehicles for the purposes of this conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution. 2. Application for driving authorization by a person who committed to refrain from driving motor vehicles for the purposes of conditional postponement of filing a motion for punishment or conditional suspension of criminal prosecution, submitted during the performance of this commitment. Simultaneously, the municipal office with extended powers informs the body active in criminal proceedings whether the applicant documented professional competence. 6. Municipal office with extended powers establishes local and temporary regulation of road traffic on Class Roman II and Roman III roads, local roads and publicly accessible purpose roads, and use of operational information equipment on Class Roman II and Roman III roads, local roads and publicly accessible purpose roads. The competent municipal office with extended powers is the one in whose territorial district the road is located. 7. Any municipal office with extended powers is competent for a. Conducting proceedings on 1. Granting or extending driving authorization 2. Issuing driving license or international driving license 3. Exchanging driving license of member state, driving license issued by foreign state or driving license not corresponding to conventions. B. Accepting surrender of driving authorization according to Section 93 para. 2 letter C or Section 94 para. 2. Accepting notification of changes to data in driving license or international driving license. Accepting report of loss, theft, damage or destruction of driving license or international driving license and other related acts. C. Providing data from register of drivers or issuing extract from register of drivers on records of drivers' point assessment. D. Issuing driver card and accepting surrendered driver card and E. Recording mentor in register of drivers and canceling this record upon request of 17-year-old driver. 8. Municipal office with extended powers that conducted proceedings or performed an act according to paragraph 7 records related data in register of drivers. 9. For activities specified in chapters Roman III, Roman IV and V of this law, which are performed by municipal office with extended powers, except for activities specified in paragraph 7 or 8. The competent municipal office with extended powers is the one in whose territorial district the usual residence of the applicant for driving authorization, applicant for return of driving authorization, holder of driving authorization or holder of driving license is located, or in the case of persons without usual residence on the territory of the Czech Republic, place of study. For canceling mentor record according to Section 83A para. 6 letter B. The competent municipal office with extended powers is the one in whose territorial district the mentor's usual residence is located. If the mentor does not have usual residence on the territory of the Czech Republic, the competent one is the municipal office with extended powers that made the first record of data about this person in register of drivers. 10. Ministry of the Interior cooperates with the Ministry in conducting prevention in the field of road traffic safety. 11. Police exercises supervision over safety and smooth flow of road traffic by a. controlling compliance with obligations of participants and rules of road traffic and participates in its management. B. Investigating traffic accidents. C. Maintaining traffic accident records. D. Dealing with offenses according to this law by order on the spot. E. Conducting prevention in the field of road traffic safety. 12. In supervising safety and smooth flow of road traffic, police officers are authorized in particular to A. Give instructions for road traffic management. B. Stop vehicles. C. Prevent driving by a driver according to Section 118A. D. Retain driving license according to Section 118B. E. Prohibit driving for the necessary time or order direction of travel if required by safety and smooth flow of road traffic or other public interest. F. Call upon driver. Mentor and driving school instructor for examination according to special legal regulation to determine whether they are not under the influence of alcohol. G. Call upon driver. Mentor and driving school instructor for examination according to special legal regulation to determine whether they are not under the influence of other addictive substance. H. Call upon motor vehicle driver to present documents for driving and vehicle operation. I. Call upon vehicle driver to subject the vehicle to roadside technical inspection, inspection of cargo placement, fastening or securing, inspection of vehicle or vehicle train weight, inspection of vehicle weight ratio in vehicle train, inspection of weight distribution on axles, axle groups, wheels or wheel groups, inspection of vehicle or vehicle train dimensions including cargo or inspection of compliance with vehicle connectivity conditions in vehicle train. J. Decide on vehicle removal if it is an obstacle to road traffic, according to procedure under Section 45 para. 4. Or vehicle that unlawfully stands in reserved parking. K. Use technical means to prevent vehicle departure according to special legal regulation. L. Collect deposits according to Section 124A. M. Retain vehicle registration certificate according to Section 6B. N. Secure vehicle or retain vehicle registration plates according to Section 124C. 13. Road Transport Inspection conducts roadside technical inspections, controls compliance with driving restrictions for certain vehicles, and controls cargo placement, fastening, and securing. 14. Road transport inspectors are authorized in particular to A. Stop vehicles. B. Call upon motor vehicle driver to present documents for driving and vehicle operation. C. Call upon vehicle driver to subject the vehicle to roadside technical inspection, inspection of cargo placement, fastening or securing, inspection of vehicle or vehicle train weight, inspection of vehicle weight ratio in vehicle train, inspection of weight distribution on axles, axle groups, wheels or wheel groups, inspection of vehicle or vehicle train dimensions including cargo or inspection of compliance with vehicle connectivity conditions in vehicle train. D. Retain vehicle registration certificate according to Section 6B. E. Prevent driving by a driver according to Section 118A. F. Collect deposits according to Section 124A. G. Secure vehicle or retain vehicle registration plates according to Section 124C. 15. Municipal police may deal with an offense according to Section 125C para. 1 letter F, points 1, 3 to 14 and 17, and Section 125C para. 1 letter G, by order on the spot. Municipal police may further deal with an offense according to this law committed by order on the spot. A. By violating local or temporary road traffic regulation. B. By unauthorized stopping or standing of vehicle on road. C. By using reserved lane in violation of Section 14 para. 1. Or failing to fulfill obligations established in Section 14 para. 2. D. By exceeding maximum permitted speed by less than 10 km/h. By violating rules for walking, cycling, driving non-motorized vehicles, riding animals, leading and driving animals, or using personal transporter. F. By violating obligation of transported person who may actively participate in vehicle ride. During ride or immediately, before its start, not to consume alcoholic beverage or not use other addictive substance. Or not start ride at such time after consuming alcoholic beverage or using other addictive substance when they could still be under influence of alcohol or other addictive substance. Or G. By violating rules for traffic in residential, pedestrian, cycling, or shared zones. 16. Military police may deal with an offense according to this law by order on the spot if it concerns a person conducting training of drivers of armed forces vehicles, or a person against whom it performs acts according to Section 9 of the Military Police Act, except for soldiers in active service. 17. Road transport inspection may deal with an offense according to Section 125C para. 1 letter A, point 3, letter B, or letter F, point 16, or offense according to Section 125C para. 1 letter K, detected during roadside technical inspection or cargo placement, fastening or securing inspection by order on the spot. Section 124, a deposit collection. 1. A police officer supervising safety and smooth flow of road traffic or road transport inspector is authorized to collect a deposit ranging from 3,500 CZK to 75,000 CZK from a driver suspected of committing an offense according to this law. If there is reasonable suspicion that they will avoid proceedings on the offense, or that possible enforcement of imposed fine would be associated with disproportionate costs, or would not be possible at all. 2. When determining the amount of deposit, the seriousness, significance, and duration of unlawful conduct and scope of damage caused are considered. The amount of deposit must not exceed the maximum fine that can be imposed for the given offense. 3. When collecting deposit, police officer or road transport inspector instructs the driver about the purpose of deposit collection and conditions for its return and issues confirmation of deposit collection, which must state the reason for deposit collection, its amount, and administrative body competent to conduct proceedings on the offense. 4. Police officer or road transport inspector keeps 1 copy of confirmation of deposit collection for record purposes of police or road transport inspection, gives 1 copy to the driver, and gives 1 copy together with deposit to the administrative body competent to conduct proceedings on the offense no later than within 2 working days. 5. Deposit cannot be collected from a person A. enjoying immunities and privileges according to law or international law, or B. whose conduct having characteristics of offense is not dealt with according to the law on offenses. Section 124B Deposit Return, Set-off, and Forfeiture. 1. Deposit is returned in full amount if the matter was dismissed, proceedings on offense were stopped, or no fine was imposed in proceedings on offense. This does not apply if deposit is forfeited. 2. If fine and obligation to pay proceedings costs are imposed on driver in proceedings on offense, administrative body decides on set-off of deposited amount against payment of imposed fine and proceedings costs. If collected deposit is higher than imposed fine and proceedings costs, the part of deposit remaining after set-off against payment of imposed fine and proceedings costs is returned to the driver. 3. If deposit or its part is being returned, an administrative body does not know data about bank account to which deposit or its part can be returned, administrative body immediately calls upon driver to communicate these data or to collect deposit or its part. The summons is delivered to own hands. 4. Regardless of whether the summons according to paragraph 3 was successfully delivered, deposit or its part is forfeited if within 1 year from the day of sending the summons, it was not collected and necessary data about bank account to which it can be returned were not communicated to administrative body. 5. Forfeited deposit is revenue of the budget from which activity of administrative body competent to conduct proceedings on offense is financed. Section 124C Vehicle Securing and Registration, Plate Retention. 1. If police officer or road transport inspector is authorized to collect deposit, and driver does not deposit it upon request, police officer or road transport inspector orders driver to drive to the nearest place suitable for vehicle parking from the point of view of safety and smooth flow of road traffic, and a. secures vehicle using technical means or by its towing, or b. prohibits continuing in ride and retains vehicle registration plates. If vehicle driver refuses to give them upon request of police officer or road transport inspector, they remove registration plates. 2. Costs connected with procedure according to paragraph 1 and damage to vehicle caused by removal of registration plates go to the driver's account. Responsibility of driver or vehicle operator for vehicle, cargo, or transported persons is not affected by procedure according to paragraph 1. 3. In procedure according to paragraph 1, police officer or road transport inspector instructs driver about conditions for vehicle release or return of vehicle registration, plates, and issues confirmation of vehicle securing or vehicle registration plate retention. In confirmation, they state reason for securing or retention, reason for deposit imposition, and its amount, and administrative body competent to conduct proceedings on offense. Police officer or road transport inspector keeps 1 copy of confirmation for record purposes of police or road transport inspection, gives 1 copy of confirmation to driver, sends 1 copy of confirmation to vehicle operator if it is not the same person, and sends 1 copy of confirmation within 2 working days to administrative body competent to conduct proceedings on offense. 4. In case of vehicle securing or vehicle registration plate retention, deposit can be deposited with body in whose competence this act was performed, or with administrative body competent to conduct proceedings on offense. Body that collected deposit issues confirmation to driver. Section 124A para. 3 applies to confirmation content accordingly. Police or road transport inspection transfers confirmation of deposit collection together with deposit no later than within 2 working days to administrative body competent to conduct proceedings on offense. About deposit at administrative body competent to conduct proceedings on offense. This administrative body immediately informs body in whose competence act according to paragraph 1 was performed. 5. If there is no other reason for vehicle securing or vehicle registration plate retention, police or road transport inspection immediately releases secured vehicle or returns retained vehicle registration plates to driver or their operator if a. deposit was deposited, b. matter was dismissed, proceedings on offense were stopped, or no fine was imposed in proceedings on offense, or c. fine imposed in proceedings on offense, and proceedings costs were paid. 6. If police or road transport inspection did not return retained vehicle registration plates within 3 years from the day of their retention, these plates are no longer returned to driver or vehicle operator, and police or road transport inspection transfers them to administrative body competent to maintain vehicle register or to foreign state that issued them. 7. About retention or return of vehicle registration plates of vehicle registered in Register of Road Vehicles, police or road transport inspection informs ministry through remote and continuous access. Section 125B State Professional Supervision and Supreme State Professional Supervision. 1. State Professional Supervision and Supreme State Professional Supervision, hereinafter State Supervision. Over-exercise of competencies in road traffic matters according to this law and special legal regulation, hereinafter exercise of competencies, are exercised by regional offices and ministry. 2. Ministry exercises supreme state professional supervision over exercise of competencies, by municipal offices with extended powers, regional offices, and road transport inspection. 3. Authorization for exercise of state professional supervision or supreme state professional supervision in road traffic matters in form of identification card is issued by administrative body into whose competent supervision exercise falls. Requirements for identification card and its template are established by implementing legal regulation. Offenses Section 125 see Offenses of natural persons. 1. Natural person commits offense by in road traffic, a driving vehicle, 1. On which, in violation of Section 5 para. 2 letter K, registration plate is not placed or registration plate that was not assigned to vehicle is placed 2. Whose registration plate is, in violation of Section 5 para. 2 letter L, covered, illegible or modified or placed so that its readability is prevented or substantially hindered 3. Which is technically unfit for road traffic due to dangerous defect or 4. Whose vehicle registration certificate was retained or declared retained according to Section 6b and technical inspection protocol according to Section 6c para. 1 was not issued, b, in violation of Section 6a para. 2. During roadside technical inspection, does not drive to equipment for conducting technical condition inspection, or does not follow instructions of person operating this equipment. C. In violation of Section 5 para. 2 letter B. Drives vehicle or rides animal immediately after consuming alcoholic beverage or using other addictive substance, or at such time after consuming alcoholic beverage or using other addictive substance during which they are still under influence of alcohol or other addictive substance. D. In violation of Section 5 para. 1 letters F or G refuses to undergo examination whether during vehicle driving or animal riding they were not under influence of alcohol or other addictive substance. E. Drives motor vehicle and 1. In violation of Section 3 para. 3 letter A is not holder of driving authorization for appropriate vehicle group 2. Their driving license was retained according to Section 118b para. 1 or was declared retained according to Section 118b para. 6. 3. In violation of Section 3 para. 4 is not professionally competent for its driving according to special legal regulation or based on decision of competent body of another member state or Swiss Confederation. 4. As holder of driving license of member state, driving license issued by foreign state or international driving license issued by foreign state, lost right to drive motor vehicle on territory of Czech Republic according to Section 123c para. 7. Or is serving administrative penalty or punishment of prohibition of activity consisting in prohibition of driving motor vehicles. 5. Their driving authorization was suspended according to Section 95 or by execution order according to Execution Code, or 6. In violation of Section 83a para. 1 does not have mentor escort, F, when driving vehicle. 1. In violation of Section 7 para. 1 letter C holds in hand or in another way telephone device or other speech or recording device. 2. Exceeds maximum permitted speed in municipality by 40 km/h and more or outside municipality by 50 km/h and more. 3. Exceeds maximum permitted speed in municipality by 20 km/h and more or outside municipality by 30 km/h and more. 4. Exceeds maximum permitted speed by 10 km/h and more. 5. In violation of Section 4 letters B or C, does not stop vehicle at signal that orders them to stop vehicle, or at instruction to stop vehicle given by person authorized for road traffic management or guidance, or for supervision of safety and smooth flow of road traffic. 6. In violation of Section 5 para. 2 letter F endangers or restricts pedestrian crossing, road on pedestrian crossing, or does not stop vehicle before pedestrian crossing in cases where they are obliged to do so, or in violation of Section 5 para. 2 letter G, endangers pedestrian crossing road to which they are turning, or endangers pedestrian when turning to place lying outside road, when entering road or when turning or reversing. 7. Overtakes vehicle in case when it is prohibited by general, local, or temporary road traffic regulation. 8. Does not give way when obliged to do so. 9. In violation of Section 29 para. 1. Enters railway crossing in case when it is prohibited. 10. Drives in opposite direction on highway or road for motor vehicles or in violation of Section 36 para. 1 letter B. Turns or reverses. 11. In violation of Section 67 para. 4. Unlawfully marks vehicle with parking permit for persons with health disabilities, or in violation of Section 67 para. 8. Unlawfully stands with vehicle in parking reserved for vehicle marked with parking permit for persons with health disabilities. 12. In violation of Section 6 para. 1 letter A. Is not fastened to seat with safety belt or when transporting child does not use child car seat or safety belt according to Section 6 para. 1. 13. In violation of Section 6 para. 1 letter H. Does not have protective helmet properly placed and fastened on head when riding motorcycle or moped. 14. In violation of Section 12 para. 5, 6 or 7 when changing from one lane to another endangers driver driving in lane to which they are changing. 15. In violation of Section 4 letter B, disobeys driving prohibition or direction order according to Section 124 para. 12 letter E. 16. In violation of Section 43, violates driving restrictions for certain vehicles. 17. Violates prohibition of vehicle stopping or standing and thereby causes obstacle to road traffic. 18. In violation of Section 21 para. 1. When turning at intersection, or to place lying outside road endangers driver driving behind them. Or 19. With vehicle or vehicle train with maximum permitted weight exceeding 12,000 kg violates entry prohibition established by local or temporary road traffic regulation. G. As transported person in violation of Section 9 para. 1 letter A. Is not fastened to seat with safety belt during ride or in violation of Section 9 para. 1 letter B. Does not have protective helmet properly placed and fastened on head when riding motorcycle or moped. H. As mentor. 1. In violation of Section 83 a para. 8. Does not sit in seat next to driver or does not monitor situation in road traffic and driver behavior. 2. In violation of Section 83 a para. 9. Performs escort immediately after consuming alcoholic beverage or using other addictive substance, or at such time after consuming alcoholic beverage or using other addictive substance, when they could still be under influence of alcohol or other addictive substance, or although their ability to perform this activity is reduced due to their health condition. Or 3. Despite summons according to Section 83 a para. 10. Refuses to undergo examination to determine whether during escort performance they were not under influence of alcohol or other addictive substance. I. In traffic accident. 1. In violation of Section 47 para. 2 letter A. Does not immediately stop vehicle. 2. In violation of Section 47 para. 3 letter B. Does not report traffic accident to police. 3. In violation of Section 47 para. 3 letter F. Does not prove identity to other accident participants including communication of data about vehicle that participated in traffic accident. Or 4. In violation of Section 47 para. 4 letter C or para. 5. Leaves place of traffic accident or does not immediately return to place of traffic accident after providing or calling help or after reporting traffic accident. J. In violation of Section 3 para. 6. Uses anti-radar or in violation of Section 41 para. 10. Unlawfully uses or imitates special warning light or special auditory warning signal. Or K. By other conduct than that specified under letters A, to J, fails to fulfill or violates obligation established in Chapter Roman 2 of this law. 2. Natural person commits offense as vehicle operator by in violation of Section 10 para. 1 letter D, ordering or entrusting independent vehicle driving to person about whom they do not know data necessary to determine their identity. 3. Natural person commits offense as driving school instructor during supervision over motor vehicle driver according to Section 3 para. 3 letters B or C, by in road traffic. A, in violation of Section 8A para. 1 letter A, consuming alcoholic beverage or using other addictive substance during ride in training vehicle. B, in violation of Section 8A para. 1 letter B, performing driving school instructor activity immediately after consuming alcoholic beverage or using other addictive substance, or at such time after consuming alcoholic beverage or using other addictive substance when they are still under influence of alcohol or other addictive substance. C, in violation of Section 8A para. 1 letter C, performing driving school instructor activity although their ability to perform this activity is reduced due to their health condition. D, despite summons according to Section 8A para. 2 letters A and B, refusing to undergo examination whether during driving school instructor activity performance they were not under influence of alcohol or other addictive substance. 4. Natural person commits offense by A, in violation of Section 87A para. 1 or 2 not undergoing traffic psychological examination. B, in violation of Section 94A para. 2. Section 102G para. 2. Section 113 para. 1, 3 or 5 Section 118B para. 6 or Section 123C para. 5. Not surrendering driving license or international driving license in violation of Section 113 para. 2 or 5 not destroying and not surrendering driving license or international driving license or in violation of Section 6B para. 4. Not surrendering vehicle registration certificate. 5. For offense, fine is imposed. A, from 25,000 CZK to 75,000 CZK, if it concerns offense according to paragraph 1 letter D or letter E, points 1 or 4. B, from 7,000 CZK to 25,000 CZK, if it concerns offense according to paragraph 1 letter A, point 4, letter C, letter E, points 2, 3 or 5. Letter F, points 2, 5, 7, 9, 10 or 15, letter H, points 2 or 3, letter I, points 1 or 4 or letter J, or paragraph 2 or 3, C, from 4,000 CZK to 10,000 CZK, if it concerns offense according to paragraph 1 letter A, points 1, 2 or 3, letter B. Letter F, points 1, 3, 6, 8, 11, 16, 17, 18 or 19. Letter H, point 1 or letter I, points 2 or 3 or D, from 2,000 CZK to 5,000 CZK, if it concerns offense according to paragraph 1 letter E, point 6, letter F, points 4, 12, 13 or 14, letter G or K, or paragraph 4. 6. Prohibition of activity is imposed for period. A, from 18 months to 3 years for offense according to paragraph 1 letter D or letter E, points 1 or 4. B, from 6 to 18 months for offense according to paragraph 1 letter A, points 1 or 2, letter C, letter E, points 2. 3 or 5 or letter F, point 2 or paragraph 3. C, from 6 to 12 months for offense according to paragraph 1 letter E, point 6 or D, from 4 to 6 months. 1. To one who committed offense according to paragraph 1 letter F, point 5 intentionally, by not stopping vehicle at instruction, to stop vehicle given during road traffic management or guidance, or during supervision of safety and smooth flow of road traffic, by person authorized to do so, or 2. For offense according to paragraph 1 letter A, point 4, letter F, point 15, letter I, points 1 or 4 or letter J. 7. By order on the spot, fine can be imposed. A, up to 1,500 CZK for offense according to paragraph 1 letter K or paragraph 4 letter B. B. From 1,500 CZK to 2,000 CZK for offense according to paragraph 1 letter F points 4, 12, 13, 14 or 16 or letter G. C. From 2,500 CZK to 3,500 CZK for offense according to paragraph 1 letter A, point 3, letter B. Letter F, points 1, 3, 6, 8, 11, 17, 18 or 19, letter H, point 1 or letter I, points 2 or 3 or D. From 4,500 CZK to 5,500 CZK for offense according to paragraph 1 letter F, points 5, 7, 9 or 10 or letter H, points 2 or 3. 8. If traffic accident is caused by commission of offense, upper limit of fine rate according to paragraph 5 for this offense is increased to double. 9. If traffic accident in which another person is injured is caused by commission of offense, prohibition of activity for period from 6 to 18 months is imposed for this offense along with fine, if prohibition of activity is not imposed for it according to paragraph 6 letters A to C. This does not apply if injury occurred only to person who is close person in relation to offender. Section 125D Offenses of Legal Persons and Entrepreneurial Natural Persons. 1. Legal person or entrepreneurial natural person commits offense by as vehicle operator. A. In violation of Section 10, para. 1 letter A. Ordering or allowing use of vehicle in road traffic that does not meet conditions established by other legal regulation. B. In violation of Section 10, para. 1 letter B. Entrusting vehicle driving to person who does not meet conditions according to Section 3, para. 2 and Section 5, para. 2 letters B and C. C. In violation of Section 10, para. 1 letter C. Entrusting motor vehicle driving to person who does not meet conditions according to Section 3, para. 3. D. In violation of Section 10, para. 2. Not ensuring that color design and vehicle marking is performed so that it is not mistakable with special color design and marking of military police vehicles, customs administration vehicles, municipal police vehicles, road transport inspection vehicles, prison service vehicles, emergency medical service vehicles and fire protection unit vehicles. E. In violation of Section 10, para. 1 letter D. Ordering vehicle driving or entrusting vehicle to person about whom they do not know data necessary to determine their identity. F. In violation of Section 6b, para. 4. Not surrendering vehicle registration certificate. 2. Legal person or entrepreneurial natural person commits offense by as consignor not handing over cargo for transport in condition or manner established in Section 52, para. 8. 3. For offense according to paragraph 1 or 2, fine from 10,000 CZK to 100,000 CZK is imposed. Section 125E Common Provisions on Offenses. 1. Offenses according to this law are dealt with by municipal office with extended powers according to competence established in Section 124, para. 5 letter K. For dealing with offenses and conducting proceedings on driving license retention. Offices of city districts determined by statute of capital city of Prague are competent on territory of capital city of Prague. 2. Offenses according to this law cannot be resolved by agreement, except for offenses according to Section 125C, para. 1 letter K or Section 125C, para. 4 letter B. By order on the spot, only offenses specified in Section 125C, para. 7. Or offense according to Section 125F, para. 1 can be dealt with. Offense for which prohibition of activity is imposed cannot be dealt with by order on the spot. 3. If notification of offense proceedings initiation, order issued as first act in offense proceedings or other document in offense proceedings according to this law cannot be delivered to addressee whose registered office or residence, or other address for delivery, is abroad. This document and other documents in these proceedings are delivered through public notice. Guardian is not appointed. Administrative body simultaneously attempts to notify addressee in appropriate manner about other delivered documents if their registered office, residence, address for delivery or electronic address are known. 4. From imposing administrative penalty according to this law, waiver or conditional waiver cannot be made in decision on offense. Provisions of law on responsibility for offenses and proceedings on them, regulating waiver from imposing administrative penalty that would otherwise be imposed in joint proceedings, are not affected. 5. Prohibition of activity can be imposed for periods shorter than its lower limit established by this law, if prohibition of activity imposed at this limit would be disproportionately strict considering driver's circumstances. Prohibition of activity must in such case be imposed for at least period corresponding to 1/2 of lower limit established by this law. 6. Fine imposed for offense according to this law that was transferred by municipal office with extended powers to general tax administrator for payment administration is 30% revenue of state budget and 70% revenue of municipality whose body imposed fine. Section 125F Vehicle Operator Offense. 1. Vehicle operator commits offense by in violation of Section 10 para. 3. Not ensuring that when using vehicle on road, driver obligations and road traffic rules established by this law are observed. 2. Vehicle operator is responsible for offense according to paragraph 1 if a. Rule violation was detected through automated technical device used without operation during supervision of road traffic safety, or it concerns unauthorized stopping or standing. B. Violation of driver obligations or road traffic rules shows characteristics of offense according to this law, and C. Rule violation does not result in traffic accident. 3. For responsibility of natural person for offense according to paragraph 1, fault is not required. 4. For offense according to paragraph 1, fine is imposed. For determining fine amount, fine range for offense whose characteristics the violation of driver obligations or road traffic rules shows is used. However, fine does not exceed 10,000 CZK. If fine is imposed for multiple offenses according to paragraph 1 dealt with in joint proceedings, upper limit of fine rate is increased to 5 times upper limit of fine rate imposed for most strictly punishable offense. Amount of fine imposed by order on the spot does not exceed 10,000 CZK. 5. Municipal office with extended powers deals with offense according to paragraph 1 only if it took necessary steps to determine perpetrator of offense, whose characteristics the violation of driver obligations or road traffic rules shows, and a. Did not initiate proceedings on this offense and dismissed matter because it did not determine facts justifying initiation of proceedings against specific person, or b. Stopped proceedings on this offense because commission of act was not proven to person accused of offense. 6. Vehicle operator is not responsible for offense according to paragraph 1 if they prove that at time before violation of driver obligations or road traffic rules. A. Vehicle of which they are operator was stolen or its plate with assigned registration number was stolen. Or B. They submitted application for recording change of vehicle operator in road vehicle register, which was subsequently granted. Section 125G, 1. If proceedings on imposing fine for offense according to Section 125F para. 1 are initiated, proceedings on offense for same violation of driver obligations or road traffic rules can no longer be initiated. This does not apply if vehicle operator is released from responsibility for offense according to Section 125F para. 6. 2. Into limitation period of offense according to Section 125F para. 1. Time during which proceedings on offense according to Section 125F para. 5 letter B were conducted is not included. 3. into limitation period of offense whose characteristics the violation of driver obligations or road traffic rules shows, time during which proceedings on offense according to section 125 F para. 1 were conducted for same violation of driver obligations or road traffic rules is not included. 4. If violation of driver obligations or road traffic rules was detected through automated technical device used without operation, oral hearing is not ordered in proceedings on offense according to section 125 F para. 1. 5. For dealing with offenses according to section 125 F para. 1 following procedure according to section 125 F para. 5. Only offenses related to dismissed matters or matters about which proceedings were stopped can be dealt with in joint proceedings within 1 month from dismissal or stopping of first of them. Section 125H. 1. Municipal office with extended powers immediately after detecting or reporting offense calls upon vehicle operator with which offense was committed to pay determined amount if a. Conditions according to section 125 F para. 2 are met, b. Driver identity is not known or is not obvious from basis for initiating offense proceedings, and c. Violation can be dealt with by imposing fine by order on the spot. 2. Municipal office with extended powers establishes determined amount at level of 1/2 of lower limit of fine rate that can be imposed by order on the spot for offense, whose characteristics the violation of driver obligations or road traffic rules shows. If violation of driver obligations or road traffic rules shows characteristics of offense according to section 125 C para. 1 letter K. Municipal office with extended powers establishes determined amount up to 750 CZK. When establishing amount of determined amount, it considers seriousness of violation of driver obligations or road traffic rules. 3. Determined amount is payable within 30 days from day of delivery of summons, according to paragraph 1. 4. Summons according to paragraph 1 must contain description of act with designation of place and time of its commission, designation of offense whose characteristics the act shows, amount of determined amount, due date of determined amount and other data necessary for making payment and instruction according to paragraphs 5 and 6. If summons according to paragraph 1 is delivered through postal service provider abroad, it is considered delivered on 30th day from day of its sending. 5. If determined amount is paid no later than on due date, municipal office with extended powers dismisses matter. Otherwise, municipal office with extended powers continues in offense investigation. About this procedure, municipal office with extended powers instructs vehicle operator in summons according to paragraph 1. 6. If vehicle operator does not pay determined amount, they may communicate in writing to municipal office with extended powers that called upon them to pay determined amount. Data about vehicle driver identity at time of offense commission within period according to paragraph 3. This communication is considered giving explanation. About this procedure, municipal office with extended powers instructs vehicle operator in summons according to paragraph 1. 7. Determined amount is revenue of budget of municipality whose municipal office called upon vehicle operator to pay determined amount. For determined amount payment administration, tax code is used. 8. If amount determined for determined amount payment was remitted in foreign currency, determined amount is considered paid in established amount, also if it was paid in lower amount and difference between determined amount and paid amount does not exceed 1% of determined amount. 9. Vehicle operator overpayment becomes amount determined for determined amount payment. A. Paid after due date of determined amount from day of its payment. B. To extent exceeding established amount of determined amount from due date of determined amount. Or C. Paid in lower amount than established amount of determined amount from due date of determined amount. 10. If overpayment according to A. Paragraph 9 letter B is returnable overpayment. Municipal office with extended powers returns it within 2 months from day of its origin. Or B. Paragraph 9 letters A or C is returnable overpayment. Municipal office with extended powers returns it within 1 year from day of its origin. This period does not run during time when municipal office with extended powers conducts proceedings on offense according to section 125 F para. 1. In relation to which determined amount was paid. 11. Municipal office with extended powers returns returnable overpayment by non-cash transfer to account maintained with payment service provider, from which amount determined for determined amount payment was remitted. If this amount was not remitted by non-cash transfer, municipal office with extended powers calls upon vehicle operator to communicate data necessary for overpayment return. In summons, municipal office with extended powers establishes period that cannot be shorter than 30 days. Returnable overpayment lower than 200 CZK is not returned. 12. Returnable overpayment expires and becomes revenue of budget of municipality with extended powers upon expiration of 3 months from day. A. Of feudal expiration of period established in summons according to paragraph 11. About this consequence, vehicle operator must be instructed in summons. Or B. Of overpayment origin if it is not returned due to not reaching amount of 200 CZK. Section 125I. If administrative body decides on imposing administrative penalty for offense committed by unlawful conduct, specified in directly applicable regulations of European Union regulating classification of serious violations that may lead to loss of good reputation. To carrier operating road transport by large vehicles for others according to road transport law or their responsible representative. It sends copy of legally valid decision to transport authority according to road transport law in whose administrative district. A. Carrier's registered office is located if it concerns carrier established in Czech Republic, or B. This administrative body has registered office if it concerns carrier not established in Czech Republic. Section 125J. 1. If person suspected of offense has residence in another European Union member state, municipal office with extended powers sends to this person together with notification of proceedings initiation, or together with order issued as first act in proceedings. Information form in official language of European Union member state in which suspect has residence. This procedure is used if it concerns offense. A. According to section 125 C para. 1 letter C, D, letter F, points 1 to 5, 12 or 13 or letter G, B, according to section 125 C para. 1 letter K, in case that maximum permitted speed was exceeded, reserved lane was used in violation of section 14 or section 27 para. 1 letter I, or prohibition to use lane established in section 71 para. 2 was violated. 2. Information form must contain description of act with designation of place and time of its commission, designation of offense whose characteristics the act shows, definition of administrative penalties that can be imposed for offense, and reference to this law. Information form sent together with order further contains definition of administrative penalty imposed by order and instruction about right to file objection against order. If it concerns act detected through automated technical device, information form must contain identification data about this device. 3. Municipal office with extended powers provides ministry with data about number of initiated proceedings in which it proceeded according to paragraph 1 in previous calendar year, always by March 31. 4. Template of information form is established by implementing legal regulation. Chapter Roman 7 Common, Transitional and Final Provisions Section 126. According to this law, driving licenses are also issued to persons who fulfill tasks according to special legal regulations. Section 127. 1. Employees of ministry, regions, and municipalities, and other persons who ensure production and completion of driving licenses, are obliged to maintain confidentiality about facts they learned during implementation of this law or in direct connection with it. Obligation of confidentiality continues even after termination of employment or service relationship. 2. Persons specified in paragraph 1 may be released from obligation to maintain confidentiality. A. Only by citizen to whom facts that are subject of obligation to maintain confidentiality relate, or B. By leading employee. In public interest, and in written form stating scope and purpose of release from obligation to maintain confidentiality. 3. Provisions of paragraphs 1 and 2 do not affect obligation of persons specified in paragraph 1 to report certain facts to bodies competent according to special legal regulations. Section 128. 1. Copy or transcript of legally valid judgment by which punishment of prohibition of activity consisting in prohibition of driving motor vehicles was imposed. Courts of all levels are obliged to send to competent municipal office with extended powers. 2. Copy or transcript of legally valid decision of administrative body by which administrative penalty of prohibition of activity consisting in prohibition of driving motor vehicles was imposed. Administrative bodies that issued them are obliged to send to competent municipal office with extended powers. 3. Notification of imposing fine by order on the spot for offense according to this law, except for offense according to Section 125C para. 1 letter K. The body that imposed fine is obliged to send within 3 working days after dealing with offense to competent municipal office with extended powers. Section 128. A competencies established for regional office or municipal office with extended powers according to this law are exercise of transferred competence. Section 129. Relationship to Administrative Code. 1. If application for driving license or driver card issuance was submitted through remote access via user interface established by ministry, it can be decided on or handled automatically without participation of official person. 2. Delivery of driving license or driver card through distribution point is considered delivery to own hands. 3. If applicant for exception from driving prohibition according to Section 43 para. 5. Is fully granted request, instead of written decision preparation, document on granting exception from driving prohibition is issued to applicant. Decision on granting exception cannot be appealed. 4. Appeal against decision on driving authorization withdrawal, driving authorization limitation, or driving license retention does not have suspensive effect. 5. For purposes of maintenance in register of drivers and preparation of driving license or driver card, municipal office with extended powers obtains digitized photograph of applicant and digitized handwritten signature of applicant when submitting application for driving authorization grant, driving authorization extension, or driving license or driver card issuance. If digitized photograph of applicant cannot be obtained from register of drivers, digital tachograph information system, citizen ID card records, travel document records or foreigner agenda information system, or substantial change in applicant's appearance occurred, municipal office with extended powers takes it when submitting application. Section 130. Employment relationships, rights and obligations from employment relationships of employees to employer according to special legal regulation, who, on day of law effectiveness, perform predominantly activity in matters of establishing local and temporary road traffic regulation. Driving authorizations and driving licenses, records specified in Register of Drivers according to Section 119, and offenses against road traffic safety. Transfer on day of law effectiveness from Ministry of Interior and Police to Ministry and District offices. Section 131, Transfer of Agenda to Transport Authorities Units of Ministry of Interior and Police, that on day of law effectiveness exercise administrative activities in matters of establishing local and temporary road traffic regulation, driving licenses and driving authorizations. Records specified in Register of Drivers according to Section 119, and dealing with offenses against road traffic safety, are obliged to transfer file agenda to competent units of ministry and district offices no later than 30 days from day of law effectiveness. Section 132. 1. Proceedings initiated before law effectiveness are concluded according to existing legal regulations. 2. Documents concerning driving authorizations and driving licenses issued before law effectiveness are considered documents issued according to this law. Section 133, Scope of validity of existing driving licenses. 1. Driving licenses granted on the basis of regulations valid until June 30, 1964 shall remain valid after this law comes into effect within the following scope. A. Driving license of driver class I or Roman II authorizes the driving of motor vehicles classified in all groups and subgroups of driving licenses. B. Driving license of driver class Roman III authorizes the driving of motor vehicles classified in all groups and subgroups of driving licenses, except groups D. D plus E and subgroups D1 and D1 plus E, C. Driving license for personal automobile driver authorizes the driving of motor vehicles classified in driving license groups AM, B and subgroup B1 and subgroup A1 with limitation to 50 cm3. D. Driving license for motorcycle driver authorizes the driving of motor vehicles classified in driving license groups A, AM and subgroup A1. E. Driving license for tractor driver authorizes the driving of motor vehicles classified in driving license groups AM and T and subgroup A1 with limitation to 50 cm3. F. Driving license for driving small motorcycles authorizes the driving of motor vehicles classified in driving license group AM and subgroup A1 with limitation to 50 cm3. 2. Driving licenses granted on the basis of regulations valid after July 1, 1964 shall remain valid after this law comes into effect within the following scope. A. Driving license of group authorizes the driving of motor vehicles classified in driving license groups A, AM and subgroup A1. B. Driving license of group B authorizes the driving of motor vehicles classified in driving license groups B, AM and subgroup B1, and subgroup A1 with limitation to 50 cm3. C. Driving license of group C authorizes the driving of motor vehicles classified in driving license groups AM, B, C. T and subgroups B1, C1 and subgroup A1 with limitation to 50 cm3. D. Driving license of Group D authorizes the driving of motor vehicles classified in driving license groups AM, B, C, D, T and subgroups B1, C1, D1 and subgroup A1 with limitation to 50 cm3. E. Driving license of Group E with driving license of Group B authorizes the driving of motor vehicles classified in driving license Group B plus E. F. Driving license of Group E with driving license of Group C authorizes the driving of motor vehicles classified in driving license Group C plus E and subgroup C, 1 plus E. G. Driving license of Group E with driving license of Group D authorizes the driving of motor vehicles classified in driving license Group D plus E and subgroup D1 plus E. H. Driving license of Group M and /50 authorizes the driving of motor vehicles classified in driving license Group AM and subgroup A1 with limitation to 50 cm3. I. Driving license of Group T authorizes the driving of motor vehicles classified in driving license groups T and AM and subgroup A1 with limitation to 50 cm3. 3. Limitations of driving license entered in the driving license on the basis of regulations valid before this law comes into effect shall remain valid even after this law comes into effect. 4. Certificate of competence to drive a motor vehicle on trolleybus track issued before the effectiveness of this law with driving license of Group C shall lose validity on December 31, 2003. Section 134 Exchange of existing driving licenses. 1. Driving licenses issued from January 1, 1994 to December 31, 2000 must be exchanged by their holders by December 31, 2010. B. From January 1, 2001 to April 30, 2004 must be exchanged by their holders by December 31, 2013. 2. Driving licenses according to paragraph 1 shall lose validity upon expiration of the respective time period established for their exchange. The validity of a driving license limited according to the previous sentence shall be extended by the period for issuing a driving license according to Section 110, paragraph 2. If the holder of the driving license proves that he submitted an application for issuing a driving license to the competent municipal office with extended competence before the expiration of the deadline established according to paragraph 1. Section 135 Validity of existing international driving licenses. An international driving license issued according to existing legal regulations shall remain valid for the period of its validity, even after this law comes into effect. Section 136 Validity of existing special markings of vehicles transporting a severely health-impaired person. Markings of vehicles transporting a severely mobility-impaired person, or markings of vehicles driven by a hearing-impaired person, which were issued according to existing legal regulations, shall remain valid until June 30, 2001. Section 137. 1. The government shall issue a regulation to implement Section 5, paragraph 2, letter B, and Section 41, paragraph 3. 2. The Ministry shall issue implementing legal regulations to implement Section 5, paragraph 1, letter D. Section 6, paragraph 6, Section 6A, paragraph 7, Section 6B, paragraph 6, Section 10, paragraph 5, Section 43, paragraph 7, Section 43A, paragraph 6, Section 45, paragraph 6, Section 52, paragraph 10, Section 56, paragraph 8, Section 62, paragraph 5, Section 65, paragraph 3, Section 66, paragraph 3, Section 67, paragraph 11, Section 68, paragraph 3, Section 75, paragraph 7, Section 78, paragraph 5, Section 79, paragraph 9, Section 87A, paragraph 9, Section 87B, paragraph 5, Section 92, paragraph 8, Section 102A, paragraphs 3 to 5, Section 102B, paragraph. Section 106, paragraph 4, Section 107, paragraph 3, Section 109, paragraph 13, Section 110, paragraph 8, Section 110, A, paragraph 11, Section 111, paragraph 9, Section 113, paragraph 6, Section 116, paragraph 5, Section 118B, paragraph 7, Section 122B, Section 123. The Ministry of Health shall issue implementing legal regulations to implement Section 6, paragraph 6, Section 84, paragraph 7, Section 85, paragraph 7, Section 87, paragraph 7, and Section 88, paragraph 6. Part 2 Amendment to the Act on Safety and Smoothness of Traffic on Roads, Section 138, Act No. 12/1997 Call on Safety and Smoothness of Traffic on Roads, as amended by Act No. 168/1999 Call, and Act No. 247/2000 Call is amended as follows. 1. Section 2 is repealed. 2. Section 3 reads. Section 3. The Directorate of Traffic Police Service exercises the competence of the District Traffic Inspectorate in relation to diplomatic missions of foreign states in matters of motor vehicle records and approval of technical fitness of motor vehicles. 3. Section 4 is repealed. 4. In Section 5, Paragraph 1, letters A, B, C, D, E, G, and K are repealed. The existing letters F, H, I, and J are designated as letters A, B, C, and D. 5. In Section 5, paragraphs 2 and 3 are repealed, and at the same time the designation of paragraph 1 is repealed. 6. Sections 6 to 8, including footnotes No. 5, 6, 7, 8, 9, and 10 are repealed. 7. Section 9 to 11 are repealed. Part 3 Amendment to the Road Transport Act Section 139 Act No. 111/1994 Call on Road Transport as amended by Act No. 38/1995 Call, Act No. 304/1997 Call, Act No. 150/2000 Call, is amended as follows. 1. In Section 21, Paragraph 5 is repealed. The existing paragraphs 6 to 8 are designated as paragraphs 5 to 7. 2. In Section 40B, Paragraph 1 is repealed. The existing paragraphs 2 to 6 are designated as paragraphs 1 to 5, Part 6, Section 142, Section 7 of Decree No. 87/1964 Call on driving licenses as amended by later regulations is repealed. Part 7 Effectiveness Section 143. This law shall come into effect on January 1, 2001, with the exception of Part 6, which shall come into effect on the day of promulgation. Klaus v. R. Havel v. R. Zeman v. R. Annex to Act No. 361/2000 Call, Overview of acts consisting of violations of selected obligations, and number of points for these acts. Violation of selected obligations, number of points 1. Driving a motor vehicle immediately after consuming alcoholic beverages, or at such time after their consumption during which the driver is still under the influence of alcohol, if the detected alcohol content in the driver is higher than 0.3 per ml, or driving a motor vehicle immediately after using another addictive substance, or at such time after its use during which the driver is still under its influence. 6.2. Driving a motor vehicle in a condition excluding fitness, which the driver caused by consuming alcoholic beverages, or using another addictive substance. 6.3. Driver's refusal to submit to examination to determine whether he is not influenced by alcohol or another addictive substance. 6.4. Causing a traffic accident in which death or serious injury to another person occurred. 6.5. Turning, reversing, or driving in the opposite direction on a highway or on a road for motor vehicles. 6.6. Entering a railway crossing when it is prohibited. 6.7. Overtaking a vehicle when it is prohibited. 6.8. Exceeding the maximum permitted speed by 40 km/h or more in a municipality, or by 50 km/h or more outside a municipality. 6.9. Not stopping the vehicle at a signal that orders the driver to stop the vehicle, or not stopping the vehicle at a sign to stop the vehicle given during traffic control or traffic coordination, or during supervision of traffic safety and smoothness by an authorized person. 6.10. Endangering a pedestrian crossing a road at a pedestrian crossing, or endangering a pedestrian crossing a road onto which the driver is turning, or endangering a pedestrian when turning with a vehicle to a place outside the road, when entering a road, or when turning or reversing. 6.11. Driving a motor vehicle that is technically unfit for traffic on roads due to a dangerous defect. 6.12. Restricting a pedestrian crossing a road at a pedestrian crossing. 4.13. Not immediately stopping the vehicle during a traffic accident, or unlawfully leaving the scene of a traffic accident, or not immediately returning to the scene of a traffic accident after providing or calling for help, or after reporting the accident. 4.14. Not giving right-of-way. 4.15. Driving a motor vehicle without holding a driving license for the appropriate vehicle group. 4.16. Violating the obligation to use a child car seat or safety belt when transporting children. 4.17. Exceeding the maximum permitted speed by 20 km/h or more in a municipality, or by 30 km/h or more outside a municipality. 4.18. Driving a motor vehicle by a driver whose driving license was detained or declared detained 419. Driving a motor vehicle by a driver who is a holder of a member state driving license. A driving license issued by a foreign state, or an international driving license issued by a foreign state, and lost the right to drive a motor vehicle on the territory of the Czech Republic, or is serving an administrative punishment or punishment of prohibition of activity consisting of prohibition of driving motor vehicles 420. Endangering another driver when changing from one driving lane to another 421. Violating the obligation to be fastened with a safety belt while driving or to use a protective helmet 422. Holding a telephone device or other voice or recording device in hand or in another way while driving a vehicle 423. Endangering another driver when turning at an intersection or to a place outside the road 424. Exceeding the maximum permitted speed by 10 km/h or more 225. Driving a motor vehicle without professional competence 226. Not stopping the vehicle before a pedestrian crossing in cases where the driver is obliged to do so 227. Unauthorized parking with a vehicle in a parking lot reserved for a vehicle marked with a parking permit for persons with health disabilities, or unauthorized use of a parking permit for persons with health disabilities when parking or driving 2.